City of Riverview versus Christopher Weigel, 251716. I apologize. I don't think it's made, I don't think it's penetrating my brain that today's already May 11th, so. All right, and so council, your appearance, please.
Alex Hill, P76961, on behalf of Mr. Weigel, who stands to my right. Sir, will you state your name, please, for the record? Christopher Weigel.
All right, thank you. And council, you're standing in for the attorney of record, Attorney Velo.
Yes, Your Honor, I'm with the Barton Morris, the same firm.
Okay, and Mr. Weigel, do you have any objection to the to Mr. Hill standing in for the attorney of record?
No, Your Honor.
Okay. And today is the date scheduled for sentencing on your client's plea as charged to larceny. And do we have anybody here from the Riverview DPW? No. Okay. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we did, Your Honor. We do have a couple minor corrections.
Okay, and what are those?
On page 1 in the general background information, it indicates that he has 4 children. So the children aged 15, 11, and 8 are his biological children, and he has 2 stepchildren, 9 and 3. So 5 children total. On page 2, Your Honor, for the substance abuse treatment history, it indicates that he's been sober since he was 19 years old. While he has been sober for about 12 years, Your Honor, that date of sobriety is in 2014 when he was 24. So a little bit more recent than when he was 19.
Okay.
Lastly, Your Honor, on the recommendations for number 2, it says no contact with Jonathan Berg. I'm not sure if this was an error. This was a larceny case. He does not know who that Mr. Berg is. He has no intentions to contact anyone related to this case, but we would ask that that be stricken unless that's an employee of DPW.
Okay, I don't know. I don't recall seeing that name anywhere, but I was wondering the same thing.
Your Honor, I've never heard of a Jonathan Berg.
Oh, that's fine, sir. That's probably just a an error. Okay, and okay, so counsel, you've indicated these are your client's stepchildren. Are you and your fiance now married?
No, Your Honor.
Okay, so they're not legally stepchildren at this point, but
Correct, Your Honor. It's a
Okay.
blended family. It's his fiance, but they're not legally married, so not stepchildren.
okay.
It was a medical.
All right, thank you. Okay, and so, all right, so I've made those corrections. And counsel, as to the recommendation, or what would you like this court to know about your client?
We appreciate the recommendation and ask that the court do what I see. Mr. Weigel, as stated, is a law-abiding citizen. As of the last 12 years, he had 2 minor brushes before his 25th birthday. I shouldn't say minor brushes. Those were very serious offenses, OWI. And as a result of that, he's changed his entire life. He's sober. There's no allegations of alcohol since 2014. And, you know, I believe that he's on the right path. Now, he does have a growing family, Your Honor, and this conduct is inexcusable and is a departure from his character. He was going through financial difficulty related to a divorce prior to this incident, and he made a horrible decision, Your Honor. He was an employee, obviously, with DPW, and the meter on his home that was registering the water wasn't operating. My understanding is essentially $50.24 was taken from DPW as a result of his conduct. And that is not a minor amount. He felt at the time under a lot of pressure and upon reflection, and he realizes that he's not punishing, you know, the government, he's punishing the taxpayers that support the water company, and he doesn't want a free ride, Your Honor, and he doesn't support that type of action. He wants the court to know that he's committed to not doing this type of conduct in the future. Now, I know that DPW did not respond to the request for restitution. He's indicated to me a willingness to pay $50 and I believe 24 cents, Your Honor, in restitution regardless. He wants to make up for that. Furthermore, we believe a term of probation is appropriate so that he can further get education to avoid any type of misconduct. He wants to lead a good example for not only his 3 children, but his 2, we expect, stepchildren in the future. So for that reason, Your Honor, and we also appreciate that this sentence was, I believe, recommended for 771. He is eager to show the court his compliance on probation, that this was a departure from his better judgment, and that he can comply with everything the court's asking. We're asking that should the court agree with a 9-month term of probation, that the court may consider perhaps in early October, a 4.5 month mark, so that if he's done everything the court's asked, he would be considered for early termination. We have no objections to the economic crime program or the making decisions classes. I would note the PSI indicates he's currently employed for Southern Tire Mart. They're trying to open a second location. He's talked to his boss about picking up additional hours. He has no qualms with community service, Your Honor. We're just asking for some consideration or discretion related to the workforce program so that he may still continue to work full-time while complying with the court's conditions. And Mr. Weigel, did you want to address the court in any way?
No, Your Honor.
Thank you, Your Honor.
Okay, thank you. So just to clarify a couple of things. Sir, you were an employee of the Riverview Department of Public Works, correct?
Yes, Your Honor.
And what was your position within the DPW?
General labor, Your Honor.
Sir, make sure your phone's off, please. Off. Your phone. Yes. It looked as though it was on when you walked in. What was your role, sir?
General labor, we didn't have separate departments. Most of us did a little bit of everything.
Okay. And so, sir, you noticed per your statement, you noticed that in October, your water meter was disconnected of some sort.
Not reading correctly.
Or not reading correctly, okay. And then you did not, the procedure if somebody calls in because their meter isn't registering correctly, there's a procedure to investigate as to what's going on, correct?
Yes, Your Honor.
And so you did not follow that procedure for yourself.
Yes, Your Honor.
And then it wasn't until December when somebody brought it to the attention of DPW that this matter came forward, correct?
Yes, Your Honor.
And so, did you notice, sir, on your water bills that it wasn't registering much?
Your Honor, I had them install a new water meter because the year before that, every single bill, I didn't know much about it, but every single bill said estimated water bill, and the dollar amount was the same every year. So I asked my boss, my previous boss that used to work there, Ron Tabor, if he could install a new meter, and he said not to worry. But then he came and checked it, and he said, "Yeah, we'll install it. Sometimes they get stuck." And this time it never got unstuck, like debris in the system. And so they did install a new meter.
Okay, when was that done?
Earlier, in November, I believe.
Could have been, was it around August of 2025 or something after that?
Yeah, it could have been.
And then the judge is asking, did you notice that the estimated amounts weren't reflected on your bill, they weren't matching up anymore?
Yeah, no, I noticed that it didn't match up, right? But I noticed that the meter, because I checked it every now and again when I would walk past it, it's right by the stairs. And I noticed that it wasn't spinning while the washer was running. And I failed to report that
Okay,
again.
and then for 4 months, that total was only $50.24?
Your Honor, so that's the only reason that I do that part in there about sometimes the boss explained it to me that sometimes when the fire hydrants get flushed and stuff, it stirs up debris in the water system. And sometimes it gets into that, I don't know how the meters work, but there's a spin inside and it jams and sometimes it frees up. So that's what the boss was telling me previously with the old meter was that usually they free up, but it did not. And that's why I had it estimated on my old meter. This one, they said it was showing no water consumption for a 2-week period.
Right, which obviously that's not accurate when you have 7 people living at the house, right?
Oh, yes, Your Honor.
All right. So the court's going to note, we don't have anybody here from Riverview DPW. The court will, as far as any specific amount for restitution, the court has, heard your client, city council, as well as you, indicating the $50.24 mark. The court does find, after reviewing the report, the recommendation in hearing from counsel and Mr. Weigel, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Weigel and the legislative guidelines. The court's going to order 9 months probation. You're eligible for early discharge. You're also eligible under 771.1 status. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately by changing the address or employment status. The court's going to order you to participate in the economic crime class. The rehabilitative goal for that condition is to become skills that will help you eliminate behaviors that are associated with economic crimes, while also hopefully helping you not repeat this offense. The court's going to order restitution amount of $50.24. The court's going to also order a making decisions class, the rehabilitative goal for that condition. You can learn further, you can learn additional strategies and skills for improving your personal choices. The court's going to order 3 days on the court workforce. The rehabilitative goal for that condition is so you can further develop life skills and protect the community. Counsel, I did hear your request for community service. However, your client should be able to do the workforce while still maintaining his employment. It should not interfere much,
Thank
if
you.
at all. All right, as to the fines and costs, the court's going to order a $300 fine, $100 screening assessment fee, $450 supervision oversight fee. That's $50 a month at 9 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, $120 for the court workforce. That's 3 days at $40 a day. So that is I'm pretty sure that's $1,395 plus the restitution of $50.24 for a total of $1,445.24. And then you can, and as I did indicate, you're eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making full payment. And so you're going to step over probation and you'll set up your payment plan and get all of your instructions as well. Okay,
Thank you very much. Mayor.
good luck to you. Have a good day. Okay.
Have a nice day here.
Thank you, you as well. Let's go on the record in the matter of the city of Riverview versus Madeline Jernigan, 25833 A and B.
Good. Oh, the honor, please present your feedback my client who approaches. This needs to change the record.
Madeline Jernigan.
All right, and good morning to you both. And today is the date scheduled for the pretrial in this matter. And counsel?
Yes, Your Honor, I had an opportunity to have dialogue with the prosecutor. They're willing to dismiss the original driving while I suspended in exchange for my client tendering a guilty plea to 1 count of no operator's license on person.
Okay, and ma'am, I'm going to ask you, to please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, and you heard that was placed on the record, correct?
Yes.
As to the amended charge of no operator's license on person, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand by entering into a plea, you'll be waiving some of those rights.
Yes, ma'am.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No, Your Honor.
Counsel, if you can please pardon your client.
I'd like to direct your attention back to May 27th of 2025. You were operating a vehicle in the city of Riverview
Yes.
and when pulled over by a marked police officer and asked to show them a valid driver's license, you were unable to do so because at the time your license was suspended.
Correct.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And counsel as to sentencing.
Your Honor, I respectfully request that she be admonished with costs and fines and a payment plan. She had some outstanding tickets. She has court dates for the matters to get solidified. I think that she's realizes the consequences of failing to pay tickets. It only gets her in more trouble, but it does appear that she's turned the corner. So I'd ask for that consideration. Thank you, Your Honor.
All right, and so how did you get here today?
A friend dropped me off.
Which friend?
Her name is Tiara.
Where do you work, ma'am?
I work at Rivertown in Trenton, the Woodhaven Buffalo, and an urgent care in Gibraltar.
And how do you get to all of your jobs throughout the week?
Sometimes I spend $70 in a day on an Uber if I can't get a ride from a friend. Somebody's picking me up today too.
And so where are you at in getting your license cleared?
I have another court date on the 20th with the city of Southgate for that ticket as well. They advise that I don't just pay it, that I go and see if it can get reduced, so I guess after that.
Have you already paid the defaulted double parking in this matter, or is that still due and owing as well?
I still owe that.
Okay, and so are you prepared to pay that today?
I don't know how much that one is exactly.
Well, we can tell you that in just one moment. Ally, if you wouldn't mind looking that up, please.
It's 270.
Your Honor, she indicates she make a $100 payment today, and I ask that the remainder balance be applied to any potential payment plan to the court.
Okay, so well, I haven't set the fines and costs on this matter yet. The 270 is on the double parking, just so you're aware as to how much you owe on that matter. And why were you driving last year, ma'am, May 27th of 2025?
I was going to work that day, when I got pulled over. Instead of getting a ride.
All right, the court's going to order $200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $525. Is there a warrant fee or a clearance fee, Ally?
$50 warrant fee.
All right, $50 warrant fee for a total of $575. Plus you have the 270 on your defaulted matter. So ma'am, it's going to continue to be a downward financial spiral if you continue to drive.
Yes.
Just don't drive. I know it's inconvenient, but you've gotten yourself into the situation. You need to make sure you're getting yourself out and getting yourself on the path to getting a license. All right, and so you have $100 that you're paying today, correct?
Yes.
And on your balance of $475, how much are you planning to pay per month, and what date of the month works best?
I could do $100, 14th of the month.
Okay. So the 14th of May is in just a few days. You're intending for that to be in
That's
May?
fine,
or
yeah, that's fine. We could begin this one.
Okay. All right. Stop at the window so you can make your initial payment. You can also get information, so you don't forget the amount that you owe in the defaulted matter, as well as, information about paying online, so you don't have to make the trip into court to make payment. Okay? I thank you. Have a good day. And don't drive, ma'am. So you can get your license back sooner.
Thank you.
Okay, all right, and then we are on record in the matter of the state of Michigan was Lori Gallagher, 251628.
Good morning, Your Honor. Mr. Shanty, bring me up Ms. Gallagher, who approaches.
Good morning. Your name for the record, please.
Lori Gallagher.
All right, is that coming through?
Yes.
Okay. All right, so today's date scheduled for sentencing on your client's plea to an amended charge of disorderly person. The original charge of assault and battery was dismissed by way of resolution between counsel. Is there a Joseph Strassner present in the courtroom? All right, and counsel, did you have an opportunity to review the report and recommendation with your client?
I did, Your Honor. It's actually accurate.
All right, and then counsel, as to the recommendation,
Your Honor, it's that she be considered for probation. She's been on tether the extent of her bond. I'd ask that she be given the opportunity for tether to be removed, comply with all terms, and conditions of probation, potentially put herself in a scenario where she could be seeking early termination. But she's very optimistic about her future, her sobriety, and I'd ask that she be given this chance to demonstrate that to the court. Thank you, Judge.
all right, and Joseph Strassner is a Riverview firefighter. That's alleged that you spit on the firefighter. So based upon your diagnosis, ma'am, why are you not under the care of a doctor? I can't hear you.
I need to find a new doctor.
Well, you received Social Security as a result of that, correct?
Yeah, I have Warnicki's encephalopathy.
Right.
I need to find a doctor in this area. Because I was living out of state.
Was that in Ohio?
Yeah.
Okay. Ma'am, in the last few years, you've been in and out of court a number of times. Much of which is for the similar charge that brought you to court originally. Are you on an alcohol tether right now?
Yes.
And how's that working for you?
Well, it's preventing it. It certainly is contributing to sobriety, but she feels that she has a strong enough system in which she will maintain her sobriety regardless. And I know that it's something she was going to be asking consideration for its removal, as it, I know it's not supposed to be comfortable, but that period of time is starting to create severe discomfort, and we'd ask for to an amended way of testing based on her lack of any violations.
Okay, well, the concern this court has, ma'am, is for your alcohol consumption, because it appears as though your alcohol consumption is your driving force with a lot of issues. Specifically, I would presume, since if you're sober, that you're not spitting on firefighters. Also, that you wouldn't strike a firefighter who's attempting to help you. Okay, so is your client interested in sobriety court counsel?
I don't believe that that was something that we discussed, Your Honor.
It may be beneficial to your client, given the allegations and the number of cases that your client has accumulated over a short while, in that regard. Do you want a moment to chat with your client?
Your Honor, my concern is I know that she does have some medical ailments. I know that her memory is difficult. She's been doing extremely well on bond. I'm concerned about how arduous that program would be, as well as her. She's indicated that she has the will to maintain her sobriety, that she feels compelled to believe that she can do that on her own. So Judge, I don't believe that anything, unless she would like to have it done along with it, with me regarding it. My concern is it's an arduous program. She has her limitations.
No, that's very valid concerns. All right, so the court's going to find that after hearing from Ms. Gallagher, hearing from counsel reviewing the report, the recommendation that that there is reasonable grounds to depart from scale 769.5. The court will also find that the following sentence is in the best interest of justice, is reasonable proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Gallagher and the legislative guidelines. The court's going to order 18 months probation. You're eligible for early discharge. The court will go over that shortly. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully. To your probation officers, often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed. You'll be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court will indicate that the alcohol tether may be removed unless it's on for another reason other than just this case. Because I do know that she has other matters in this court, so I'm not sure. So there was the alcohol tether 251386 and 251363. If it's been determined that I've already ruled that can be removed in those matters, then it can be removed as well in this matter. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you can further have assistance and support in providing coping mechanisms to maintain sobriety and hopefully prevent this matter from happening again. You also remember to have a psychiatric evaluation and participate in any treatment if recommended. The rehabilitative goal for that condition is so that you can further determine what your mental health needs and you can have some management and coping strategies at your availability. You're not to have any contact with Joseph Strassner. The rehabilitative goal for that condition is to ensure the victim's safety. And any questions regarding those conditions, counsel?
No, Your Honor.
The court's going to order a $200 fine, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 9 months. And since you're eligible for, at 18 months, and since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $1,625. If I have not already, your client's not eligible under 771.1 status. And you may request early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. All right. And counsel, I understand that your client's currently on probation on 2 other disorderly conduct matters. I believe those may have also been reduced from assault and batteries. But then there's the December 22 out of Ohio for assault. So for the reason from the Ohio case is why your client's not eligible. Any questions? All right. And so ma'am, please make sure you're going over probation. And then you can set up your payment plan with probation. All right. Good luck to you. Thank you. Have a good day. Let's go on the record in the matter of the city of in the state of Michigan, where's Gabriel McNeil, 26288 A and B.
There you go.
Is this not a state of Michigan?
Good morning, I'm Neil LeBlanc here on behalf of Gabriel McNeil. Mr. McNeil, please state your name for the record, sir.
Gabriel McNeil.
All right, good morning. And so today is we can only do the arraignment today, counsel. I know that you worked out a plea agreement, but this is a
The state of Michigan.
state of Michigan case.
I was not aware of that.
Sure is. That says it on the ROA and the ticket. So,
All right, I'll explain that,
Okay.
we do the arraignment,
yes.
Oh. Okay. Here, with respect to the arraignment plan, formal reading stands to meet the charges.
Okay, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. We'll schedule this matter for pretrial.
May 21st at 8:40.
I'm sorry, that's the 21st?
Yeah.
Nope, that's scheduled on the 21st, Jeff.
Neil's here on the 28th. That's the only Thursday he's available. Can we do the 28th? Does that work, Ellie?
Yes, we can also do 8:45.
Okay. All right, and then counsel, as to bond.
As to bond, my client, obviously presented him here when showed up on time and when he was supposed to be, he supported his wife with him today. He has no prior history, any type of behavior. He's a man of some senior years and he's gainfully employed. He's a chef by trade, actively engaged in employment. I think that personal bond would be appropriate in the circumstance.
Okay, and where do you work, sir?
Well, actually, I cater, but right after I leave here, I'm going to an interview of taking over a restaurant on Bogey and East Jefferson in Troy. So,
East Jefferson.
yeah, right next to the Ducros Bouchier building, right across from the GM.
Oh, okay, yeah.
Right, so there's a.
Well, they run the same way. That's why I was confused as to
Oh,
how that.
Bogey goes like this and East Jefferson goes like this. They cross. Well, it's right across from the GM building.
Right, is that the old, oh, I know, it's on the.
And right
outside
next
focus
door
one.
is Ducros Bouchier.
Right. Okay.
Prayerfully, when I walk out of here, I'll be able to get that.
Okay. And sir, if you were to test right now, what is in your system?
Nothing,
Have you ever failed to appear in court for any reason?
no,
And do you have a valid CCW, correct?
yes,
There was an accident.
yes,
It appears to be a single vehicle accident. That was only your vehicle, correct?
yes.
Okay. Okay, the court's going to order a $7,500 personal bond. You are not to possess or consume any alcohol or drugs that are not prescribed. And you're not to possess or have access to any firearms or weapons. Do you have any other firearms or weapons at your home where you have access to those, sir?
Yes,
Okay, and do you have access by way of a code to the safe or a key to the safe, or how do you have access to those firearms?
it's in my, lockbox.
The lockbox,
Yes.
okay. So does that lockbox, is that lockbox permanently affixed or can it
It could move, yeah.
transport?
Yeah.
All right. And do you have somebody that you can, that may legally take possession of that lockbox and not allow you access to that?
Yes, I guess my wife can do that,
Okay,
yes.
well, how would you not have access if you're living at the home?
So I'm confused, I'm not allowed to even have a weapon in my home?
Correct, not right now, based on the nature of the charges.
I didn't know that because
Well,
they returned it to me.
If I may, Your Honor, what she's trying to, if I may. You can't have access to the gun, either take it to, you can have it at a friend's house, who can hold it legally, or have it locked up such that you can't unlock it.
Okay, yes, I
You need
can.
to be, you can't have access to that gun while the case is pending. This is just a bond condition.
correct.
Oh, okay, yeah, okay, I can find somebody, I don't.
Okay. I mean, if you're, will retain the key and you don't, and she doesn't give you access to it, then that's something that you could do.
We can do that,
But you're not allowed, you can't have access to that.
okay.
I'm actually surprised that the gun was returned, given the nature of the charges, but, okay. All right, so then just make sure that you're, submitting an email or otherwise to the court that that condition's been satisfied, okay?
Okay,
All right. All right, and then we'll see you back on May 28th. Just have a seat, you'll get a copy of your, bond conditions, please. We are on the record in the matter of Nicole Dillon, 2612A.
Very good. Good morning, Your Honor. Get a voice here. I have full bill. Please state your name, miss.
Nicole Dillon. All right, and good morning, and thank you for dressing appropriately for court. Also, thank you, Mr. McNeil, for dressing appropriately for court, and good luck to you at your interview. And so, counsel, today is the date scheduled for a probation violation. Your client was sentenced on April 8th of this year, at which point the court allowed the alcohol tether to be removed. Perhaps that was an error, because now it's alleged that your client tested positive for alcohol April 15th and April 27th. And in addition to that, it was diluted. And so, counsel?
Your Honor, review the allegations. My client, she admits them, accepts responsibility for them, prepared to plead guilty to those two violations. Is that correct?
Yes.
Thank you.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth? Definitely. All right. And you heard the allegations that were placed up, correct? As to those allegations, how do you plead? You've gone over your advice of rights for probation violation purposes with your attorney, correct?
Yes,
And you understand all of those rights.
yes,
You also understand that by entering into a plea, you'll be waiving some of those rights.
yes,
You understand the possible penalty as a result of your plea, whether, and that the recommendation of this matter is for you to continue and complete all terms of probation, pay a $50 probation violation fee, 90 days on the alcohol tether, 10 days jail, suspended. Do you understand that that's the recommendation?
yes.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No,
And any immigration issues?
no.
All right, counsel, if you can please voir dire your client.
Yes, I will. Miss Dillon, do you recall being placed on probation by this court?
Yes, I do.
And one of the conditions of that probation is that you randomly test for alcohol.
Yes,
And you, and in addition, you're not to be drinking alcohol, correct?
correct.
And the report indicates that on two occasions, April 15 and April 27, there was evidence that you had in fact drunk alcohol in violation of this court's order. You have any use of that?
Yes, I do.
You're on testimony.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea. To the allegations and indicate technical violations 1 and 2 will enter as a result of that plea. And counsel, as to the recommendation.
Right, the defendant is still in, next, that she's had struggles and she's, accepting the directives of this court. And obviously this is something she's struggled with. The recommendation of the tether, that seems appropriate. If as an alternative, do think that we're worth, maybe this would be an instance where sober link would be still a good alternative for her. I'm a little confused if I may, Ms. Dillon, you were on a tether previously?
Yeah, before I got something.
How long were you on a tether?
8 weeks, I think.
I see.
7 or 8 weeks.
And did it interfere in some way with your employment?
Well, I went off work for 6 months. Tomorrow was my first day back to work.
Well, her concern, Judge, and again, obviously you can weigh this. She's a physical therapist, so she's a physical job, a lot of movement. And she's fearful there was another person who had a tether at her employment, and this caused a problem with management. Is there a blanket rule that she's patient or partner? And so she's anticipates that having a tether might be problematic at work. I don't have proof of that, there is no specific guideline, is that correct? To your employment?
To be honest, I don't know. I just know that they went to HR about that nurse.
In any event, beyond that, she appreciates the court and suspending the jail sentence. She assures me and she assures the court she's working hard at her sobriety. Not hard enough, but she's redoubled her efforts.
Ma'am, are you enrolled in grief counseling?
I'm so sorry. I just signed, me and my family up for a family grief counseling, therapy. I upped that after, last time when I picked my son's ashes up. I upped it to 2 times a week, and then I also started there's an appointment today, the substance abuse counseling.
Okay, and I can appreciate those efforts. But when a parent loses a child, there are so many more layers. And I can appreciate you doing I think that there's some tissue underneath the podium there.
Oh, sorry.
Don't apologize, you don't have to apologize, ma'am. That, for your family therapy, grief sessions, that's obviously a good start also, but you also need to do something for yourself for grief counseling so that you can allow yourself an opportunity to express yourself in a way that you may not feel free to do so when you're with your other children.
That is true.
So, while I can appreciate, ma'am, that you're going back to work and that this month has been extremely difficult for you, or the month of April has been extremely difficult for you, the alcohol consumption is only exacerbating the issues.
Yeah, I think it was a sign of both times. And after the funeral, and then after I got his ashes, both times. Like, it was meant to be that I got tested. After that second time, I told my husband, and I bought those at home ETT test. And I started substance abuse. I mean, just hold myself accountable and the grief counseling, and I stopped taking they prescribed me with like a sedative type. So I was in bed all the time. I stopped taking that.
There's no talking in court, please.
They added another med that I feel like has kicked in where I'm like able to get out of bed. And I think starting work tomorrow will, I don't age about it, but well,
Correct. And the first couple days back at work, I'm sure will be extremely difficult. However, it's also good that you'll get back into a routine. Right? Not that, time will make it better. Time will allow you the grace to adjust to what your new normal is.
yes,
Which is why grief counseling for yourself is extremely important as well. Okay. All right. So what I'm going to do is I'm going to continue and have you continue and complete all terms of probation. I'm going to waive the probation violation fee. One time, that's one time.
yeah, I totally understand.
The court's going to order 90 days. I'm going to indicate sober link.
Thank you.
Just so you're aware, ma'am, you're testing 6 times a day so that you will be interrupting your sleep. So you're testing every 4 hours,
Okay.
okay? And that's designed intentionally so that there's not an 8-hour gap. And so it's a way to help you also stay accountable,
Okay.
okay? Now, I understand that you're on some medication, so you just need to confirm how that will all look for you being able to get up to do your testing.
Okay.
And then the court's going to order 10 days jail suspended. All right. Any questions regarding any of that?
With the soberly, do I still go to the other testing?
Yes, you do, because the sober link doesn't test for drugs or any other substances that may not be prescribed, okay?
Okay.
All right. So I'm going to have you please go over to probation. And then you will get set up with your sober link, okay?
Thank you.
You're welcome. Good luck with your first day of work tomorrow, ma'am.
Thank you so much.
You're welcome.
Thank you.
Thank you.
You can remove the tether on this one.
Yeah, I wrote it for this time. Yeah. Mhm. Yeah. Okay. All right. So, let's see, here. Let's go off the record for a moment. Ms. McLean, have you spoken to Ms. O'Keefe?
I did,
You're mute. Oh,
and yeah, I saw I did that. I'm sorry. I did, and she decided to withdraw her motion, and she's packing and she's moving along, Your Honor.
is Ms. O'Keefe in the courtroom?
I
He's in the break.
I
Oh,
think
she's on the breakout room?
She was gonna leave, I thought. She was on her phone in her car.
Okay, well. Hey, can you send a message out there to ask if she's left the building or if she would just want to.
Yeah, we did our whole conference in the car, so. But you can check, of course.
Okay. Mr. DeBoy, okay, is Devon Jackson, is that person here?
I don't have the finals here. I haven't spoken to that person.
Okay,
I wasn't aware that person had checked in yet.
okay,
Jackson?
Not here.
not here, okay. What about Adjourn Davis,
No.
Xavier Downey?
Mr. Downey has checked in. I have his final in his. I haven't spoken to him yet.
Okay, he's out there in the
Yeah,
lobby,
he's in the lobby yet.
okay. Jack McNally,
Yes.
He's down in the courtroom, Your Honor.
okay, you ready on Mr. McNally?
Yes, sir. Yep.
Okay, and then Mr. Honeycutt?
Working on this still, Judge.
Oh, okay,
He's here.
okay, and then Samet, Drew Grayson? Who's that assigned to?
Everybody else is checked in. Second page are all here.
Okay, who is Mr. Grayson assigned to?
Who?
Grayson, Drew Grayson? 10.
Grayson? Oh, they haven't even checked in.
Oh, okay. All right.
Check.
Okay, so, let's handle, all right, let's, I'm just saying Xavier, oh, Downey's here, okay. Let's handle Mr. McNally,
Grayson just showed up.
okay. All right, so I know Mr. McNally and then, okay. All right, let's go on the record of the matter of the city of Wyandotte versus Jack McNally, 138
Right here.
A and C and B.
Right here. I do the lawyer on behalf of Jack McNally. Mr. McNally, please state your name for the record, sir. Jack McNally.
All right, thank you. And so today is the date scheduled in this matter for sentencing on your client's plea to a for possession of controlled substance, an amended charge of failed to report an accident, and amended charge of driving while license suspended first offense. And counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, I have gone over with him. Mr. McNally advises that the factually it's accurate. We don't need any corrections. With respect to the comments with respect to the recommendation. Mr. McNally, as he advised at our last hearing, he's our working man. He's a contractor, currently working on a project in Alabama, out of state. He does support his family. One of his children are still minors at home. And we ask the court to consider placing him on probation rather than incarceration.
Well, tell me about your warrants, sir. Have you cleared them up?
I might have one or two still pending due to non-payment.
All right, and so when are you intending to clear those up?
Trying to reach out, well, I reached out to the court, I'm waiting on for thing is. It's Van Buren, no, not Van Buren, here on Township, Porch.
All right, pretty sure Huron Township is part of the 34th District Court in Romulus. So, is Carol Wagner present? No. All right. If you were to test right now, sir, what is in your system?
No. It's been a few weeks since I had any marijuana.
A few weeks?
Yeah.
How many weeks?
Couple days before our last court date.
April 1st? So like 5 weeks?
Roughly, yeah.
Okay. So, sir, how'd you get here today?
Uber.
Uber. How much did it cost you? Or pull up your app, it'll show on there. Mr. DeBoy can look right at it and he can tell the court what it reads. For today's date.
$12.97.
This is 9:24 AM, $12.97, Uber.
Okay. And so, sir, how do you get to all of your job sites?
You pick up.
Well, I would state that I don't find that there's reasonable grounds to Department of Sales 76.9.5 in this matter because I don't know that probation would be helpful, given that your criminal history dates back 26 years almost, and that you're still offending with the same stuff, sir. You have a warrant pending out of Lincoln Park. Which is the 25th District Court for a matter from Lincoln Park, the 34th District Court, that's currently Huron. Then there's also 34th District Court, another one from Huron. And then another one from 34th District Court. And then a fourth one. So you have 4 warrants are out of the 34th District Court.
That's all the same. Apparently,
Four, yes,
the
4.
recollection is that's all the same,
So same incident for four of those, but you still need to appear. And then Lincoln Park is a separate one.
Yeah, I wasn't aware of Lincoln Park.
So, I would say that, one positive is that you don't have any convictions since 2022, but that's because you haven't appeared in court, so you have those wouldn't appear on your record because you haven't, handled those matters. What's that?
I was saying all that is all traffic related.
Sure, traffic related or not, you still need to go to court. And you're here for a traffic related offense.
You're right.
You don't have a valid license and then you went ahead and you hit another car. Which, do you understand what the ramifications of that is?
Yes.
What's that?
Had it prolonged my license and I've done damage to somebody else's vehicle.
Well, correct. And since you don't have valid insurance, since you don't have a valid license and you're not covered under insurance, so then potentially this person's out money. Because of your decision to drive a vehicle when you don't have the right to do so.
Right.
Driving in the state of Michigan is a privilege. Not a right, and you don't have that privilege right now, sir. Yet you continue to just flip your nose at the courts and continue to drive. So here's what I'm going to do. I'm going to order 60 days jail. I'm going to suspend $50. No driving. And you are to test randomly. Because you're not to possess or consume any alcohol or drugs unless prescribed. All right, so that's the order of the court, sir. When are you scheduled to be back at work?
Next week,
What date?
Monday. The 18th.
Okay, here's what I'll do. I will suspend 55. Your clients will serve 5 days jail. That way, sir, you will be out in time by Friday so that you can then handle what you have to handle over the weekend. Are you on your phone, sir?
Oh,
Check it out.
Okay.
Sorry.
And then upon your release, sir, then you'll have to contact probation for your random testing, okay?
The term of the testing be on,
Sorry?
how long would the testing be ordered?
Well. Just one moment. Then we're gonna set up a jail review date. Ellie, can you pick a date in? Well, you could do June 29th. June 29th at 9:45 a.m. You also, sir, need to clear up your warrants. All right, and so we will address the length of testing on June 29th at the jail review. That's the day that you're here, counsel. That's why I picked that day.
Thank you.
As to and so let me just indicate this. This is for counts A and B. I'm sorry, A and C. Concurrent. Which means that it runs together, sir. It's not that and then this one, so they run together. As to count B, fines and costs only. So that count B, it's $100 fine. Crime victim assessment fee of $75, justice system assessment fee of $50, for total $225. Count A. Is a $100 fine, $100 screening assessment fee, cost prosecution $200. Crime victim assessment fee of $75, justice system assessment fee of $50. Total $525. Then count C, the court's gonna order a $200 fine, crime victim assessment fee of $75, justice system assessment fee of $50. $325. So the total between all of these, sir, is $1,075. You did post a bond of $740. It's a balance of $335. Okay, so at this point, we will I will indicate that the balance due is to be addressed at your review hearing on June 29th. That way it frees up some of your money, sir, to pay on your warrants or to handle those cases you have warrants for. Okay? All right. That's the best I can do for you, sir. All right,
Thank you.
you're welcome. So you're gonna go out this way, sir. All right, let's go. No, I do not. Of TEC Premises LLC versus Nancy O'Keefe, all of the occupants 2600349. Ms. O'Keefe, I'm gonna have you step up to the podium.
Oh, she came back in.
So your appearance, please. Ms. McLean, your appearance, please.
Oh, I'm sorry. Victoria McLean on behalf of the plaintiff tech premises, Your Honor.
All right, and your P number, counsel?
P43446.
Thank you. And ma'am, your name for the record, please.
Nancy O'Keefe.
Okay, and so ma'am, you had sent this communication to the court, or dropped it off. And I did read that communication to Ms. McLean before the two of you spoke. And so then Ms. McLean stated when I asked if she had spoken with you that yes, she has, and that you're going to withdraw your motion. Okay. Is that because you're no longer eligible for rental assistance, or?
Well, I don't know if they provided a provider ID yet. I was approved, but it was for $410. I figured that was better than nothing. But I think I've decided, because I now went to Wayne Metro to apply for assistance, and they're pausing all funds right now. So I think my best thing would be to move. So when I filed the motion, the 27th, till now, you know, I've been exploring all options to pay the back rent and stay there. And so I made the decision that I just don't think I can afford to stay there right now. And I'm gonna move because I just don't know, you know, I'm working. I took a job as a caretaker just to do what I could to make money. And even to file another extension, you know, say it's whatever you graciously decide to do is fine. A week, 2 weeks, you know, it's not, I don't know if that's gonna make a difference, you know what I mean? Because I've applied to all these, for these resources. So I've done everything that I can. And so I'm thinking another week or two is not gonna make a huge difference. But I'm working and I'm saving everything I can. But just to prolong it, I think would be senseless, and just to move would be better.
Okay. All right, so I just wanted all that on the record because, counsel, not that as an officer of the court, I was second guessing what you stated. I just wanted all that to be on the record because she's not represented. And it was her motion and she's, withdrawing it.
Yes,
So,
thank you.
but in the future, counsel, if you can have a conversation with your client that if one of their tenants is choosing to request rental assistance, that your tenant should comply, or some communication otherwise.
Yes, Your Honor.
So, okay, the court will indicate the motion is withdrawn, and so then ma'am, and counsel, I can't access my file right now because my other computer screen isn't open. So does your have I already signed the judgment?
Yes, Your Honor. We signed it
Okay.
the 10th of April.
Okay, and so, ma'am, just so you're aware, what that means then is that this court can sign the writ of eviction when that's presented by Ms. McLean, okay?
Thank you.
All right, thank you.
Okay.
All right, have a good day.
Thank you.
Thank you. All right, thank you. All right, let's go off the record for a moment. Okay, Mr. Truitt, you're here to solve my problem, hopefully. Nicole Dillon, 26182A. And counsel, your appearance, please.
Yes, again, Neil DeBoyer here on behalf of the defendant, station clerk, please.
Don?
Thank you.
Okay, and so I had failed to address the jail review. portion of this, which was as a result of, I believe, a bond violation. Oh, no, I think I suspended as part of the sentence. When this court, sentenced your client. The court ordered 5 days jail suspension. And then, so as to the jail review council, going to adopt the recommendation at an additional 10 days, an additional 5 days for a total of 10, with a total of 15 being suspended. If there's another violation, that jail will be served and it will not be suspended
Okay.
in the future, okay? Okay. All right, and then, so everything else is, status quo, as I've already stated, and I do apologize for having to recall this matter. Okay,
Does she need a return to probation?
she should, just to make sure I haven't messed anything else up.
Thank you.
Okay,
Thank you.
have a good day. Okay, all right, Mr. DeBoy, are you ready on anything else? Okay, let's go off the record. Which other ones do you have left? Because I'm supposed to be starting my.
Mr. Downing just pre-tried it. I just need to talk with him again. I think Mr. Grayson's here. Other than that, I'm working.
Okay, you don't have Cole Sparks or Vashmi ready?
I have not spoken to them. They're here. I'm not yet aware of it.
I believe they're here.
All right, I'm on it. Thank you.
Okay, thank you. All right, you ready, Mr. Shumkey?
Yes, Your Honor.
All right, so let's go on record in the matter of, so you're gonna have first here. Edwin Zamet, 26199.
Good morning, Your Honor. Mr. Champney, bring back my client approaches.
Good morning, sir.
Good morning, Your Honor.
Your name for the record, please.
Edwin Zamet.
Are you picking him up?
Yes.
Okay, all right, and sir, thank you for dressing appropriately for court. And today is the date scheduled in this matter for a bond violation as well as a probation violation. It's alleged that, well, let's talk about the bond violation first. Your client was arraigned here in this court on February 24th, and apparently he has new charges in Lincoln Park, April 20th. Your client entered into a plea here March 4th. And those new charges appear to be possession of controlled substance. Again. All right, counsel, as to the allegation of your client has new charges pending in Lincoln Park. What are we doing with the bond violation?
Your Honor, we'll stipulate that he had police contact, that he was charged with a crime. I can't specifically say what happened on that date and time, nor if it's gonna reflect in a conviction, but we will stipulate that he has been charged with another crime.
Okay. All right, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, and you heard the allegations regarding the bond violation, correct, sir?
Yes, Your Honor.
As to those allegations, how do you plead?
You're gonna admit that you're not to. Guilty, Your Honor.
Okay.
And you've gone over your advice of rights for bond violation purposes, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
Are you picking them up, Ally?
No.
You need to speak up, sir.
Yes, Your Honor.
All right. And, you also understand sort of the possible penalty as a result of your plea. This court can revoke your bond, amend your bond or conditions, or any of the like, or any other, issue, consequences court deems fit. Do you understand that?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, and any immigration issues?
No, Your Honor.
All right, counsel, and counsel, if you can please order your client.
Mr. Zamet, you are currently on bond with Wyandotte District Court, correct?
Yes.
All right, and a condition of that bond is you were not to have police contact or accrue any new criminal charges, is that correct?
Yes.
All right, and you will stipulate that on or about April of 2026 this year, you were charged in the city of Lincoln Park, and although not convicted, you have been charged with possession of misdemeanor, is that correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violation based upon your police contact was 25th, with Lincoln Park Police Department. And, I'll, hold off on sentencing until we handle the sentencing on this matter. On the current matter. And counsel, do you have an opportunity to review the report and recommendation with the client?
Yes, Your Honor. It is factually accurate. No deletions, additions, or corrections.
Okay, and as to the recommendation, counsel.
Your Honor, as to the recommendations, with respect to request consideration for my client to start his probationary terms conditions, I think that it would be very beneficial. I'd ask that any sort of admonishment regarding the charges that happened in Lincoln Park be suspended to find out what the outcome of the Lincoln Park case is. I think that it is still would be tremendous assistance for my client to begin his probation, to provide him with support and guidance through this arduous time. I think that the circumstances that present themselves with the way he appeared today, very kind, very cordial, he was not difficult. And he in fact appeared eager to start his probationary terms conditions. So I'd ask that he be given that opportunity. Thank you, Your Honor.
Okay, Mr. Zamet. At what point are you going to get that it's not in your best interest to continue to associate with Ms. Anderson?
I totally understand, and doing my best to make good choices in my life, and a lot of things are going on in my life that have caused a lot of problems. I've got to move and sell my family home. My siblings and I are going to sell the home, and I need to move, and just a lot of things going on. And
Okay, sir, You didn't answer my question.
I'm sorry.
You're not going to be able to make good choices.
Pardon me?
You're not going to be able to make good choices with Miss Anderson still in your realm of communication.
Yes, no, Your Honor.
Every time that you're in trouble, sir, what's the common denominator?
Mr. Henderson,
Correct.
Yes.
Correct.
I'm sorry, Your Honor.
If you test right now, what's in your system, sir?
Nothing, Your Honor.
And when's the last time you spoke to Mr. Campbell?
I haven't spoken to him in since he was arrested at my house when he tried to attack me.
Okay, and so, when Miss Anderson's still living with you?
Your Honor.
No?
No, Your Honor.
When did you have her move out?
Several weeks ago or months or whatever, over 6 weeks or 8 weeks, maybe. Seems like one time.
Mom, sir. And was she with you with your Lincoln Park contact?
No, Your Honor.
No. Do you want to serve jail time, sir?
No, Your Honor.
Can I suggest you stop engaging in the behavior you're engaging in?
Yes, Your Honor. I agree, Your Honor. Yes.
So what are you doing, sir, to make sure you're not going to repeat this behavior?
I went to enter, like doing, NA or, similar program to make sure that I don't make any bad decisions in my future. And, I'm really ashamed of my behavior and my decisions in the recent, months and in the recent, months.
Here's what the court's going to do. The court's going to find, after hearing from counsel, hearing from Mr. Zamet, reviewing the report, the recommendation. The court does find that there's, and as well as the 155.001 eligibility, the court does find there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence being the best interest of justice to be reasonable, proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Zamet and the legislative guidelines. The court's going to order 24 months probation. You're eligible for early discharge. You're also eligible under the 155.001 status, which means that it's taken under advisement. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are not, or you are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed or be subjected to random testing. The rehabilitative goal for that condition serves so that the court can monitor your progress in maintaining abstinence and sobriety. You are also to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition serves so that you can further have assistance in providing coping mechanisms so you can turn off your phone. Your phone goes off. Thank you. To maintain sobriety and prevent relapse, hopefully preventing this matter from happening again. You're to attend the FAN meetings once per month. The rehabilitative goal for that condition is so you can have additional support system to maintain your recovery, as well as recovery resources. You're not to have any contact with Ms. Anderson or Mr. Campbell. That's for your benefit, sir, because you don't seem to be able to make decisions that you need to make when they are involved. Any questions regarding those conditions?
No, Your Honor.
The court's going to, and that those are concurrent. It's to both. So the counts are concurrent. The court's going to order for possession of controlled substance, count A, $300 fine, $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. $2,025. That's account A. Account B, $100 fine. I'm not charging a screening or assessment fee. I've already assessed that in the first one. $100 cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50 for a total of $325. For a total of $2,350. They'll set up a payment plan through probation. As to your bond violation, the court's going to order 5 days jail suspended. If there's a violation, sir,
Yes.
you will be serving that jail.
Thank you, Your Honor.
As I've indicated, you're eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Do you understand all of that, sir?
Yes, Your Honor.
All right, please stop at probation. Somebody will be with you shortly.
Your Honor, housekeeping issue, my client's been on tether, I
Oh.
believe, for a period of time regarding his, bond. I'd ask for consideration for an altered, screen.
Yes, tether to be removed.
Thank you, Your Honor.
All right, stop at probation. Somebody will be with you shortly, sir. Good luck to you. You're welcome. Okay, Mr. Lloyd is not in here. If we wanna.
It will be signed.
All right, so Mr. DuBois, we're going on the record in the matter of the city of Riverview versus Xavier Downey, 251534.
Good, we are a little boy here on behalf of Defendant Xavier Downing, state your name, sir.
My name is Xavier Downey.
Okay, thank you. And so, this matter was last week and the court had a lot of questions as to which counts were being dismissed and which counts your client was pleading on. And we could not get those answers because Mr. Johnson had left prior to the end of the docket. So we set it the pretrial for today. And so now today.
Yes, sir, I think I should be able to clarify.
Okay, so this is not something we need to do, the order of discovery?
That's not my work, Your Honor, that's a remnant from previously, so no, there is no request for discovery.
Okay, then I'll cross it off. Okay. All right, perfect. Thank you. Okay, so if you'd like to place the counts that your client's pleading to on the record, yes, thank you.
Yes, Your Honor, my client here offer a plea of guilty to the following. Count 1, which is a misdemeanor count of larceny. There will be count 3, which is a misdemeanor count of breaking and entering without permission. It will be count 5, which is another count breaking and entering without permission. And it will be count 7, that is malicious mischief. Counts 2, 4, 6, and 8 would be dismissed.
Okay, so he's pleading guilty to the odds and dismissing the evens.
Very good, Judge.
Okay. All right, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Are you picking him up?
No.
A little bit louder, please.
Yes, ma'am.
All right, thank you. All right, and so you heard the plea that was placed on the record, sir, correct?
Yes, ma'am.
As to count 1, larceny, how do you plead?
Guilty.
As to count 3, breaking and entering without permission, how do you plead?
Guilty.
As to count 5, breaking and entering without permission, how do you plead?
Guilty.
As to count 7, malicious mischief, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No, ma'am.
And counsel, if you can please order your client.
Yes, I will, Your Honor. Mr. Downey, do you recall being in the city of Riverview on about the 9th of October last year?
Yes, I do.
And at that time,
Let's see.
at that time you were, I think it was in the vicinity of Mulberry Street, but there, you and some friends were, had gone into someone's vehicle without permission. That would have been a 2020 Ram 1500. And someone you were acting with took a gun magazine, not a gun, but a gun magazine from that vehicle. You admit that?
Yes, sir.
Likewise, on that same date, basically that same evening, and that same vehicle, you or with the assistance of others entered into that vehicle without permission.
Yes, sir.
Furthermore, there was an incident involving a Ford Bronco, and you were either you or those you were with entered into a Ford Bronco that was parked on the street without permission. Am I
Yes,
correct? And then finally, there was a vehicle, a Jeep Wrangler. You or someone you were acting in concert with, campered with that Jeep Wrangler.
Yes, sir.
Your Honor, that's my doubt.
Did that last one come through from Mr. Downey?
No.
Yes, sir.
Okay. All right, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to counts 2, 4, 1, 3, 5, and 7. Dismiss counts 2, 4, 6, and 8 per the plea agreement. The court will continue your bond and conditions. You're going to go over to probation, sir, whereby you are going to get all your next steps. Okay,
Thank you, Your Honor.
all right, thank you. Have a good day. Let's go on the record in the matter of City of Riverview versus William Honeycutt Jr., 251414 A and B.
Good morning, Your Honor. I have to bring up my client who stands to my immediate right.
All right, thank you. And Mr. Honeycutt, your name for the record, please.
William Honeycutt.
All right, and then Mr. Johnson, your appearance, please.
And good morning, Your Honor. For the record, Terry Johnson, P7077 on behalf of the city of Riverview.
Thank you. All right, so Mr. Honeycutt has pled guilty previously and sentenced on a trespassing and failed to display. We're here regarding the restitution amounts that have been put forth as relates to the damage to the HVAC unit, for lack of better terms, up on the roof. And so it's, if I recall correctly, there was a request of $1,850 of restitution with an attached invoice. And Mr. Honeycutt was disputing that amount. So today was the date scheduled for a restitution hearing. And so has there been a resolution to the amount, or are we holding the hearing?
There has been a resolution, Your Honor, to have a opportunity to speak with a representative of the establishment, and we've agreed upon a restitution of $1,200.
That is accurate, Your Honor.
All right, and so Mr. Honeycutt, you heard what's been stated, correct? And you've spoken with your attorney?
Yes, ma'am.
And so then the court will amend the order of probation. Accordingly, to represent to reflect the $1,200 restitution amount. Okay. All right, thank you.
Thank you, thank you, Your Honor.
All right, have a good day. Okay, and is Mr. DeBlois still in here or, okay?
Right, would you let me get him? He's right.
Yes, please. We have these two matters and then I know we have the in custodies and I'm clearly not making my 12 o'clock meeting, so. I know you're ready on the in custodies, right, counsel?
Yeah, and I'm ready on the other two, as well, Judge.
Which other two? Oh, the two I have in front of me.
Yeah.
What I thought was Mr. DeBlois. Okay, never mind. All right, let's go on the record in the matter of the city of Riverview versus Julian Jimenez, 26402-251579 A, B, and C. You can disregard Mr. DeBlois. I was wrong. These are Mr. Shempke's cases.
Very well, thank you.
Thank you. Sorry, Mr. Johnson. Thank you.
Good morning, Your Honor. Mr. Chairman, we have my client who stands to my immediate right.
Thank you. And sir, your name for the record, please.
Julian Jimenez.
All right, please keep your hands out of your pocket. My valley. Okay, so today's the date scheduled for the arraignment pretrial on these matters. You have one pending from November 3rd of 25, driving while unlicensed, and then 2 civil infractions. And then while you're waiting for that, you wanted to come in to see us so badly that you were arrested for driving while license suspended, revoked or denied on March 25th. And so then counsel adds to the arraignment in these matters, which I guess I've kind of already kind of waived, not waived, I guess.
My client stands here.
All right, the court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment. And as to the pretrial counsel.
Your Honor, my client indicates that he is actively seeking the means to get his license. Would put the defense in a significantly better position if he did in fact come back to court with a valid license. So I'd be requesting a 30-day adjournment so that he can make those necessary steps.
All right, Ally, what does that look like for us?
We can do the June 15th.
And I'm here on that day, Judge.
All right, June 15th at 9:45 a.m. All right, then counsel as to bond.
Your Honor, my client came in on his own volition. Obviously, he's starting to see that these are very serious offenses and there are consequences. That being said, I would be respectfully requesting consideration for a personal bond.
All right, well, your client failed to appear in court January 12th of this year on the first one that he had, the 25 case. And then it appears as though he was, and then he was arrested and then had a cash bond posted for the March 25th incident. Why did your client fail to appear?
Your Honor, I think that he has limited experience with the criminal system, the judicial system, and potentially he thought that this was more of a ticket and not a misdemeanor offense. I don't believe that's an excuse, but Judge, obviously he's been made aware that that is not acceptable and he has appeared in all future court dates timely.
Sir, how'd you get here today?
My girlfriend,
Who's your girlfriend?
Samantha Sturgill.
Where's she?
She's in the car with my son.
Do you work, sir?
Yes, sir. I mean, yes, ma'am.
Where do you work?
I work at Princess Square Apartments. I'm a maintenance man.
And how do you get back and forth to work, sir?
I live there at the moment. I just moved in.
Do you have any other pending matters, sir?
No, ma'am.
Out on bond, you're not out on bond in any other jurisdiction?
No, ma'am.
You're not on probation or parole, where are you?
No, ma'am.
All right, the court's going to continue your cash bond on the 26402. The court's going to order a $7,500 personal bond on 251579A. You are not to operate a motor vehicle without a valid license. So, sir, do not drive. Right? You're getting this opportunity to have an adjourned date so you can try to get clearances. Make sure you're not driving. All right, thank you. Have a good day. We're on the record in the matter of the city of Riverview versus William Garrison II, 26413.
Good afternoon, Your Honor. Mr. Shempey is going to be my client who approaches.
Thank you. And sir, your name for the record, please.
William Garrison.
All right. And good morning. And today is the date scheduled in this matter for the arraignment pretrial in council.
As the arraignment waiver form reading, my client stands mute.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial counsel.
Your Honor, I've been, it's my understanding they're willing to, since the original charge of my client is to tender a guilty plea to the lesser included charge, failed to report an accident.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and sir, you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of failed to report, sir, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
I don't know that we're picking you up, sir.
Yes, Your Honor.
That's good change.
Okay, thank you. And you understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
And you also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And any immigration issues?
No, Your Honor.
All right, and counsel, if you can please order your client.
Sir, I'd like to direct your attention to March 20th, 2026. We are operating a vehicle in your neighborhood in the city of Riverview.
Yes.
And while backing out of your driveway, did you accidentally strike another vehicle and fail to call the police upon striking that vehicle?
Yes.
Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge. And as to bond counsel,
Your Honor, my client came into court on his own volition. He's not on probation or parole, so I understand. I believe he has to meet priors. I read the police report. It was a circumstance where he did bump a vehicle. I believe that he had thought that he might have not committed any damage. However, when the police came and asked him what happened, he was very forthright. He was not deceptive. He was sincere with our dialogue today and was willing and ready to accept responsibility. I'd ask consideration for a personal bond.
all right, sir, do you have any other pending matters?
No, Your Honor.
Have you ever failed to appear in court for any reason?
No, Your Honor.
Is this person your neighbor? Is the person, the owner of the other vehicle, your neighbor?
He's a friend of mine, Your Honor.
Is that Mr. Younglove?
Yes.
All right. The court's going to order you not to have any assaultive, threatening, abusive, or intimidating contact with the victim. And the court's going to order a $3,500 personal bond. Please report over to probation, sir, and somebody will be with you shortly, okay? You got a copy of your bond conditions over there as well. All right, you'll get your sentencing date as well from probation, just so that because there's a named victim, because there's an accident, we have to be able to give them an opportunity to request any restitution. Okay?
Right.
All right, thank you. Have a good day. State of Michigan versus Chelsea Smith, 26304.
Thank you, Your Honor. And good morning, Your Honor. David Bogart appearing on behalf of Ms. Smith, who is present and standing to my right.
Thank you. And good morning, ma'am. Your name for the record, please.
Chelsea Smith.
Okay, very good. Thank you. And so council, if you're having difficulty with the dim lights, then we can change it, but we try to kind of have some type of a calming feeling
Not at
there.
all. No difficulty at all.
So considering many people are not calm when they're here. So, all right. And so today is the date scheduled for sentencing on your client's plea to an amended charge of controlled substance use and to the charge of operating while intoxicated. The original charges of possession of controlled substance and the high VAC were dismissed by way of resolution between council at the probable cause conference. And did you have an opportunity to review the report and recommendation with your client, counsel?
Yes, Your Honor. I went through the pre-sentence investigation report. I went through it with Ms. Smith. I also went through with it with her parents who are her guardians, and they are in the audience as well, Your Honor. I find no additions, corrections, nor deletion to it, and only have elocution at
Okay. And you may proceed, counsel.
Thank you, Your Honor. Reviewing the report and speaking with Mr. and Mrs. Smith as well as Chelsea about this. Your Honor, we certainly know and realize that Ms. Smith made a poor decision. It wasn't a mistake. It wasn't an incident. It was a poor decision, and she certainly accepts that responsibility. Your Honor, she's provided to me, which I will provide to the probation department as well, or the court if the court wishes, proof that she continues to attend teen wellness attendance. She's attended AA as well as NA. There are confirming emails here with that. She did have a high VAC of 0.199, essentially 0.2. She knows that that was 2.5 times the legal limit. That has been discussed with her as well as her parents. And she is grateful for her plea. She's also grateful that she does have the eligibility for early release, but that's really what hasn't been on her mind. She has tested negative during all times up until this date today, and we believe she will continue to test negative. She did first test positive, but that was on 3/13 within a few days of the incident. We expected that, quite frankly, Your Honor. And as the recommendation indicated, save for the instant case, she's never had anything on her motor vehicle record or anything on her criminal case history. She does have an excellent relationship with her parents and her family and her sister. And Your Honor, we would ask the court to adopt the recommendations of this. The only thing I would hesitate on is the inpatient and residential treatment. Your Honor, she is substantially meeting with her psychiatrist regularly, as well as meeting with the teen wellness and counseling. And her parents can certainly verify that as well. The other recommendations that we see here from the no alcohol and bad outpatient, certainly the mental health, we don't have any issues with that, Your Honor. The only thing I would ask is that court would consider not an actual inpatient simply because of what she has been doing. And her parents can certainly verify that as well. She is a Cat 5 with alcohol and a Cat 2 with drugs because she really has had no drug issues except for the instant case. But as this court is aware, that's how things start. But I think it's been caught in time. I think she realizes what she has done, what she should not do. First, it certainly has got her parents more aware of it as well. So, Your Honor, we would ask to adopt the recommendation and hold the inpatient if the court feels or probation feels more beyond what she's already doing. Thank you, Your Honor. Is there anything you'd like to say, Ms. Smith?
I would like to just say I apologize. I'm owning up to my mistakes.
All right. Thank you. I appreciate hearing that. And you're apologizing to the court, yourself, your parents? Okay. And ma'am, and I totally appreciate you, taking the time to apologize, but just so you know, the court, you don't need to apologize to the court. As far as that, we're here anyway, whether it was you or somebody else that was here, we're here. Now to your parents, yes, because they, seem to be pouring a lot into you and your care and whatnot. So I'm glad that you've acknowledged that and to, apologize to your parents. So are you not working? So you've been on disability since your late teens, and that's based upon, your mental health status, correct?
Correct.
Are you unable to work at all? Or are you allowed to work minimal hours? What is the status of that?
I'm not allowed to work.
Okay, all right. But you are allowed to volunteer and perform some community service, correct? Okay. And how are you feeling now that you've not been using any substances or alcohol?
A lot better.
You feel a bit more clear-headed with your thought process? Very good, very good. All right, and so counsel, the court would agree that inpatient or residential is not necessarily something that's being recommended today. That's after the needs assessment, that was what the recommended treatment services that your client could benefit from. However, given everything else, because obviously with that needs assessment doesn't take into account some of the other factors that probation takes into account. And so that's not necessarily recommended at this point, but it could be on the table moving forward, ma'am, if we need some additional support. After hearing from counsel, hearing from Ms. Smith, reviewing the report, the recommendation, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds that the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Smith and legislative guidelines. The court's going to order 24 months probation. That's for both counts. 1 and 3. That's concurrent. It's not 24 months and then 24 months. The court also finds that you're eligible for early discharge as to both counts. You're eligible under 7411 for count 1. You are not to violate, so everything else I'm going to indicate, I'll specify it's if it's only for one count, but otherwise it's for both counts. You're not to violate any criminal law of any unit of government. You are not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling, which I know you already have, so I'm going to indicate that you are to continue with that. The rehabilitative goal for that condition is so you can further receive assistance in providing coping mechanisms so you can maintain sobriety, hopefully preventing this matter from happening again. You are to also participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so that you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. You can continue with your NA and AA meetings 2 times per week. The rehabilitative goal for that condition is to help give you additional support and to learn tools to help you maintain sobriety. The court will also order you to participate in fan meetings once per month. The rehabilitative goal for that condition is so that you can further receive support to maintain sobriety as well as additional recovery resources. Your parents can go with you to that as well. If you're unfamiliar with that, it's an organization that meets once a month. And it's for individuals that are in recovery, have been in recovery for a while, new to recovery, have lost somebody to overdose, are supporting somebody in recovery, things of that nature. So it's a whole realm of individuals that attend those meetings. You will also have to continue with your mental health counseling. The rehabilitative goal for that condition is so you can further determine your mental health needs and you can get additional coping strategies. I'm also going to order 75 hours of community service. I think that would be very beneficial. So you have a goal, whether it's once a week or whatnot, but I think that sometimes that's helpful to have a little bit structure during your day. And the court's going to order that, as to both counts, so it's 75 hours total. Any questions regarding those conditions?
No, ma'am.
Okay, the court's going to order as to count one, it's a $100 statutory fine, $100 screening assessment fee, $1,200 supervision oversight fee, $50 a month at 24 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, so that's a total of $1,825. As to count three, the court is going to order a $300 fine. I'm not assessing any screening or oversight fee. I've assessed that on the first count. Cost of prosecution, $300. Crime victim assessment fee of $75. Justice system assessment fee of $50 for a total of $725, which is $2,550 between both. Okay? Now, you did post a bond, so when you go over to probation, ma'am, you will be able to set up a payment plan with probation. All right? As I did indicate, you are eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay?
Thank you.
I did go over that pretty quickly. Probation will also go over that with you as well.
Okay.
Okay? Any questions?
No.
None for me, Your Honor.
Okay, good luck to you, ma'am. You're going to go over probation next. Okay?
Thank you, Judge.
Thank you.
Have a good day.
All right, you as well. Okay, let's go off the record for a moment. Mr. Stroya, what's Mr. Stroya here?
Yes, sir. Yes, ma'am.
Yes, Mr. Stroya, which matter are you here on?
Probation violations.
Violation.
Oh, there we go. Okay, thank you. All righty. Morning, Brian.
Morning.
Okay, so Mr. Shemke, are you ready? I don't see, is anybody in the jail there? Okay,
Chris talked to everybody, so we'll be ready whenever you
Okay.
start running them through.
Okay.
I'm ready on 7 cases at the court convenience.
yep, okay. Okay, so. Okay, Mr. Munson, are you ready on Ms. McAuliffe?
Yes, ready on all three.
Okay. All right, and Mr. Katz, you are out of the breakout room and you're ready on your matters, correct?
Yeah, if I can get a few minutes, Your Honor.
Oh, you need a few minutes? Okay. All
Thank
right,
you.
let's go on the record in the matter of Kings Forest Apartments. First, Amanda McAuliffe, 2600576.
Good morning, Your Honor. Grant Munson on behalf of the plaintiff.
All right, Ms. McAuliffe.
I'm here.
Okay, your name for the record, please.
Amanda McAuliffe.
Okay, and so counsel, you and Ms. McAuliffe were able to speak in a breakout room, correct?
That's correct, Your Honor. And we'd like to enter into a consent judgment at this time, and I'm prepared to place the terms on the record.
Okay,
So that'll be a consent judgment for a total of $3,403.04. That includes the attorney fees and court costs. That'll be paid in 2 installments, $1,700 on May 22nd and $1,703.04 on May 29th. That's a judgment for possession only, writ of eviction to issue if either payment is missed.
okay, and so counsel, I have all that. I just need a breakdown of the rent because did you submit a judgment already, counsel?
Yes, I believe so.
Right, okay, so I need a breakdown, please.
Sure. So it's $3,195 is the rent to retain.
Okay.
And the attorney fees and court costs are $208.04.
Okay, all right, and so, ma'am, you heard the terms of that judgment, correct?
Yes.
All right, and you have, you understand that Mr. Munson represents the interest of your landlord and not your interest, correct?
Correct.
And you've also received your advice of rights in your packet of information, correct?
Yes.
And you understand that by entering into this agreement, that you'll be waiving some of those rights, specifically as it relates to legal representation and rental assistance, correct?
What do you mean by rental? Because I have applied for some help with DHS.
Oh, did you tell Mr. Munson that?
No, because my appointment's not till after court. So I mean, if we came to this agreement, I could probably just tell them I don't need assistance.
Well, ma'am, okay, here's the thing. If you've applied
Okay.
for assistance, I'm required to set this out for 2 weeks.
Okay, so I did apply for assistance and I have an appointment from 11 to 1. I did not tell him that. I did not know that that was something I should have told him. I'm sorry.
Okay.
So Your Honor,
Yes.
hearing that, it makes sense. Let's just adjourn this for the rental assistance. She can file the form and then, if it's paid before the next hearing, we'll dismiss it anyway.
I'm so sorry about that.
That's okay.
No problem.
That's why I go over the advice of rights. All right, so we will set for a second hearing on. We're gonna do May 26th. Oh, well, that's 14th, so we can do May 29th, council.
That works.
I'll tell you the time in just one moment. At 8:30. And then, ma'am, there is a
May
form that
29th.
you I'm sorry, what's that?
I was just repeating what you said, May 29th at 8:30.
Yes. There's a
Okay,
form,
and I'm-
it's DC 539, that you have to make sure you're filling out
Okay,
and submitting to the court within 5 days.
okay, I can do that.
Okay, we'll see you back on May 29th at 8:30 a.m.
All right, sounds good. Thank you.
You're welcome. Have a good
Have a
day.
great day. You too. Bye-bye.
Take care.
Okay, and then, Mr. Shunky, are you, let me see here. Abrams, do we have Gage Abrams? Okay.
Sure, up there.
Oh, right here. All right, let's go on the record in the matter of the Gage Abrams, 26106A.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
All right, and Gage, your name for the record, please.
Gage Abrams.
Okay, and so today's date scheduled in this matter for probation violation. Mr. Abrams was sentenced on March 18th. At which time this court, I'm sorry, Mr. Abrams was sentenced on March 18th and it's alleged on April 4th. Your client tested positive for marijuana and failed to appear for drug tests on April 8th and April 22nd. And counsel?
Your Honor, I've gone over these violation allegations with my client. He's not going to be asking for a hearing. He'll admit to the violations.
Okay, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and you heard the allegations, correct, sir?
Yes.
As to those allegations, how do you plead?
I do plead guilty.
You've gone over your advice of rights for probation violation purposes with your attorney, correct?
Yes.
And you understand all those rights?
Yeah.
I'm sorry?
Yes. Sorry.
And you also understand, sir, by entering into a plea that you'll be waiving some of those rights.
What rights are being waived? I'm sorry.
We discussed this, sir, in which you could have a hearing in which you could contest these violations if you were to say that you did not test positive, or if you were saying that you failed to, that you did appear, and that you provided a sample. So we're waiving that because we're going to provide an explanation as to what took place.
Absolutely, okay, sorry.
All right, you understand those then, sir?
Yes, yes.
And you also understand the possible penalty, correct?
Yes,
And the recommendation in this matter is for your probation to be continued, complete all terms of probation, $50 probation violation fee, 30 days on the alcohol tether, and 15 days jail suspended. You understand that's the recommendation?
yes, I understand that's the recommendation.
And you also understand, and so knowing all that, sir, you want to continue with your plea?
Yeah.
Yes?
I believe. Yeah, I believe, yes, I believe so.
Well, I need you to know so, sir.
Yes, I'm sorry.
Okay, that's all right. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? I'm sorry, for you to enter into this plea, sir, for your probation violation.
No.
All right, counsel, if you can please board your client.
Yes, I'd like to direct your attention back to a test you took on April 4th of 2026. Do you stipulate that it indicated the use of marijuana based on the test results?
Yes.
And then furthermore, although you appeared at the locations on the date of April 8th and April 22nd of 2026, you were unable to provide a suitable sample. Is that correct?
On April 8th, I was not able to make it there. I actually had
All right, so you failed to appear on the 8th. Did you make it on April 22nd?
April 22nd, I did make it. I did attempt to.
And you were
on
unable
the
to
8th, I
provide
did notify Miss Shaw.
You were
Hold
unable
on,
to provide
excuse me. We can only have one speak at a time because it's not coming through on the record when there are multiple people speaking. Just please be aware of that.
To reiterate, you failed to appear for your testing on April 8th, 2026, correct? Yes or no?
Yes.
And then on April 22nd, 2026, although you appeared, you were unable to provide a valid sample. Is that correct? Yes or no?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violations 1 through 3 based upon your plea of guilty. And counsel?
Your Honor, I had an opportunity to have a dialogue with my client. He indicated that he does in fact have a very valid medical marijuana card and documentation that he's provided to Ms. Shaw regarding the necessity of it due to a cancer prognosis from his prescribed physician. That being said, it didn't appear as alcohol, although the originating substance abuse issue was a problem here. I'd ask that instead of an alcohol tether being applied as he didn't test positive, that potentially, if testing were to be increased, that he be, and per his request, be given a sober link device that would satisfy any testing that he needed to solidify, and then have Ms. Shaw look over the documentation that he provided regarding the marijuana use, and then potentially at a later date be granted permission should the court find that reasonable. Otherwise, I believe recommendations are well in order, and I'd ask to be adopted. Thank you, Judge.
All right, so here's what the court has before it, a request. Well, that was dated April 27th is a letter from that approved Mr. Abrams' medical marijuana card through the state of Michigan Licensing and Regulatory Affairs Division. This appears to be a new doctor specifically for cannabis purposes only and not a treating physician. And this appears as though this, well, first of all, this care plan for cannabis therapy was May 5th, dated May 5th. And this card that was approved was dated April 27th, both of which were after these violations. Further, the court will note in reviewing the pre-sentence report, I need some clarification because counsel, you indicated your client has a cancer diagnosis but I'm showing here that your client stage 4 cancer, that he's been cancer-free since 2023 based upon the report at time of sentencing.
Yes, Your Honor. The cancer diagnosis was originally the reason why he got medical marijuana in the first place. And then when he had a remission, he still continued to use cannabis use for pain management. That being said, I would encourage my client to get further documentation from a prescribed physician to substantiate the potential necessity for medical marijuana. And until that is provided and improved, I would again also encourage my client to discontinue any use that is not permitted by the court.
Right. So, sir, your treating physician, because in your report, it indicates you have a treating physician, that you were under a doctor's care. So I need something from that treating physician, not from this person, this doctor that you just met with for the first time on April 23rd.
Okay, my doctor did recently retire, so I would have to sign on with a new primary physician there, but I don't even know if it's within their policy to write the cards for it. When I had called to ask to set up an appointment with them, the receptionist had advised me to go do this, to do that. I have nerve damage due to the tumor cutting off all my circulation in my left leg through my femoral artery for the stent of my medical condition, and I didn't realize that it was something that I was just using recreational cannabis because I started using it when I got sick. It continued, and there was just I hadn't seen a need to get a medical card.
Okay, so sir, let me just clarify something. That you don't need to actually get a card. If I have something from your treating physician that just indicates that that's how long they've been your treating physician, and how often you have follow-up appointments and whatnot, then just so you know, that will be sufficient. Lisa, you don't have to let that, you can let the people sit in the waiting room for a little bit.
Okay.
When they're popping in, just till we clear a couple of these people off. So it's easier for you. So, and also, sir, nevertheless, you still tested positive for marijuana without having any approval to use marijuana.
I understand that. I wasn't fully aware. Well, I was aware. I understand. I'm sorry. I'm not exactly sure what to say.
Okay, well, I'm going to adopt the recommendation of part. I'm going to order you to continue and complete all terms of probation. You are to pay a $50 probation violation fee. The court's going to also order 15 days jail suspended. And so I just wanted to be clear that you do not currently have approval by this court to utilize marijuana for medical purposes. You need to make sure that you're submitting something from your treating physician.
When you say treating physician, that's like the primary care doctor or whatnot.
Yes, or your oncologist, if you still treat with your oncologist or what that may be. Somebody that can show that there's a bona fide patient-doctor relationship and not just somebody that you just walked into a medical clinic and.
Well, this gentleman, I did meet with him. We had about a 2-hour meeting beforehand. He went over a lot of my medical records and whatnot, and then we went through with going through with the state stuff. And then he did tell me that if I needed to, I could reach back out to him and he could make a letter of medical necessity and all that stuff. So I'll figure it out. I apologize.
Sir?
I'm okay. Yeah.
Excuse me. Do you have a follow-up appointment with this doctor?
I'm waiting for the receptionist to call me with a follow-up appointment. We were supposed to schedule it. I just haven't. Been trying to find. I have my I had my MAD meeting tonight. I had my substance intake the other day. I have the follow-up with them in 2 days. On top of school and work, I've been just trying to figure out a time frame that's good for me to be able to follow up.
Okay. All
But
right,
he
well,
suggested every 3 months
every 3 months?
is what he had suggested, and he told me I could call back when I had a date.
Okay, well, when you get,
to reschedule it, so
when you get that date, sir.
I'm sorry.
When you get that date, send that into your probation officer and we may be able to readdress that if you haven't already submitted something from your treating physician.
Okay.
Okay. All right. I'm going to have you please email in your probation officer and then somebody will be with you shortly. Okay? Thank you. Have a good day.
Thanks. You too.
All right. Thank you. All right, let's go off the record for a moment. Okay. All right, let's go on the record in the matter of City of Wyandotte for Aaron Smith, 251681 A and C, and then in council.
Yes, Your Honor. Edward Holmberg on behalf of the defendant who's sitting to my left, right, excuse me. Say hello.
Hello.
To your name.
Ma'am, hello, your name, please?
Aaron Smith.
Okay, and so today's the date scheduled for sentencing as well as a bond violation. And the sentencing is on your client's plea to an amended charge of operating while visibly impaired.
Correct, Your Honor.
Operating while intoxicated and open intoxicants in the vehicle were both dismissed by way of resolution between council. And then the speeding was amended to a double parking. And council, as to the bond violation is alleging that your client tested positive for.
There was
I'm
one
sorry.
positive
It had-
test on.
Hold on, please, that there were missed tests on the sober link. A number of missed tests on the sober link, and then there was a positive test on Sunday, March 29th. As well as multiple missed tests on that same day.
That is correct, Your Honor.
Missed tests on April 10th, April 14th, April 26th. And also a missed test on February 21st. And so council, as to the bond violation, what's happening with that?
Well, just if I may, Your Honor, the defendant has notes about those dates, about what happened, get the allegations. I think it might actually be better if we did that in person, just because I think we could explain it better that way with her notes. I don't know if the court would want to just put the bond violation off to another date and we could do the sentencing, or if that would work, we could come in person. She's got notes that explains what happened on those dates and the reason for the missed test. I believe she did provide some of them to the court as well, that the court might have. I'm not sure if the court reviewed them. They were emailed to the court.
All right, well, council, if you want to do that in person, then we'll just handle all this in person. Alicia, can we do an in-person hearing?
And we could do it today. Would that work?
Well, when can you be here?
I guess, well, I mean, or,
I don't know right now.
yeah, we can be there in 20 minutes, not even, depending on, make sure there's no trains, probably 15 minutes.
Okay. All
All
right.
right. See you shortly.
Okay, we'll see you shortly.
Yeah.
Yes, let's go off the record. What?
I'm not.
Oh.
Well, on the iPhone?
Hello?
What's your name, please?
Yakira Smith.
Okay.
This was scheduled for 8:45, ma'am. Are you just now logging in?
No, I've been
She
here,
was,
but
okay.
I've been here. It's just my connection had disconnected.
No
And I
worries. Okay,
joined
thank
back.
you. Okay. Mr. Katz, did you speak to Ms. Smith already?
We did, Your Honor. So we're all
Okay,
set.
so okay. So, all right, do you have to, do you need to check anybody else in?
No, I don't believe so.
Okay.
Excuse me, Your Honor.
Who's that? Mr. Smith?
Yes, my name is Troy Smith. I'm
Yes.
still waiting, right?
Yes, you've already
Okay.
spoken to Mr. Katz, correct?
Yes, ma'am. Yes, Your
Okay,
Honor.
yep. We're just getting ready to call this here in just one moment.
Okay, I was
Excuse
just
me
making
too.
sure.
Hold on, I can't have everybody interrupting when people are speaking. Okay?
I'm sorry, I don't know how this works and I have a 10 o'clock. Do I just sit here and wait?
You're Miss LePage?
Yes.
Yes, and that's Robert LePage. We're waiting to see if Devin Gomez has checked in.
Okay, do I just unmute my phone then till you call me?
We request you to unmute, yes.
Thank you.
If Mr. Gomez is out in the parking lot, in the lobby.
No, I haven't gotten anything from Dave lately, but.
All right, Ms. Wilburn, we have you checked in as well.
Your Honor, I was actually just popping in. I tried calling the court. Mine's a dismissal, both of mine, but it was submitted this morning. So I just wanted to make sure the court was aware.
Okay, perfect, thank you. Yes, it's much more effective by email, counsel, only because our landlord tenant clerk is in here doing the recording today. So,
Okay, no problem, Judge.
okay.
I just wanted to let you know it's a dismissal.
Okay, thank you.
Thanks so much. Have a good day.
As well. All right. So. So. I'm not sure whose phone is making that noise, but, Mr. Lumber, did you speak to Mr. Anderson already?
I did, Your Honor, and we have a consent judgment.
Okay, all right. All right, let's go on the record in the matter of residences on Penn versus Suzette Bellinger, 2600571.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
I thank you, Ms. Bellinger. Please unmute and state your name for the record.
Suzette Bellinger.
Okay, and counsel?
Your Honor, this is a non-payment rent possession case. We did enter into a proposed consent judgment. There's currently a balance due of past due rent of $3,388. That's 3388. 180 of costs for a total of $3,568. Ms. Bellinger has until May the 29th to pay that amount. She was advised of MCR 4.201 and the court's gonna submit, so.
Okay, and so, yeah, you heard the resolution that was placed on the record, correct?
Yes.
And you understand that Mr. Katz represents the interest of your landlord and not your interest, correct?
Yes.
Also have received your advice of rights in your packet of information, correct?
Yes.
And you've had the opportunity to review that information.
Yes.
You understand that by entering into this agreement, ma'am, that you'll be waiving some of your rights, specifically your right to representation and rental assistance, correct?
Correct. Yes.
And do you have any questions regarding that?
No.
All right, the court does find then that the waiver of rights is valid. The terms of the judgment are reasonable. The court does find by consent plaintiff is entitled to recover possession of property. The amount not due owing for unpaid rent and other costs is $3,568. If that amount is not paid, or defendants that move out on or before May 29th, plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage or property the rent continues to accrue.
Yes.
What is that? Oh, okay. And no money judgment will enter at this time. And any objection to the court indicating via Zoom on your signature line for the judgment?
Yes.
Do you have an objection to the court entering your name or entering via Zoom for your name?
No.
Okay. All right. The court will sign this and then you will receive a copy of this later today.
Okay, thank you.
You have a good day.
You too.
Thank you.
Bye-bye. Do I just leave? Do I?
Oh, okay. Yes. Okay. Did they already chat? All right, let's go on the record in the matter of residences on Penn versus Brianna Stevenson, 2600572.
Good morning again, Your Honor. Sidney Katz on behalf of plaintiff.
All right, thank you. And Ms. Stevenson, your name for the record, please.
Rihanna Stevenson.
All right, thank you. Ma'am, please turn on your camera.
Oh, sorry, 1 second.
Okay, thank you. All right, and so counsel, you had an opportunity to speak to Ms. Stevenson, correct?
Yes, Your Honor, we do have a proposed consent judgment. This is a non-payment of rent possession case. There's currently a balance due of past due rent of $1,738, costs of $180 for a total of $1,918. That's 1918. Defendant has until May the 29th to pay that amount. She was advised of MCR 4.201.
All right, and so, ma'am, you've heard that agreement that was placed on the record, correct?
Yes.
Okay, and you understand that Mr. Cass represents the interest of your landlord and not your interest, correct?
Yes.
And you've also received your advice of rights and your packet of information, correct?
Yes.
And you've had the opportunity to review those rights.
Mm-hmm.
Is that yes?
Yes, sorry.
That's all right. And you also understand that you'll be waiving some of those rights by entering into this judgment.
Yes.
Do you have any questions regarding those rights?
No.
Do you have any questions regarding your rights in the court rule as Mr. Katz explained to you?
No, no question.
All right. The court does find by consent. Well, first, the court does find the waiver of rights is valid. The terms of the judgment are reasonable. The court does find by consent that plaintiff is entitled to recover possession of the property. The amount due and owing for unpaid rent and other costs is $1,918. If that amount is not paid, the defendant not move out on or before May 29th. Plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage to the property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter at this time.
Okay.
Any objection to this court indicating via Zoom on your signature line?
I'm sorry, what was the last part?
Do you have any objection to the court indicating via Zoom on your signature line?
No.
Okay. All right. The court will send that back to you later today.
All right. Thank you.
All right, thank you.
Bye.
Let's go on the record in the matter of residences on Penn versus Shakira Smith, 2600574.
Good morning again, Your Honor. Sidney Katz on behalf of plaintiff.
All right, Ms. Smith.
Hi,
Hi, your name, please?
Shakira Smith.
Shakira, I'm sorry, I think I said Shakira, I'm sorry. All right, and so
That's
today is the date scheduled in this matter for, I believe this is the first hearing, counsel, and do you have an opportunity to speak to Ms. Smith?
I did, Your Honor. Your Honor, we did enter into proposed consent judgment. So this is a non-payment rent possession case. There's currently a balance due of $2,376 of past due rent, $180 of costs for a total of $2,556. That's $2,556. Defendant has until May the 29th to pay that amount, and she was advised of MCR 4.201.
All right, and so ma'am, you heard all of that. That was just placed on the record, correct?
Yeah.
Yes?
Yes.
All right. And you understand that Mr. Katz represents the interest of your landlord and not your interest.
Yes.
And you understand your rights that you've received in your packet of information. Is that correct?
Yes.
And you also understand your rights under the court rules explained to you by Mr. Katz, correct?
Yes.
Do you have any questions regarding any of that?
No.
All right, the court does find the waiver of rights is valid. The terms of the judgment are reasonable. The court does find by consent, plaintiff is entitled to recover possession of the property. The amount now due and owing for unpaid rent and other costs is $2,556. If that amount is not paid or defendant is not about on before May 29th, plaintiff may apply for an order of eviction to the defendant. Additional money may be owed if damage to the property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an eviction, and no money judgment will enter at this time. The court will sign it upon receipt. Do you have any objection to this court indicating via Zoom on your signature line, ma'am?
No.
Okay. All right. You'll have, the court will sign that and send it on out today.
Okay, thank you.
Have a good day.
You too.
And then we're on the record in the matter of residences on Penn versus Troy Smith, 2600575.
Good morning again, Your Honor. Sidney Katz on behalf of plaintiff.
I'm sorry, counsel, you trailed off. What was that?
Oh, good morning again, Your Honor. Sidney Katz, P51471 on behalf of plaintiff.
All right, thank you. And Mr. Smith, your name,
Yes.
please.
Troy Smith.
Okay, sir, do you have a hat on?
No, I took it off. Sorry, Your Honor.
You had a hat on when I asked the question, so the answer is yes.
Yes.
Okay, and you're in a vehicle, but you're not driving, is that correct?
Yes.
Okay, and so, counsel, you had an opportunity to speak to Mr. Smith?
Yes, Your Honor. Your Honor, this is a non-payment rent possession case. We did enter into a proposed consent judgment. Currently, there's a balance due of $5,043 of past due rent, $180 of costs for a total of $5,223. That's 5223. Defendant has until May the 22nd to pay that amount or move out. He did indicate he is planning on moving out. He was advised of MCR 4.201 as well.
Okay, and so Mr. Smith, you heard that agreement that was placed on the record, correct?
Yes, Your Honor.
And you also understand, sir, that Mr. Katz represents the interests of your landlord and not your interests. Is that correct?
Yes, Your Honor.
And you have also, sir, received your advice of rights in your packet of information, correct?
Yes, Your Honor.
And you understand by entering into this agreement that you'll be waiving some of those rights, specifically your right to representation and rental assistance, correct?
Yes, Your Honor.
All right. Do you have any questions regarding those rights?
No, Your Honor.
All right. The court does find the waiver of rights is valid. The terms of the judgment are reasonable. The court does find by consent plaintiff is entitled to recover possession of property. The amount now due and owing for unpaid rent and other costs is $5,223. If that amount is not paid or defendant does not move out on or before May 22nd, plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage to the property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter at this time. Any objection to the court indicating via Zoom for your signature line, sir?
No, Your Honor.
All right, the court will sign that and send that out today. Have a good day.
Thank you.
Thank you. All right, and then Mr. Katz, you have one more residences on Penn versus Marjorie Fisher, 2500569. Counsel, your appearance, please.
Good morning, Your Honor. Sidney Katz, P51471 on behalf of the plaintiff.
All right, and we don't have a Marjorie Fisher that's checked in. And counsel?
Your Honor, this is a non-payment rent possession case. There's second mailing by the court at this time requesting a default judgment. Currently, there's a balance due of $4,038. That's 4038 of rent, 180 of costs for a total of $4,218, 4218. Requesting a default judgment in that amount with writ to be issued after May the 22nd. To the best of my knowledge, the defendant is not in the military, minor, unable to stand trial, and to the best of my knowledge, the property is being kept habitably.
Okay, the court will note this matter was scheduled for 8:30. It's now 10:37. defendant not checking in, not contacting the court, second mailing being completed. The court does find, by default that plaintiff is entitled to recover possession of the property. The amount now due for unpaid rent and other costs is $4,218. If that amount is not paid, the defendant does not move out on or before May 22nd. Plaintiff may apply for an order evicting the defendant. Additional money may be owed if damage to the property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judge will enter at this time.
Thank you, Your Honor.
All right, and I will sign that judgment and send that back.
Thank you. Have a good
All
day.
right, thank you. Have a good day. Okay, let's do this here. Okay, let's go off the record for a moment. Okay, let's go on the record in the matter of the city of Wyandotte versus Aiden Nemeth, 26354.
Morning, Your Honor. Edward Sullivan, I agree on behalf of the defendant, Mr. Nemeth. Please speak clearly. Give your name to the judge.
All right, good.
Sorry.
You can adjust the microphone. And so good morning. And today is the date scheduled for sentencing. However, that cannot be effectuated because your client did not complete the needs assessment. And the link was sent on March 1st.
Judge, today's gonna be like Groundhog Day because the next defendant did the same thing. And I think that generation, when they were born, the OBGYN gave him a cell phone after he smacked him. And I don't know how they couldn't figure out how to do it, but I got two young guys who are more technologically advanced than I will ever be. And neither did it. So they did it out in the hallway, but we're gonna have to come back. I'm sorry.
Right. I mean, sir, you were sent the link on March 1st. No, that could not have been March 1st.
March 19th, I think, Your Honor.
No. He didn't enter the plea until April 1st, so that was April 1st. In any event, sir, that's been 5 weeks. Do you recall getting that link?
I didn't check my email.
What? That's like not checking your text messages when you're giving your number to somebody that you're interested in. I mean, come on. Or your Snap. I guess they don't do text message anymore. It's Snapchat. So, sir, that's your responsibility. You've given your information to probation, so you should expect that you're going to receive something. If you're to test right now, what's in your system? Bond and conditions are continued. You have to go to probation to get your rescheduled sentencing date.
By the way, the other thing that young people do is after they don't check their emails, their phone will be at one bar. They're gonna ask to borrow your charger. That's the second thing they do. So,
Well,
right?
that's not
We'll
wrong.
get a new date, right, Judge?
Yes, from probation. All right.
I got another guy who did the same thing.
Yep, I see that too. City of Wyandotte versus Faro Gallio, 26368A.
When I act for the defendant, I'm not saying anything. I'll give your name, sir. Wait, no hands in your pocket.
Oh, and thank you for dressing appropriately, Mr. Nemeth, and also Mr. Gallio. Okay, and your name, please?
Otto Gallagher.
Okay, so you were sent your needs assessment and you didn't complete that either.
No,
Why not?
I just seen the email yesterday. I just completed it in the hallway.
You didn't check your email for the last month either?
I didn't check it. I totally forgot about it. I've been running my business, so.
Or do you get people to email you information for your business?
It was in the junk folder.
Okay, and you knew that you were going to be receiving that. So you probably should have, what's that?
That had reminded me. I forgot about it.
See, Mr. Zelnick has to get used to holding hands again for people to make sure they're getting stuff done. If you're a test right now, what's in your system?
Absolutely nothing.
Bond and conditions are continued. You'll get your rescheduled sentencing date when you go to probation.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Okay, and then counsel, I'll be with you and Mr. Gates in just a couple moments. Okay, and then let's go on the record in the matter of Devin Artrip, 173988.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Okay, Mr. Artrip, your name for the record, please.
Yep. Arthur.
All right, thank you and good morning. And today is the date scheduled for show cause. Well, there's a warrant because you didn't appear for your show cause. We had moved it to, let's see here. January 22nd or 26th. You did not appear for that warrant issued January 28th. You walked in on the warrant and it shows as though your fines and costs need to still be paid, sir. Alicia, would you mind looking this up to see what the balance due and owing is, please? Thank you.
Your Honor,
Yes.
I came in, I believe 2 months ago, and you gave me a date, and then I got it in the mail that it was today.
Correct. So originally you were supposed to have been here January 28th. You walked in. I believe it was April 14th and we moved it to today's date. Oh, no, it was the 28th and we moved it to today's date.
Excuse me. Judge, the total balance is $2,242.
Okay, $2,242. All right, counsel, did you speak to your client about a payment plan?
I did, Your Honor.
All right, where are we at with that?
Your Honor, as he indicated, he was in treatment to the beginning of April, and then he went to Salvation Army, got out on May 18th. Right now he's on tether with Lincoln Park, living in Ecorse with his mother. He's currently applying for jobs. He was asking if he could start a payment plan next month, starting June 15th. To begin with, right now, feasibly $75 a month, but obviously once he gets employment, to be revisited.
All right, you can pay $75 per month beginning June 15th, sir?
Yes, all I can do right now is just donate. I'm trying to get on my disability. But my lawyer said that probably won't be until like September. So
Okay.
I can I can get paid up to $1,900 a month, without it affecting my, disability.
Okay.
So in the meantime, I'll try to donate plasma and see what I can pay you. And then, I'm on the sober link right now with Lincoln Park. And I was supposed to be off in January. And I didn't follow, I had a rocky road. I wasn't making the requirements in the beginning of my probation. So Judge Clifton pushed it for a couple more months. And I should know more at the end of this month. On the 21st, I have to meet back with him and Miss Mendenhall. They told me till further notice with the sober links. So I'm not sure if I'm gonna get more time with the sober link at the end of this month or.
Okay, so sir, what I'm going to state is that if for some reason you're having trouble meeting your monthly payment for the court here.
Yes.
Email into the court.
Okay.
Or communicate with the court.
Okay.
In person, via email. So that a warrant doesn't issue.
Okay.
Okay? All right. Thank you. Have a good day. Okay, and then we are on the record in the matter of King's Sports Apartment versus Phyllis Simmons, 2600578.
Grant Munson for the plaintiff.
Your P number, counsel, please.
P71994.
I'm sorry?
P71994.
Okay, thank you. Ms. Simmons, your name for the record, please.
Mrs. Simmons had passed away. I'm her son, Dylan Simmons.
Okay, Mr. Simmons, please turn your camera on.
I don't have a webcam.
Are you on a computer or a phone,
Yes, I'm on a
sir?
computer.
Okay, well, I need to be able to see who I'm speaking to, so
Maybe
So if
Mr.
you
Simmons
can't-
could hang up and then reconnect on a phone.
well, I'm sorry, counsel, let me just ask a question. Mr. Simmons, do you have a cell phone?
Yes, Your Honor, but I don't.
Sir, I'm not proceeding if I can't see you. So your option is to either you have to come back or come in person in just a short bit, or you can call back in on a cell phone with a video. So that's your choice.
Okay. I'll go on my phone.
Okay, you can log off and log back in. Thank you. All right, in the meantime, we'll go on the record the matter of Kings Forest Apartments versus Kenesha Tagger, Alonzia Tagger, 2600580.
Grant Munson, P 71994 for the plaintiff.
All right, and Kenesha Tagger,
Kenesha Tagger.
okay, Alonzia Tagger,
Alonzia Tagger.
okay. And so counsel, you had an opportunity to speak to the tenants in this matter, correct?
I have, Your Honor, and they've indicated that they're seeking rental assistance. So I think we're just looking for an adjournment at this time so they can do that.
All right. All right, you can set this for a second hearing, May 29th.
Eight 30.
8:30 a.m. And you will both have to submit DC Form 539 within 5 days. Okay,
Thank you. Okay.
thank you. We'll see you back on the 29th at 8:30.
Thank you.
Thank you. And then we are on the record in the matter of 14411 Pennsylvania Road versus Derek Anderson, 2600582.
Ready, Your Honor. Eric Lumberg on behalf of the plaintiff, P 46135.
Okay, thank you. And Mr. Anderson,
Yes, ma'am.
your name for the record, please.
Derek Anderson.
Okay, and so counsel, you had an opportunity to speak to Mr. Anderson, correct?
Your Honor, I did, and we've reached an agreement.
All right, and if you'd like to place it on the record?
Yes, Your Honor, we've reached an agreement to enter a consent judgment, possession only. Rent to retain possession is $4,379.78 plus $164.15 in court costs and fees for a total of $4,543.93 to be paid or vacate by May 25th. 2026, or which shall issue. Mr. Anderson has been advised of all of his rights, given me permission to sign his name. Judge, I apologize. I did not submit a proposed order. I will get a consent order with everything filled out, e-filed quickly within the next half hour.
No worries. We just try to do that as a benefit to all parties. And so counsel, I just want to confirm the amount of unpaid rent is $4,379.78, correct?
Correct.
Okay. All right, and so, Mr. Anderson, you heard the terms of that judgment, correct?
Yes, ma'am.
Okay, and you understand that Mr. Lumberg represents the interests of your landlord and not your interest?
Yes, ma'am.
And you also understand, sir, that your advice of rights that you've received in your packet of information, correct?
Yes.
And do you have any questions regarding those rights?
No.
All right, and you understand, sir, that you'll be waiving those rights, some of those rights, specifically your right to legal assistance and.
That's what I've been trying to do. I called the property manager and told her that. So.
Well, I'm sorry. What have you been trying to do, sir?
Get rental assistance.
Have you applied for rental assistance?
No, I've been working, trying to come up with the money to pay them. So I haven't really had time to do that, but I had to call off so I can come to court today. So yeah.
Okay, so you're seeking rental, I'm sorry, what's that, counsel?
So, Your Honor, I was going to say, Mr. Anderson did not inform me of that If he does want to apply and submit the proper paperwork, then we'll have to set a new court date.
Okay, so I'm indicating that, so we're not gonna enter the consent judgment
Okay.
because, okay, so we'll set this for a second hearing on May 29th.
8:15.
I'm sorry,
8:15.
8:15?
Oh, I'm sorry. No, 8:45.
I can work earlier if you want me to work earlier, but, okay, 8:45 AM. Sir, you have 5 days to submit your, it's called DC Form 539.
Okay, you talking to me, ma'am?
Yes, sir.
5 days, okay.
Yes. Okay, we'll see you
And
back on
with-
May 29th at 8:45 AM.
May 29th, okay, thank you.
Okay, Mr. Anderson, you should go make the payment of what we've talked about.
All righty.
Okay, thank you, Your Honor.
Okay, thank you. I appreciate your patience today.
Okay.
Okay, and his, Mr. Gomez checked in? Do we know? Let's go off the record for a moment.
No.
Okay. All right, Mr. Shemke, you've spoken to, Ms. Lopez and Mr. Stroya?
I have, Your Honor.
Okay, perfect. Okay. Just so you know, Miguel Velasquez in the breakout is in the waiting room, but we're just pausing on some of those right
And
now.
I've spoken to him already as well, so I don't need a
Very
separate
good.
one.
Okay, alrighty. Okay, and so we're on the record matter, Robert LePage, Marie LePage versus Devin Gomez, 2600678. And Mr. Robert LePage, your name for the record, please unmute.
You have to say your name.
This is Robert LePage.
All right, good morning. And Marie LePage, your name for the record, please.
Marie LePage.
Okay, and so today's the date scheduled in this matter. It appears as though it's the first hearing. And I do not, let's see here. I do not see personal service effectuated. I do not see a request for a second mailing. So we have to set this for a second hearing because the defendant has not appeared and I'm not permitted to enter a default without either personal service or a second mailing.
I'm sorry. Could you, what was that? Say that again.
I'm sorry?
I'm not understanding. What did you just say?
Well, there's a procedure by which this court, since the defendant did not appear,
okay,
whereby this court could enter a default judgment if that's what you requested. However, before I can do that, there are certain procedures that have to have been followed, and those were not. So I cannot enter a default judgment at the first hearing because there was not a request for a second mailing. And so therefore, there was not one done. Further, there was not any personal service. So I cannot enter a default judgment only on alternate, on posting.
now Randy Miller did go and try to deliver it. Doesn't that count? And he posted it on the door.
Okay, so ma'am, that's what I just stated. That's not personal service per the court rules. That's posting. So I cannot enter a default judgment on that because there was not a second mailing that was requested by you. So we're gonna have to set this for a second hearing on May 26th.
You can't, we just want to get the property back. We can't.
Ma'am, I've just stated the process by which I can do that. I cannot enter a default judgment today because personal service was not obtained on the tenant by the process server, and a second mailing request was not completed nor paid for by you and Mr. LePage. So I am precluded from entering a judgment today.
Okay.
And Alicia, what time on the 26th?
8:30.
8:30 a.m. on May 26th. Does that date work for you or no?
May 26th, hold on. No, that will not work. Could you do it the Wednesday?
We don't do these on Wednesdays. We can do them on Mondays, Tuesdays, or Fridays.
Okay, hold on. I just gotta look at one thing.
I can do May 29th.
We'll take the 26th.
Okay, at 8:30 a.m.
Yes.
Okay, we'll see you all back on May 26th, 8:30 a.m.
Okay, thank you.
Thank you. Have a good day. Okay. And okay, so let me just oh, they're there. Okay. All right. I'm going to step off. I have to chat with two attorneys in just one moment. Then we're gonna go down the list here with Ms. Lopez, Mr. Rhodey, Ms. Shabani, Mr. Stroya, then Robin Morgan. In that order, we're going to do that. All right. So let me
Please rise.
go off the record. And then we're not meeting, at least you have to check everybody in. Okay.
You may see it. Should have mentioned. Yeah, take these two, forgot my.
I couldn't hear our.
Pardon me?
When she went through that list of who she's gonna call when she comes back on, I didn't hear her call.
Well, she doesn't. If you want to see that, we know you're.
Oh, okay, all right, just.
We've got, yeah.
I'm gonna be last.
I have a feeling you're gonna tell me there's something I can do, but the hearing is gonna be more today for the stipulation for the attorney to withdraw for the plaintiff.
Okay.
So if we stipulate to adjourn to a new date, can we get out of here? I think the case is going to close as well, so I think we're just gonna end up adjourning and then stuff.
See, she usually, she want to call it on the record, she usually goes kind of, because we've got, obviously you can see there's a lot of people here, so. She usually goes in order of the docket, but I'll see what that was.
Yeah, she's probably gonna wanna call it on the record more than likely, but I. Okay. Oh, I know you're. Okay, I appreciate that.
If you're familiar with it, then you can.
Yeah, I'll ask her.
I see Mr. Simmons on here.
Okay.
Mr. Simmons, can you unmute and turn your camera on, please?
There's no talking in court, please.
Yes, sir.
Okay. Oh, hi, Dylan.
Hi.
There's,
Sorry
okay.
about that. I've never done this before.
No, you're okay.
Hey.
All right, so we're on the record in the matter of Kings Forest Apartments versus Phyllis Simmons, 2600578. And I understand that Ms. Simmons has passed away and that Mr. Simmons is here. Mr. Simmons a named in all other occupant counsel?
He is. He's an occupant of the unit.
Okay. All right, and so, counsel, did you have an opportunity to speak to Mr. Simmons, correct?
Yeah, I did, Your Honor. He's indicated that he's applied for rental assistance or is in the process of doing so. And so I think we'll need an adjournment and then hopefully we'll resolve it and go from there.
What am I looking for in the metal stand-up files, you said?
Mhm. Yeah, it's laying like that. It's like that. It's in there like that, but it's just loose paper. It's not a file.
Is it a new file?
No, it's not a file. It's just paper. There's a package of papers.
Package of paper.
Yeah. It's not paper.
Okay,
Just loosely in there.
all right.
Yes. All right. Okay, so. Oops. Okay, and so we will set this for second hearing on May 29th. $8:45. 8:45 a.m. And then you have 5 days to submit DC Form 539, please.
Okay, Your Honor.
Okay, we'll see you back on the 29th. Thank you.
Thank you, Your Honor. Have a nice day.
You as well. Thank you.
Yep.
Great. Okay, and then we are on the record in the matter of Haley Lopez. Yeah. Oh, thank you. No, okay. We're on the record in the matter of Haley Lopez, 25187.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Okay, and Ms. Lopez, your name for the record, please.
Haley Marie Lopez.
Okay, so this, today's date scheduled in this matter for a bond violation hearing where it's alleged that your client Okay, so this is a bond violation as this matter the conviction or the offense in 24th District Court occurred while your client was on bond prior to being placed on probation. So, because your client the offense date was January 26th. Your client was on probation or was on bond and not sentenced until January 29th of 26. So that's why this is scheduled for a bond violation as opposed to a probation violation. And so counsel adds to the bond violation.
Your Honor, my client is not asking for a hearing, will admit to accruing a new charge while on bond.
All right, ma'am, please raise your right hand. Do you solemnly swear or affirm the other right hand? Thank you. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And so you heard the allegation, correct?
Yes, Your Honor.
And as to that allegation, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights?
Yes, Your Honor.
And you understand the possible penalty as a result of your plea?
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And counsel, if you can please vote to your client. You can lower your hand, ma'am. Can you please vote to your client?
Yes, I'd like to direct your attention back to your offense date with the 27th District Court. That was on January 26th of 2026, and you had a pretrial date in which you pled guilty on April 15th of 2026. Is that correct?
Yes, Your Honor. Or yes, sorry.
All right, and while on bond, though, you did accrue a new charge out of, I believe, the Lincoln Park District Court for retail fraud, which would violate a bond condition that you had to not have police interaction or accrue new charges. Is that correct?
Allen Park, but everything else is correct.
Yes, Your Honor. Thank you. Allen Park. Your Honor, I would stipulate to the violation and defense satisfied.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violation. And counsel?
Your Honor, she currently has excuse me. She is scheduled for a PSI on June 5th of 2026, and then is sentencing in Allen Park on June 5th. So I'd ask that we just maneuver the sentencing, see what the PSI and the sentencing terms and conditions of Allen Park are. It's quite possible that there's an option to run some of the terms and conditions concurrent. Thank you, Judge.
Well, I don't know that that's necessarily the best way to handle this. Ms. Lopez, you're on bond. And while you're on bond, you're convicted of retail fraud for stealing $158.20 worth of items, 13 different items.
There's no excuse for it, but I got kicked out of my mom's house and I was going through a really hard time. I'm very ashamed of what I did. It's not who I am, and this is a very big learning experience for me.
And did you inform your attorney of that prior to sentencing in this court, or no?
I informed Allen Park about that. They're aware of it, but we didn't really have a major discussion about it today. It was just the basics. So no, I didn't.
No, ma'am, your attorney that you had for sentencing.
Oh, yeah, and Allen Park?
No, here.
No, I didn't.
Okay. And so are you working?
Yes, I am. I'm at work right now.
Where are you working, ma'am?
I'm working at a Coney Island called Ted's in Allen Park.
Okay. All right. The court's going to order 5 days jail. I'm going to suspend that jail. You're all set. Have a good day.
Thank you, Your Honor. Have a great day.
You as well. All right. Let's go on the record in the matter of the state of Michigan versus Dennis Rohde, 26305.
Good morning, Your Honor. Mark Mandel on behalf of Mr. Rohde, who's present by Zoom. I'm in my car. I'm not operating the car.
Okay, very good. Thank you. Mr. Rohde, your name for the record, please.
Dennis Rohde.
Okay. Today's date scheduled in this manner, counsel, for sentencing on your client's plea to an amended charge of fleeing elude 4th degree attempt, as well as phones have to be off. Unregistered, operating an unregistered motor vehicle. And counsel, I just want to confirm there was an amendment done on the pre-sentence report and recommendation. And did you receive the amended one?
Amended.
It was sent yesterday afternoon, probably about 4:30 or so, to your office because upon review of this, it appeared as though the convicted offense appeared under the original offense on the report and recommendation that was submitted, as well as the early termination being not eligible because of waiver of that. That also have been left off of the original one. So I just want, those were the two portions of the report that were amended that were sent out. Did you receive that, counsel? You're muted.
Sorry, Judge.
Okay, did you receive that, counsel?
I'm looking right now. Yes.
Okay. All right, so did you have an opportunity to review the report and recommendation with your client?
I have, Your Honor, and we'd ask that the court adopt the recommendation. And if I may speak on behalf of Mr. Rohde's behalf, Judge, for a man Mr. Rohde's age, there is no excuse to offer about his behavior. And even when I ask it or his wife asks why you did it, Dennis said the same thing. He had a triggering moment in his head and he panicked and he took off on the bike. None of it made sense, especially when Dennis doesn't have interactions with the law. He's raised children, he's married, and he has a good job. As a result of this incident, his entire career was on the brink of being thrown away. But the dealership is sticking with him and they're keeping him gainfully employed. He is so thankful of that. He is so thankful of the offer the prosecutor made in this case. As soon as this incident happened, it required, in essence, a family intervention. And when I first met Dennis a day after or 2 days after the incident, he was beyond panicked about it. I have seen personally Dennis accept full responsibility for this, and not by just saying it to the court, but understanding his actions and getting treatment for it. He has extreme anxiety issues. So, Judge, he's lined up before you, being very proactive, obviously very remorseful. He, in essence, turned the motorcycle into a weapon by driving at that speed, fully aware of it. This court knows some people come before you with a heart and a conscience, and some don't. In Dennis's case, this weighs heavily on his conscience and heart. And since this incident happened, not only is he addressing it, but he's addressing his the underlying anxiety issues which he has suffered with his entire life. So with all that said, Judge, I think it's a proper recommendation. We're thankful of the recommendation. We're thankful of the offer, because this case could have been worse. And with that said, Dennis, is there anything you would like to say to the judge?
Yes, please.
Okay,
Good morning, Your Honor.
good morning.
I have thought about this many times. I've relived it in my head over and over, as you can imagine. And my first thought is I'm very happy that nobody was hurt or harmed or was ever in enough danger that somebody got hurt. And as a father of two and a resident of city of Wyandotte, for me, if I would have heard of this and it involved any of my boys, or he's seen something like this and told me about it, I'd find it completely unacceptable. And as I relive that, I have just decided to make sure that that the city gets what it deserves, and it's a better version of myself. And I intend to do it if given the opportunity.
Thank you for that, Mr. Rhodey. And if by city, you mean the community in which you live, which is the city of Wyandotte, I can appreciate that. And in fact, you do hear about individuals attempting to flee the police, which they are not usually very successful. They're usually apprehended by the police department. And sir, you actually touched upon something that I was going to ask you, because you were in residential neighborhoods at more than double the speed limit. And not only did you put your own life at risk, obviously, but the risk of everybody in the community, children as well. And so I think a lot can be said that this is at least this is the extent of the charges that you were facing, sir, and not something that involved any injury, significant or otherwise, or anything fatal. So after hearing from counsel, hearing from Mr. Rhodey, reviewing the report, the recommendation, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matters, taking into account the circumstances surrounding Mr. Rhodey and the legislative guidelines, as well as taking into account the plea that was placed on the record. Court's going to order 18 months probation. Per the agreement between parties, Mr. Rhodey is not eligible for early discharge. That eligibility was waived at the entry of the plea. You are not to violate any criminal law of any unit of government. You are not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You are to perform 75 hours of community service, the rehabilitative goal for that condition, so you can further develop life skills and give back to the community. You are to enroll and participate in a decision-based driving level 2 course. The rehabilitative goal for that condition is so that you can further increase your knowledge about traffic laws and safety practices and hopefully prevent this matter from happening again. You also are to participate in the Making Decisions program. The rehabilitative goal for that condition is so that you can learn additional strategies and skills for improving personal choice, personal decision-making. Any questions regarding those conditions?
No, Your Honor.
No, Your Honor.
All right. The court's going to order a $500 fine, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 18 months. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $1,925. There was a bond posted by Angela. Let me see if she's, nope. I believe that she authorized the application of the bond to be applied for fines and costs. So when you go over to probation, sir, or when you email them to probation, you will discuss all that with them. Okay?
We'll be there in 10.
Okay?
Thank you, Judge.
You're welcome.
Thank you.
Have a good day. Sir, email
You-
into probation, please, by 12:15. All right?
Yes, thank you.
Very good. Thank you. Have a good day. All right, and then we are on the record in the matter of the City of Wyandotte versus Robin Morgan, 26330.
Morning, Your Honor. Rick Nelson on behalf of Mr. Morgan.
Thank you. And sir, your name for the record, please.
Robert Morgan.
All right, thank you for addressing appropriately the court. I do appreciate your patience this morning. And today is the date scheduled in this matter for sentencing on your client's plea to an amended charge of operating while visibly impaired. The original charge of operating while with a high BAC was dismissed by way of resolution between counsel. And counsel, did you have an opportunity to review the report and recommendation of the client? All right, and are there any corrections that need to be made?
No, Your Honor, just some information. My client lives in Tennessee. He has a mother that lives in Southgate. He comes up quite frequently to take care of her when she needs certain things. He was very proactive in his sentence. He went to Downriver Guidance and they set him up on a program where he can do some of it there and some of it by video since he lives out of state. He has a lot of medical issues, Your Honor. He was in an accident, he lost a leg, so he has numerous appointments that he has to keep in Tennessee. So I guess what I'm asking is he's willing to comply with everything, but I just asked you to, if you could fashion a sentence, I would ask you for 12 months probation and some consideration so he can come back and forth.
Okay, so I'm a little bit curious as to how the treatment is going at the guidance center if your client resides out of state, because sometimes different insurance doesn't work out of state, so to speak, that are visible line.
Well, he can address that if
They're accepting my insurance. I went twice already. I started last Thursday. And then yesterday was my second class.
Okay.
And they want me to go to my doctor and get a physical, my friend, before it's over.
Okay.
So I plan on being here for at least a month, do a month-long class and maybe take a weekend off, go down and take care of my business down there.
All right, so, and sir, I can appreciate that you have some injuries. Fortunately, you don't have any further injuries as a result of this offense, right? Because, what's that?
What'd you say? I'm sorry.
Fortunately, you don't have any further injuries as a result of your decision to drive that night.
No,
Because at a .175, sir, you were pretty drunk.
I was also parked in the parking lot. Let's see. I'm sorry.
Okay, well, you didn't just plop down there, right? So my point is, sir, is that it could have been a lot worse than whatever this court is going to fashion for its sentence. That's my point in that statement. And you have a prior, so you know, sir, at what point that feels, and what that feels like. So, here's what I'm going to do. Do you travel out of state is your intention to travel out of state on a regular basis, such as the third weekend of every month or once a month?
Until this IOP is done.
Hold on, sir, please let me finish. Okay, because the recording can only record one, and I'm not sure if you know where I'm going with my question. Or are you intending to pretty much reside up in Michigan and only visit down there every once in a while? I'm trying to understand what that is.
No, I live down there. I only plan on coming here to visit and to get these classes done. It's 12 weeks plus 3 months. And they told me I could Zoom a couple of the classes. But I do also have to go down to the primary doctor, like I said, they requested.
Okay, and so you are currently in IOP, correct?
Yes, ma'am.
Okay. And you currently have an alcohol tether, correct?
No.
No. I'm sorry, I read that on another file. I apologize. If you test right now, sir, what's in your system?
Nothing.
Okay, so here's what I'm going to do. After hearing from counsel, hearing from Mr. Morgan, reviewing the report, the recommendation, taking into account the circumstances, the court does find that there was reasonable grounds to depart from MCL 769.5. The court also finds the following sentences in the best interest of justice is reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Morgan and legislative guidelines. I'm going to order 18 months probation. You're eligible for early discharge, given the level, counsel, and that he has a prior, even though it was a number of years ago, the court finds that 18 months is appropriate. The court's going to order 5 days jail suspended. That means, sir, that you don't have to serve that time, but if there's a violation, that jail time's right on the table. Okay? You are eligible for early discharge, which I will go over shortly. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. So what you'll have to do, sir, since you're going to be in between both places, is once you're down in Tennessee more consistently, you'll have to identify a testing agency down that way. Okay. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. And let me just go back to leaving the state without the consent of the court. Currently, you're in Michigan while you're doing your IOP, correct?
Yes.
Okay. And so then what you'll have to do, sir, is if you would like to go down to Tennessee to take care of some matters, you just have to communicate with your probation officer. Okay, you can't just decide, oh, I'm gonna go down there today. You have to communicate with your probation officer, okay? As long as there aren't any violations, there shouldn't be a problem with having that permission granted, but you still need to stay in communication. The court's going to order you to continue with your intensive outpatient substance use counseling. The rehabilitative goal for that condition is so you can continue to have assistance in providing coping mechanisms so you can maintain your sobriety and prevent relapse, hopefully preventing this matter from happening again as well. And then the court's going to also order you to attend the MAD Victim Impact Panel. the rehabilitative goal for that condition, sir, so you can further increase your understanding of the dangers of driving while under the influence and to educate you about the consequences of such behavior. Any questions regarding those conditions? Okay. The court's going to order a $300 fine, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month and 18 months. And since you're eligible for early discharge, sir, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, a total of $1,725. Keeping in mind that up to $450 of that could be waived.
Yeah.
Yes, and your client can work out a payment plan with probation for the balance of that.
He's been paid for that.
Okay, so what we'll do then is we will back out $450, so $1,275 is what would be due and owing, and you did pay $500 already. So that would be $775 out of pocket, if my math is correct. Okay? As I've indicated, sir, you are eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort to making full payment. Okay?
Thank you, Your Honor.
Good luck to you, sir. Please stop at probation and somebody will be with you shortly. I appreciate your patience today.
The rest of the evening.
Thank you, you as well. All right, and this is a matter of Cheryl Shabani, 241258. Mr. Shanky?
I'm sorry, I didn't hear what case you called, Judge.
Cheryl Shabani, 241258.
Your Honor, that is the one person I did not speak to. I didn't speak to that individual.
Okay. Okay, well, we'll recall this one in just a couple moments. Let's go on the
Team turn.
no, that was only for the, well, I don't know that. Notice was that's the. Let me see.
Not still on the
Yeah,
docket.
that's not. I
There
mean,
is-
I'm
Okay,
happy
let's
to
go
talk.
off the record for a moment. Okay, so it appears as though. Right, I don't know where Ms. Tucker is. Ms. Shabani, have you spoken with your attorney?
Yes, ma'am. I talked to her just a little bit ago. She's finishing up a trial, but she's still on her Zoom, so she should be here.
Well, she's not zoomed in yet. Okay, we'll just wait for her to log in then.
I can probably text her really quick, maybe.
That's fine, that's fine. All right, thank you.
You're
All right,
welcome.
let's go on the record in the matter of Steven Stroya, 2690.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Thank you,
Stroya.
and Mr. Stroya, your name for the record, please.
Stephen DeVere Stroya.
Okay, and today's the date scheduled for a probation violation where it's alleged that you tested positive for marijuana on April 4th, tested positive for marijuana and meth April 20th, tested positive for meth and had a diluted sample on May 1st of this year. And you're currently on probation for disorderly conduct and were sentenced on March 17th. And counsel?
Yes, Your Honor, I've reviewed this matter with my client. He's not going to be requesting a hearing.
I'm sorry, what was that?
He's prepared to enter into a plea. He's not going to request a hearing.
All right, and Mr. Stroya, I'm going to ask you to please raise your right hand. You solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay. And, sir, you heard the plea or the allegation that was placed on the record, correct?
Correct.
All right, you may lower your hand.
Thank you.
And as to the allegations, sir, how do you plead?
Guilty.
And you've gone over your advice of rights for probation violation purposes, correct?
Correct.
And you understand all of those rights.
Correct.
You also understand, sir, that by entering into a plea, you'll be waiving some of those rights.
Correct.
And you understand, sir, the possible penalty as a result of your plea.
Correct.
And that the recommendation in this matter is for you to continue and complete all terms of probation, revoke your under advisement status, pay a $50 probation violation fee, attend intensive outpatient treatment, serve 15 days jail tethered to treatment. Do you understand that that's the recommendation, sir?
Yes, I do. Correct.
Knowing all of that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
Nobody has.
All right. Any immigration issues?
No, Your Honor.
All right. And counsel, if you can please body your client.
Yes, I'd like to direct your attention to April 4th, 2026. Did you violate the terms and conditions of your probation by having a test that reflected use of marijuana?
Yes, I did.
And then on April 20th, 2026, did you also have a test that indicated use of marijuana and amphetamine?
Yes, I did.
And then on May 1st, 2026, indicated methamphetamine use as well as a diluted sample. Is that accurate?
Yes, I did. That is very
Yes,
accurate.
Your Honor.
All right. Thank you. The court does find the plea as knowing, voluntary, and factually accurate, and the court will accept your plea to the probation violations. Indicate technical violations 1 through 3 will enter. And counsel?
Your Honor, I will note that my client does have a strong family support system. He is gainfully employed. Judge, I have no concern as applies to the IOP or even the tether to the treatment. Judge, I really would be concentrating the majority of my argument and request humbly for consideration of the advisement status not being revoked. Judge, in this circumstance, I know that these are 3 violations, but they're all within a relatively short period of time. My client's going to articulate to the court that he was making some actively bad decisions, but he has gone headfirst in the right direction to his sobriety as far as seeking proper counseling and company. So I'm going to ask for any leniency this court could determine when determining an appropriate admonishment for my client. Thank you, Judge.
Sir, well, I mean, you have the opportunity for this to be dismissed off your record. And sir, you're violating by using these substances. If you test right now, what's in your system, sir?
If I tested right now, I have nothing in my system.
Video.
Sir, you've taken the substance use to a bit of a different level since you have 2 meth tests on there.
Understand how to fucking do.
Ms. Shabani, we're removing you for your language.
Sorry. So sorry.
All right. So what this court's going to do is this court's going to order you to continue and complete all terms of probation. The court's going to order you to pay a $50 probation violation fee. You're going to serve 15 days jail. You're to report today. You're going to be tethered to treatment. And then upon your release, sir, you are to enroll in intensive outpatient substance. I will continue your under advisement status. If there's one more violation, sir, that's revoked.
Yes, Your Honor.
Didn't he just tell you to stop talking? That's 3 times you've been told that. Stop talking.
You talk again, you're going outside. Understand?
Yes.
Thank you.
You are also going to report to jail tonight. To be tethered to treatment through the Wayne County Jail. And then upon your release, you're to enroll and attend IOP. Okay, sir, good luck to you. Please, please contact Ms. Shaw and she will give you information about, reporting today.
Thank
All right,
you.
Good luck to you, sir. All right, let's go
Thank
off the record for a moment. Ms. Tucker, good morning. Mr. Holmberg, yours is
Good
next,
morning,
right?
Your Honor.
All right. And your client's been on Zoom, but we just removed her because of her language. So she's back in the waiting room. Have you spoken with
Okay,
your
I was
client?
on earlier, but I'm in the middle of a trial, so I had to get back in.
Okay. Have you spoken with your client already? Are you ready to go?
I am ready to go, Your Honor.
All right. Are you on a short break for your trial?
Yes, we're coming, they just said there's a jury verdict, so we'll be going back in the next few minutes.
Okay. Is your client going to be entering into a plea, or are we setting it for a hearing?
So, Your Honor, I don't know if the court saw, they amended it yesterday for the Suboxone. She took in her prescription. And I don't know if Your Honor remember at the last court date, she showed the court that she had a letter from her doctor about the marijuana, and Your Honor said you accept that. So she would just be admitting to the one missed test.
Okay.
She did say she tried to give them the letter that, Your Honor, said she accepts from the doctor, but they didn't take it.
Who didn't take it?
Is it pretrial services?
Well, that'd be our probation department. We don't have the luxury of having pretrial services.
Okay, probation. She did give
Okay.
him the Suboxone. She said she tried to give him the letter that she gave to the court when we were there for the last violation.
Okay. All right, here's what I'm going to do, counsel. Since you're in this jury trial, I'm going to, what we'll do is we'll set, I'm not going to go all the way out to your sentencing date because you don't have sentencing date till July 2nd, I think. So, we will get you a new date on that one, okay?
Thank you, Your Honor.
All right, if you want to just let your client know that we're going to reschedule this.
Will do.
All right, thank you. Good luck to you. Have a good day.
Thank you, Your Honor. You too.
Thank you. All right, so we are on the record in the matter of the City of Wyandotte versus Aaron Smith, 251681. A.
Good afternoon, Your Honor. Christopher.
Nope, this is Mr. Holmberg.
Or I'm sorry, did you call a separate case?
I called Ms. Smith. Yes, it's Mr. Holmberg.
And if I may, Your Honor, Edward Holmberg on behalf of the defendant, who is now at the podium.
Okay. And your name, please?
Aaron Smith.
All right, and so today, so we're here for an in-person hearing regarding sentencing and the bond violation hearing, which alleges that the various SoberLink violations that I stated earlier. And so, counsel?
Yeah, Your Honor, I did go over my client, what the prosecution, or I guess what the conditions, she was entitled to a contested hearing for a bond violation hearing. She has decided to enter a plea of guilty to the bond violation here with an explanation of the point you're in.
Okay. Can some man please raise your right hand? You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
I can't hear you.
Yes,
All right. And so you had heard the allegations that were placed on the record, correct?
that's correct.
And as to those allegations, how do you plead?
Did you miss the test?
I did miss a time.
Okay. And you understand, you've gone over your rights as it relates to bond violation hearing with your attorney, correct?
You're right, you understand you're gonna be tested here, that we discussed that you're gonna plead guilty and then with an explanation, correct?
Yes,
All right. And you also understand the possible penalty as a result of your plea.
yes,
Knowing all of that, do you want to continue with, do you want to continue with your plea?
yes.
And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And counsel, if you can please report to your client.
You read the allegations of the bond violation, the various states that you allegedly missed tests, correct?
That's correct.
And you agree that you did miss those tests at those times, correct?
I agree to a couple of them that I am aware of.
Okay, but there were tests you missed, correct?
Yes,
Okay.
yes,
And then you also saw that there was one test where you tested positive for alcohol, correct?
that is correct.
And you are agreeing that there's a positive test for alcohol, but you have an explanation for that, correct?
I do.
All right, and the court does find the plea as knowing and voluntary and factually accurate. The court will accept your plea to the bond violations. So let me ask this question. There were a number of so February 20, let me see here, I think it was February 21st. You had a missed test at 10 a.m. Then March 29th, you had a missed test at 6:45 p.m., 6:15 p.m., 6 o'clock p.m. There was a positive test, actually, there was a positive test at 6 o'clock p.m. And then you missed your retest. All the way down to 7:45. 7:45, 8:15, 8:45. Then April 10th at 6 p.m., it shows missed test. Also a missed test at 10 a.m. And at 2 a.m. on April 14th. Sunday, April 26th at 6 a.m. And so, ma'am, I explained to you on February 11th that you'd be testing 6 times a day on the sober link.
Can you explain why you were missing those tests and what your notes say? So, please.
So each time that I'm aware that I missed a test, I had like wrote on a Post-it, stuck it in my device box. And then I currently, after I got the violation through my email, I had written out, I went back to my notes. So Sunday, March 29th, I was walking out the door for work. I had my purse around me,
What was a positive test?
that was my positive test. So I'm walking out, I have an Amazon package sitting on my porch, bend over, grab the package, open it, oh, it's my perfume. Squirt, squirt, walk out my door. As I'm walking, my alarm, I have a very obnoxious alarm that goes off every single time I'm supposed to blow. That starts going off, reach in my bag, unzip it, blow, continue walking, get in my car, go to work, walk into work at 6:30, 6:25. We do shift change. I have a full guardrail, and I never looked back at anything. I waited. My alarm went off on my watch. 10 p.m. I go and I see that I missed a test, and I started freaking out. So that was in regards to Sunday, March 29th. That's what had happened. I didn't even realize I had blue positive. I had
Doesn't that send a notification on your device?
So on the device, if you miss, it tells you, it says retest, and then you have to wait 15 minutes. And then you redo it. But I put it back in the case, I zipped it up, put it in my purse, got to work and started my day at work. And then
So you,
didn't look at my phone, didn't look
Okay.
at anything until 10 PM when it was time for me to blow again.
so your positive test is because you ingested perfume while you were doing your test?
That's the only thing that I can think of, because I literally just sprayed, it was a new bottle of perfume, I just got off my porch, I sprayed it, I walked up my door, alarm goes off. So that's the only thing that I can think that it picked up that. I have not had a drink since December. And I mean, I have other dates that are written here, so, and I'm not even, usually I know when I miss, because it will say, you know, miss test, or, I'll get an alert to my phone. So there's been times that I've actually like realized, oh my God, I missed a test, and I'm blowing like 1 hour past my time just to make sure I get it in.
So since you get notifications to your phone, you're telling this court that on March 29th that you did not receive a message to your phone that you were positive and you had to do another test?
I did not, because my phone was in my purse. I go by my watch. Once I get to work, I'm not supposed to have my phone on.
Right, isn't your watch connected to your phone?
My watch is connected to my phone.
Do you get messages on your watch?
So I don't know how to work. I only got this watch because of the alarm. I don't know how to like read a message. I don't know how to like send a message or anything like that. I literally only use this for my alarm to go off, because I don't have my phone on me when I'm at work. So I have to make sure I have something that buzzes to remind me, hey, it's time. And I go and I blow.
Okay, so tell me about all the other missed tests that you had. You said that the ones that you were aware of. You know you test you test every 4 hours.
Right, 6 times a day.
Yeah.
So April 26th, I woke up to my 10 AM alarm, realized I missed the 6 AM alarm, like looking at it. And then it's also like sometimes I'll blow, especially if I'm sleeping. I've noticed that it doesn't take like a full blow. And I try to be mindful of that, but I'm being like woke up out of my sleep. So maybe I should have like re-blew or something. And I'm like in my sleep, you know what I mean? So I realized that, and I had called my attorney and let him know, and I actually was calling around to locations to find out where can I go? Can I go pay for a test? I found a place in Dearborn and I found a place in Romulus. It was $80 for a urine test. A blood alcohol test was $130. I don't have that kind of money right now. Like this past month and a half has been really slow for the industry. So he said, you know, don't worry about it. I will get in contact with Natalie. And, you know, so here we are. And then after like reading over, you know, like the violations, I had told my attorney, like April 14th and April 10th, I don't even have like a note saying, like telling myself, hey, I missed a test. And I am very good about like, I have a little folder, I keep notes and I write down everything.
Okay, I can appreciate that.
I don't understand, as far as like April 14th, there is not, I honestly truly believe that it's not possible that I missed, I think it was 2 tests that day, and not be aware of it. Like, I'm taking this very seriously. Like this device is my child, basically. Like per se, like there's been times that I've left my house and I'm like, oh my God, I'm turning back around. My device, you know, and I carry my work bag, my purse, so I'm going through my stuff. I mean, Your Honor, I'm taking this so seriously.
What I could say too is, you know, the difference I've seen in her, just the way her appearances alone. I mean, I don't like to be insulted, she's not bloated anymore, she's lost weight, she's not drinking, it's just from the appearance alone. When she first came to the office, you could tell she was drinking. She's not drinking anymore, she doesn't smell like alcohol, she's not bloated, she's doing what she's supposed to do. I know she's been going to counseling, she's doing both substance abuse and mental health counseling for traumas that she had earlier in her life. She's going to his team wellness you're going to, and you're seeing a psychiatrist as well, correct?
Yes.
Yeah, she's doing, I mean, if anything, she's probably got a problem with coffee, because I'm not saying she's got 2-3 cups of coffee on her. But I mean, that being said, she's doing what she's supposed to do. I mean, she's been vigilant. He said I know she sent in a letter to the court with her, you emailed that to the court, correct? Your version of what you wanted to put to here?
Yes.
She's made lifestyle changes. Unfortunately, she is a bartender. She's around the hours she works. That is some of the issue. And again, the court had good reason to put, based on the blow that she had for putting her on the 4 times a day. Six times, excuse me, every 4 hours. And she understands that. She realizes that. She takes it seriously. It's just sometimes, I think with the schedule that she works, there are going to be, unfortunately, unintentional misses. And you'll see in the letter, she acknowledges she put herself in this position. She realizes she put herself in this position. She's taking responsibility for that.
All right.
And she actually told me too, which is kind of, she was worried about if she had a drop going to testing facilities, that she would not be able to make it to her schedule. She didn't want to be in more trouble. She said, I can't just keep the breathalyzer with me. This way I know I'll always have it. I can be responsible for it.
Right, and if I recall correctly, that was one of the reasons that, and where your client works were reasons why the court did not do the tether. But, and just so you know, I'm very much aware that testing 6 times a day means it's interrupting your sleep. However, the court is also aware that there is an 8-hour period by which there would not otherwise be testing, which could leave a window of opportunity for consumption. So that's why this court has you testing 6 times a day, especially given the level of 0.323 that you had at the time of the offense. So, all right, what I'm going to do is I'm going to order 3 days jail. I'm going to suspend the jail. All right, so if there's any probation violations or otherwise, then that means that this jail is back on the table. Okay.
Go to jail.
Okay. No, that's what the suspended means. Okay, there's a tissue underneath the podium if you'd like to. You're welcome. Counsel, do you want to handle the sentencing?
Yes.
As well?
As far as.
Is your client interested in treatment court?
I
The
think
mental health treatment court, based upon some things that you've stated today?
that I didn't have an opportunity to go over the full scale of what the treatment court would be. I know she is going through she's going to, like I said, team wellness. She does treatment with a psychiatrist for certain things that happened earlier in her life and bouts of depression, which again is in the report. I did not discuss that with her though, to be honest with you. I don't know if the court, if you want me to do that, I could do it. I have another court I have to be in. I could do it at another time if the court wants to do it that way.
Well, what we could do is we could adjourn the sentencing out, so then you can chat with your client about that, and she can even speak with our coordinator to see if it's something that she's interested in as well. If you like.
What exactly is it that you're?
It's mental health treatment court.
Yes, so it would address some of the issues that have contributed to your alcohol consumption. And that's a very, very, very brief overview of it, but that's what it is.
I mean, I believe that, may I speak? I believe that that's what I'm currently doing. Like I am seeing a psychiatrist at Pure Psychiatry, and then I'm at Team Wellness.
Yes.
Therapy, so.
Yes, that could continue, and then there's also some additional support and treatment that you could benefit from as well. So if you'd like to just get that information, we can just set this for another date then.
Okay.
Okay. So you're gonna go over to probation, and then you're going to potentially speak to Courtney. If not, you'll get a date to speak to Courtney if you're interested in that, and then we'll get a new date. Okay?
Thank you so much, Your Honor.
All right, thank you. Have a good day. Thank you. Okay. Let's go on the record in the matter of Raul Garcia, 251037.
Good afternoon, Your Honor. Christopher Shemke appearing on behalf of my clients. Time we consent to the matter being heard via Zoom.
All right, and
Good
Mr.
morning.
Garcia, if you could please state your name for the record.
Raul Garcia.
Okay, so this is a probation violation that's alleged. It's alleged that Mr. Garcia was on probation for operating while intoxicated and no operator's license on person. Tampered with his tether and tested positive for alcohol April 21st. And counsel?
Your Honor, I'm going to ask to have this matter set down for an in-person hearing. He has documentation that will substantiate that he was at the urgent care. He might have some documentation supporting some medication that he on could lead to a false positive. And additionally, he has documentation that will substantiate breathalyzing every day with negative results. So, I haven't seen any. This is per my client. I've instructed him to send that to me immediately as well as to his probation officer. So I'd ask to have the matter set down for a hearing.
Okay. All right, the court will set this, you're in person June 1st, counsel. We can do that.
Okay, Judge.
Alicia will tell us the time in just one moment.
9:15.
(9:15 a.m.) All right. Sir, if you test right now, what's in your system?
Nothing, Your Honor. I've been clean ever since that first incident that I had.
Okay.
Mr. Garcia, stop talking. You just asked a question, you answered it.
Okay. All right. Very good. Thank you. And so we'll see you back on June 1st at 9:15 a.m.
Okay.
Thank
Your
you.
Honor.
Have a good day. All right. And this is a matter of Ivan Miles, 25647.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Okay. And Mr. Miles.
Yes.
Please turn your camera on, sir.
Yes, my camera's on.
Thank you. Okay, today's the date scheduled for probation violation hearing. Mr. Miles is on probation for disorderly conduct. And it's alleged that Mr. Miles failed to complete anger management, failed to report to his last appointment, failed to complete community service, and which is very unusual based upon the balance of Mr. Miles' probation. He's been making everything, and then all of a sudden, he hasn't he hadn't really missed anything, and so now, and he's been on probation since August 6th. And now he's completed, he's not completed things that he's supposed to have completed. And so, counsel?
Your Honor, I've had a dialogue with my client as to the nature of the case. He's going to admit to not attending the scheduled meeting. He has completed the anger management class, however, he has not yet provided proof, so he'll admit to that. And then he has completed the community service, but he has not provided the proof. So in this circumstance, he will admit to the violations, and we can expand with an explanation, but a hearing will not be necessary. Thank you, Judge.
Okay. All right, sir, please raise your right hand. Do you solemnly swear or affirm sorry, the other one. Sorry. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. All right. And sir, you heard the allegations, correct?
Yes.
All right. Yes, those allegations, sir, how do you plead?
Mr. Miles, you're going to be pleading guilty with an explanation that we will provide with an allocution.
Yes.
You have to say it though.
So, sir, as to those allegations, how do you plead?
Guilty with an explanation to,
Okay, and sir,
I couldn't hear that last part you just mentioned.
no, that's good. I just need to know if you're pleading guilty or not guilty.
Guilty?
Okay, and you've gone over your advice of rights for probation violation purposes with your attorney, correct?
Mr. Miles, we discussed that we could have a hearing where we could contest these violations, and we're going to waive
Yes.
that hearing because we're going to provide an explanation, correct?
Yes.
All right, and you also understand, sir, by entering into a plea that you'll be waiving some of those rights, correct?
Yes.
And you understand as well the possible penalty as a result of your plea, whether, and that the recommendation in this matter is for you to continue and complete all terms of probation, extend probation until June 6th, complete all the terms and
Yes.
conditions of probation, and pay a $50 probation violation fee. Do you understand that that's the recommendation, sir?
Yes.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or forced you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, if you can please vote your client.
Yes, you had failed to attend a scheduled probation visit on April 20th, 2026. Is that correct?
Yes, Your Honor. Yes.
All right. And then furthermore, although you've completed your anger management class, you have failed to provide proof of that completion. Is that correct?
That is correct because
I'm not asking you because wise. We will get to the explanation. I'm asking you yes or no questions.
sorry.
And then furthermore, although you've completed your 50 hours plus of community service, you have failed to provide proof. Is that correct? Yes or no?
Yes, that's
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations and indicate technical violations 1 through 3 will enter. And counsel?
Your Honor, in this circumstance, my client's apologetic. He was unable to make that probation visit, but he has been in full compliance. As the anger management, he does have some financial constraints right now. So although he's completed the class per his statement, he has to pay for the certificate, which I've encouraged him to do as soon as possible. And then furthermore, I've encouraged him to get his community service hours to Ms. Shaw as soon as possible. Seeing the recommendations are just expanding, allowing my client to comply with the terms and conditions, I'd ask they be adopted. Thank you, Judge.
All right, so, sir, because and I'd like to know this because I was going to have you submit proof of your completed items by Friday. Can you pay for what you have to pay for and get your certificate by Friday?
That's really contingent on my age loss claim settlement check being dispersed to my account. But yes, if that is the case, yes.
Okay, if it's not
Okay,
dispersed this week, will it be dispersed next week?
Yeah, I have no control over that. It should have been dispersed months ago. Could have been finished with this months ago. And dealing with the insurance company through my company.
Okay.
It's been held up.
All right, I'm going to indicate by May 30th. Okay, sir, maybe you can speak to them about how to get those, how to get that certificate released otherwise, or even if there can just be an email sent over to the court or something, sir. So we have proof of that. And, all right, so what the court's going to do then, so I understand, sir, based upon the communication I have from your probation officer, that you were in the middle of trying to remove yourself from an unhealthy situation and whatnot, and that you did have a little bit of some setback, but so that's why it took a little bit longer for you to finish what you needed to finish. But why did you miss your April meeting with Ms. Shaw?
I've been out of town. My dad's father, my grandfather, I had a birthday the 15th, and I've been out of the town ever since.
Okay, where's out of town?
I am in Silver Spring, Maryland.
Do you have permission to travel to Maryland, sir?
Believe so. I didn't speak with the probation officer,
You did or did not?
but I did not.
So then where would you believe that you have permission to be in Maryland from?
I guess I didn't think I was gonna have to make that.
Sir, one of your conditions of probation is you're not to leave the state without consent of the court. And so how long have you been in Maryland, sir? Is that where you're currently at? What's that?
That's where I'm currently at.
And how long have you been there,
Right.
sir?
Since the 14th, 13th. I'd like to mention that the wage loss could have continued as it has. So where else would I be without income?
Well, sir, I'm not suggesting that you live on the street or something, but you are required to communicate and request permission to leave the state while you're on probation with court supervision.
Failed to do that.
Okay. So, sir, what I'm going to do is I'm going to adopt the recommendation. I'm going to order your probation under advisement status to continue. We're extending this to June 6th. You'll submit proof of your anger management and community service completion by May 30th. And then make sure you're making your next appointment with Ms. Shaw. Okay? And please send her something in writing requesting your temporary relocation to Maryland. Okay?
Yes. Well,
Thank you. Have a good day.
Thank you. I appreciate you, Judge.
All right, thank you. Have a good day, sir. And then we're on
Thank
the
you. I
record
appreciate
in the
you,
matter
Christopher.
of Miguel Velasquez, 251542.
Good afternoon, Your Honor. Christopher Shemke appearing on behalf of Mr. Velasquez.
Mr. Velasquez? Oh, he was on here. I'm not sure where he's at. So we'll have to recall this. Okay. All right. Because I have two civil matter. I have a small claims appeal and then another here, a summary proceedings matter. And then we can do the in custodies.
Okay, Judge.
All right. So. Oh, there's Mr. Velasquez. Okay, so a recall
Sorry,
matter.
it kicked me out, and the code I
Okay.
got earlier
Okay.
wasn't the right one.
Okay, sir, just a moment. Okay.
Sorry.
Court's going to recall the matter of Miguel Velasquez, 251542. And counsel?
Good afternoon, Your Honor. Christopher Shemke appearing on behalf of my clients. Time we consent to the matter being heard via Zoom.
All right, sir, your name for the record, please.
Miguel Velasquez.
Okay. Today's the date scheduled for the probation violation. Your client is on probation for assault and battery. And your client was sentenced on March 19th. And it's alleged that your client tested positive for marijuana April 3rd and April 28th. And counsel?
Yes, Your Honor. I've had an opportunity to have a dialogue with my client. He will not be seeking a violation hearing. He's prepared to admit the violation. I've gone through his rights, and we are prepared to proceed.
All right, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to those allegations, sir, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights with your attorney for probation violation purposes, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
You also understand the possible penalty as a result of your plea, correct?
Yes, Your Honor.
Knowing, and you understand the recommendations for you to continue and complete all terms of probation, continue your under advisement status, $50 probation violation fee, attend outpatient treatment, revoke your under advisement status for any future violation, 10 days jail suspended. Do you understand that's the recommendation, sir?
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Also, if you can please guard your client.
I'd like to direct your attention to April 3rd and April 28th of 2026. Did you take a test that indicated use of marijuana in your system, which would violate the terms and conditions of your probation?
Yes, sir.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations, indicate technical violations 1 and 2 will enter. And counsel, your as to the recommendation.
Your Honor, I believe the recommendations are appropriate. My client does have a medical marijuana card. I have submitted that to Ms. Shaw. He's needs to get a valid document from his prescribed physician to indicate his necessity for it for chronic back pain. He has yet to establish that, but I've encouraged him to do so. And in the meantime, until the court has granted him permission, should they decide to, I've strongly advised him to not consume or utilize marijuana in any shape or form. Thank you, Judge.
Okay. And so, sir, when did you submit your medical, your request for marijuana for medical purposes?
So here's the little mix up because I was supposed to see my probation officer on this date, and I was kind of waiting to see her to talk to her, and it fell into today's meeting with you. So I was planning on showing it to her when I met her on Zoom today.
Okay, sir, that wasn't my question. When did you? Okay, let me ask you a different question then. When did you obtain your medical marijuana card?
I believe it came in the mail 3 days after sentencing.
Okay. Well, and who prescribed that for you, sir?
There is a medical facility in Allen Park, I believe on Allen Road, but I talked to my primary care physician that she suggested I go get evaluated for a medical card.
Okay, then you'll have to have a communication from your treating physician. You don't even have to get your medical marijuana card for the court purposes, as long as we have something from your treating physician. So at this point, from what I've heard, I'm not likely to approve it, sir, because you stated on your pre-sentence report or interview, no serious illnesses, diagnoses, or accidents in the past, not currently under a primary doctor's care. So based upon all that and the fact that you were already using marijuana daily, the court is not, and that you did not have a valid medical marijuana card, the court's not inclined to grant that at this point without having something from your treating physician, sir.
Okay, I have a question. I submitted a paperwork that it was her in writing suggesting I go see for a medical card. Is that what you're looking for?
Sir, you can communicate with probation with exactly what the court's looking for as far as, it might just be easier just to have something. So there's a list of things like 4 or 5 pieces of information that should be included in that, okay?
Okay.
All right. In the meantime, the court, what if you were to test right now, sir, what's in your system?
Just the remaining marijuana.
When's the last time you used it, sir?
Yesterday before I talked to my attorney.
So it wouldn't be the remaining marijuana, it'd be new use marijuana, sir.
Correct. but I stopped smoking after I got off the phone with
Well, good. Good. I'm not sure why you couldn't, follow the orders of a court. In any event, the court's going to order, continue and complete all terms of probation, continue your under advisement status. You're not, you are to pay a $50 probation violation fee. You are to enroll and attend outpatient treatment. The court's going to revoke your under advisement for future violations and 10 days jail suspended. You're going to email, into Ms. Shaw as to when you need to, meet with her next, okay?
Okay, thank you.
All right. Have a good day, sir.
You too, bye.
Thank you, Judge.
Let's go off the record for a moment. David Patrick Bradley Jr., 201272.
Ready, Your Honor, Neil Blair on behalf of David Bradley. Sorry, that's what I have. Yep. Sure, can you say your name?
David Patrick Bradley Jr.
Okay, Mr. Bradley Jr., yes. All right, today's the date scheduled for the show cause in this matter, counsel.
Yes, Your Honor.
Well, it's actually, it wasn't scheduled. It's on the docket now because your client had a warrant out for his arrest because he failed to appear for the show cause, where it shows that he has an unpaid balance of $4,210. And, counsel?
Yes, Your Honor, I did review the file. Briefly, the thick file originally started out apparently as a felony case. Without going back through day one history, it appears that current problem is it never paid fines and costs, and there's a balance of $4,200.
Correct.
That he admits, so he's prepared to plead guilty to that. He admits that he did not make those payments.
Okay, sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay, and sir, you heard the allegations as to the show cause, correct?
Yes, Your Honor.
And as to those allegations in the show cause, sir, how do you plead?
Guilty.
And you understand your rights with the show cause here, and you've gone over that with your attorney, correct?
Yes, Your Honor.
And you understand by entering into a plea, you'll be waiving some of those rights.
Yes, Your Honor.
And you also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, counsel, if you can please bring your client.
Yes, I will. Mr. Bradley, do you recall pleading guilty or being convicted of a crime in this court?
Yes, Your Honor.
And
No, you don't want to give your attorney a demotion.
thank you.
Oh, yes. Yes, sir.
And you were placed on probation as part of your sentence in that matter, correct?
Yes, sir.
And part of that probation included the requirement that you pay some fines and costs, is that correct?
Yes, sir.
And do you admit that you did not successfully complete payment of those fines and costs, and that you still owe a pretty significant sum of money to the court?
I didn't hear you, sir.
Then do you admit that you owe $4,210 to this court?
Well, let me clarify. I just received confirmation that the amount is actually $8,540.
Wow. All right. Apparently the amount that is due and payable is now, the judge indicated, a little bit above $8,000. Do you acknowledge that?
Yes, sir.
Your Honor, Tiff,
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea with show cause. So counsel, let me just clarify the, from the 2020 case.
Yeah.
When I assessed fines and costs, I'm just looking, just so that we're all aware on the same page. The fine that was assessed was $1,000. This is for break and entering a vehicle to steal property less than 200, malicious destruction of personal property 200 to 1,000. Restitution of $700, crime victim fee and state assessment fee of $150, supervision fee of $4,500. because it was 24 months and there were two different charges, it looks like. $100 for other costs and then another assessment of $100. So that total at that point was $6,555. So what that appears to be is what the additional charge cost counsel, I believe, are late fees and potential interest or warrant fees is what that appears to be. But the original amount due is $6,550. So there's that. Okay, so Mr. Bradley, why have you continued to blow off the court over the last 6 years and not make any payments?
That's not what I'm trying to do. I'm trying to get back on my social security because every time I keep getting incarcerated, they keep cutting me off. Right now, I'm in the process of getting it back. I'm waiting on the a big back check right now. It should be coming in
just a moment.
19.
Just a moment. So counsel, because there were two counts, one was $4,210 and then the other one was $4,330. So just so that there's, you're clear on that. Well, sir, here's an idea. How about you stop getting incarcerated? How about you take care of your matters and stop violating the law? Then you won't have to worry about that. That would be one start, don't you think?
Yes, ma'am.
Yeah. So what are you doing for work then, sir? What's the nature of your disability that you have to have Social Security?
Because I can't work.
Why can't you work?
I'm mentally disabled.
Sir, there are many, many, many individuals that are mentally disabled or have mental health issues that work. So what specifically about you is going on with yours that prevents you from working, sir?
It just, my brain thinks of other things when I'm working and stuff, and it just stops me from working. But I just want to get this over with. Like, you gave me a chance last time, and if it's just money, I can pay a little bit, here and there.
How do you support yourself, sir?
My dad helps me out here and there.
Well, sir, here's the thing, right? Your brain may think of other things when you're at work, right? So you have a hard time focusing. There are ways to work on that. There are ways, see a doctor about that, right? But not working and using that as a reason to not work, sir, is not working very well for you, it appears.
I do see a doctor every month. I see Southwest Counseling Solutions Mental Health.
Okay.
I get Adderall and Doxepin.
Okay. And so you can't work with the medications? When you take the medications, you still can't work, sir?
It wears off. I told him it wears off between 10 o'clock in the afternoon, but he doesn't want to up my medication because it's a class 1 controlled substance.
Correct. There are other things, just so you're aware, sir, there are other things that you can do to help yourself other than just medication. But then if it wears off between 10 and 2, maybe get a part-time job that you work in the morning until 10 o'clock. At least that's something.
You're right.
But you have to start doing for yourself instead of relying on everybody else to do things for you and help you while you continue to get in trouble. Why were you in the Wayne County Jail before Wyandotte PD went to pick you up?
I had a possession of less than 25 gram charge. I got time served in there.
Hold on, sir. Possession of what?
A cocaine.
Oh, I'm sure that's helpful for you, sir. You're just compounding your problem, sir.
Oh, it wasn't mine, but I did plead guilty. It was on me, so it was mine. So, I'm not gonna sit here and make excuses for it.
And when were you arrested on that charge, sir?
April 26th.
Out of what jurisdiction?
Southgate.
All right. I don't know. Well, let's see. Here's what I'm going to do, sir. I'm going to set you up on a monthly payment plan and I'm going to order you to get a job.
Yes, ma'am.
So I'm going to indicate $25 per month on each count for a total of $50 per month. Your first payment is going to be due July 1st. You're to submit 30 job applications per week.
Yes, ma'am.
And attend interviews if they call you in for interviews. You're to submit a list, sir, of everywhere you've applied and how you've applied and when you applied.
Yes, ma'am.
You're to submit that by Friday afternoons. By
Yes,
Friday
ma'am.
afternoon each week. Your failure to do so, sir, will result in another show cause whereby that could lead to incarceration again.
Yes, ma'am.
You have somebody, you have a victim in this matter that is still out $700. It's been 6 years.
Okay.
That's a little bit selfish of you, sir, in not making sure that that restitution at the very least was paid.
Yes, ma'am.
Okay, so, sir, upon your release, so upon your release, sir, you have to stop at the window so you can get the email information for the court.
Yes, ma'am.
Now, since today is Wednesday and you won't be able to really submit 30 job applications between now and Friday, you need to submit at least 10 by Friday. Got it?
Yes, ma'am.
Okay, have a good day.
Thank you.
Thank you. Okay, let's see here, we go. Let's go off the record, yes.
Since he's in custody, I have to executive.
Well, yeah, but wouldn't it be a judgment of sentence on the show cause?
No, we always did like a bit. That was what we did on city, normally did, like a personal bond. So that they can get released.
Okay,
Do you want me to do like a judgment?
yes, because it's a judgment of sentence on the show cause. That's why I didn't set that, because that's what I thought it was, but if I need to do it that way, I can.
Okay, no, that's fine, we can do it that way and see how it works.
Yeah, I mean, if it doesn't work that way, I can do it the other way. I was just explaining to you why I didn't set it on, that's why I thought. You just tell me when you're ready on the next ones. What's that?
Okay.
Oh, okay. Let's go on the record in the matter of the city of Wyandotte versus Jonathan Windell's 26542.
Good morning, Judge. Attorney Corey Westmoreland, very on behalf of Mr. Wendell's. Mr. Wendell's, would you please state your full name for the record? Jonathan Wendell.
All right, good morning. And today is the date scheduled for the arraignment and pretrial in this matter. And counsel, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive formal reading. My client stands mute.
The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, and then ask to the pretrial.
Yes, Your Honor. Signed to the account is the original IBAC to one count of operating with legal affairs.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and you heard the plea that was placed on the record, correct? Are you picking him up, Allie? Please repeat it again.
Yes.
As to the amended charge of I-41 visibly impaired, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand, sir, the possible penalty as a result of your plea,
Yes, ma'am.
whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all that, do you want to continue with your plea?
No, ma'am.
You don't want to continue with your plea?
So actually, we offered.
Oh, yes.
Okay, so knowing all of that, sir, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No,
And any immigration issues?
no.
Counsel, if you can please refer to your client.
Mr. Windows, were you operating a motor vehicle in the city of Wyandotte on April 26th of this year?
Yes, I was.
Prior to operating that motor vehicle, can you consume the alcohol?
Yes.
What did you consume, approximately how much?
I had 4 good boys and 2 red tea shots.
And did that impair your ability to operate that motor vehicle?
Yes.
Is that yes?
Yes.
Your Honor, you'll stipulate, I believe it was a .179 and a .184.
Yes. Did you say red teas?
Yeah.
What are red teas? Is that an alcoholic drink?
Yeah.
Yes? Okay. All right, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement, and as to bond counsel.
I would just ask that bond be continued. Mr. Windows did post a $500 cash bond. He has no prior criminal history whatsoever. He's not on probation or parole out of any other court, and has no other pending matters at this time.
All right, and sir, where is it you work?
RBC in the volume.
All right. Compare to us right now, sir, what is in your system?
Nothing.
The court's going to order your cash bond to continue. You're not to possess or consume any alcohol or drugs unless prescribed. And then you're going to have a seat in probation. You're going to get a copy of your bond conditions and all of your next steps. Okay?
Thank you.
You're welcome. Have a good day. The city of Wyandotte versus Nathaniel Hayes, 26530. Wait, this is in custody Wyandotte? No, Mr. Hayes is not.
It's up to you.
Your Honor, good morning. Richard T. Serrano, P33828. Today, Your Honor, I am here on behalf and with my client, appears to my right. And this is the date time set for his arraignment pretrial. Sir, please state your name for the record.
Nathaniel Hayes.
All right, good morning. And counsel, you're correct. Today's date scheduled for the arraignment pretrial, and as to the arraignment.
As to arraignment, Your Honor, I then have to speak to my client to advise him the ball is constant. He has signed a form regarding that. He understands them. And Your Honor, I've explained to him the nature of the charges, all maximum penalties involved, be it from this court or any administrative agency such as the Secretary of State. He also understands that. And at this time, he's prepared to go forward with the plea or the pretrial.
All right, sir, I'm going to have you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, and you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone over your advice to rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency. Is that correct?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please refer to your client.
Thank you, Your Honor. Mr. Hayes, on or about April 21st, 2026, in the evening, approximately 9:53 p.m., were you operating a motor vehicle in the city of Wyandotte?
Yes.
On or about that time, did you have contact with the Wyandotte police?
Yes.
And the police gave you several field sobriety tests on the road and the like. Is that correct?
Yes.
They thought you had been drinking. Had you been drinking before operating a motor vehicle?
Yes.
Tell the court what you drank and approximately how much over what period?
About 3 to 4 Coors Lights in a matter of 10 minutes, cleaning out trucks after work, after a 14.5-hour shift with no food.
You had not eaten, correct?
No, sir.
And those are alcoholic beverages, is that correct?
Yes, sir.
We're non-alcoholic beer, is that correct?
Correct.
I use that term loosely. There's no such thing as non-alcoholic beer, but you were drinking the real 12-ounce beer cans, correct?
Yes, sir.
All right, and did you believe that your ability to operate the motor vehicle was impaired by the consumption of that alcohol, and that the officer said that you were speeding is the reason they stopped you, right?
Yes, sir.
You agree that you don't drive that way normally. Alcohol had a factor in your speed. Is that correct?
Yes, sir.
Subsequently, you were arrested, taken to the police station, correct?
Yes, sir.
And you went for a breathalyzer test there, didn't you? No. Is that yes?
Yes.
And the results came out 0.102 and 0.719. You agree with those results?
Yes, sir.
You agree that those are above the legal limit of 0.08?
Yes, sir.
Alcohol limit.
I'm sorry, he was answering while you were speaking still.
Sorry. You believe that those results were over the 0.08 threshold of being alleged drunk driving, correct?
Yes, sir.
I'm satisfied.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And counsel, as to bond, please.
Your Honor, my client did post a $500 cash bond. He tells me that he is on probation in the 33rd District Court to extend his probation for Judge McNally. It was for not another charge, but it was non-alcohol or drug related. So he does have that as the only thing he has. Nothing else pending, Your Honor. We'd hope the court would allow his bond to continue, and I'm sure there's going to be some conditions for my client, which he will abide by.
All right, and sir, what are some of your conditions for probation out of the 33rd District Court?
All done. I was supposed to get off. Judge McNally wanted to see what you're gonna do. To be honest, he was a little disappointed. I finished everything in my probation.
Right, well, sir.
I'm disappointed in myself too, Your Honor. It was a mistake. Shouldn't have happened.
Okay, have you ever failed to appear in court for any reason?
No, ma'am.
All right, and other than that matter, do you have any other pending matters?
No, ma'am.
All right, the court's going to continue your cash bond. If you were to test right now, what is in your system?
A little bit of THC maybe.
Do you have a prescription for that?
No, it's legal.
I'm aware it's legal, sir, but not for you because you're here in court now on an alcohol-related offense. So no alcohol or drugs unless prescribed. All right, when's the last time you used the THC?
That's good.
Okay, so you're not currently under the influence?
No.
Okay, very good. All right, so the court, as I've just indicated, you're not possessed or consuming alcohol or drugs unless prescribed. You're gonna go over to probation, and then you will have all of your next steps. Okay, sir, and you'll get a copy of your bond conditions as well.
Thank you, Your Honor.
All right, good luck to you, sir. City of Wyandotte versus Robert West Jr., 26560A and B.
Your Honor, good morning, Richard T. Serrano, P. 828. Today, Your Honor, I appear as LNC counsel on behalf and with my client, who's presently in the Wayne County Jail. Sir, please state your name for the record, only.
Robert Orwell West Jr.
Okay, good morning. Today is the date, counsel, as you've indicated, for the pretrial. And you had an opportunity to meet with the prosecuting attorney.
That's correct, Your Honor. I will start with the older case, February 11th, 2026. That's okay.
Oh, I'm sorry.
There are two.
Yes, there. So 26181 is the other matter. So this is the one that we're starting with, okay?
Correct.
I only have one sheet, that's why I'm missing here.
Both plea forms are in files, Your Honor.
I'm only seeing one plea forms in the 560. Let me see if I got put it in a different spot. Nope, I don't have it for the 181 council.
Oh.
I don't have that one. Do you have it in your?
No, do you mind if I go look in the prosecutor's office real quick, Your Honor? I'm sure that I put one in each spot.
Well, hold on. I'm sorry. I got split. Here it is. I got in between the outside and the inside there. Okay.
So,
All right, I have it. Yes. Okay.
which would you like first, Your Honor?
Whichever one you want to start with, council.
Okay, February 11th, 2026, the
Okay.
one matter.
That's fine.
Your Honor, my client has been advised of all of his rights. He is willing to plead guilty to the plea bargain that the prosecutors offered, who will plead 1 count of possession of controlled substance. That's in fact accepted. The other charge of the paraphernalia would be dismissed on the prosecutor's motion.
All right. And then counsel, if you'd like to place the plea on the other case on the record, we can do those at this. I can voir dire them at the same time.
Yes, thank you. Your Honor, my client was to avail himself of the offer made on the more recent case, April 30th, 2026. He will plead guilty to the driving while license suspended as charged. That in fact was accepted by the court. The other charge of possession of drug paraphernalia would be dismissed on the prosecutor's motion. He's been advised of his rights. Will waive the court's examination.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
All right. You heard the plea that was placed on the record, correct?
Yes, ma'am.
As to the charge from February 11th of possession of controlled substance, how do you plead?
Guilty.
And as to the charge of driving while license suspended from offense date of April 30th, how do you plead?
I plead guilty, ma'am.
You've gone over your advice of rights with your attorney, correct?
Yes.
There is a fire emergency in the building. You are to leave the building.
And you also understand, sir, by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am.
And you understand as well, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way?
No, ma'am.
Any immigration issues?
No.
All right, counsel, if you can please vote to your client.
Mr. West, can you hear me?
Yes, ma'am. Or yes, sir.
All right. Let's start with the older case. On or about February 11th, 2026. On that date, approximately time, did you were you in a motor vehicle in the city of Wyandotte?
Yes, I was.
You were the passenger, correct?
Yes, sir.
And the driver was a Ms. McCollum, is that right?
Yes.
All right. There came a time where the police officers questioned you regarding you, and then subsequently you were seated in the front seat passenger seat. Is that correct?
Yes, sir.
And upon the officers' search of the vehicle, they discovered some what turned out to be narcotics at your foot with some paraphernalia. Is that correct?
Yes. Yes, sir.
You were in possession of that. You did not have a prescription for what they found. Is that correct?
No, ma'am. Or no, sir.
I'm satisfied as to that, Your Honor.
No, it's not correct. No, you didn't have a prescription.
No, I didn't have a prescription.
Okay. And the court does accept the plea as knowing, voluntary, and factually accurate as it relates to that matter.
Mr. West, I'm asking you now about the other case, about April 30th, 2026, approximately 4:30 p.m. Were you operating a motor vehicle in the city of Wyandotte?
Yes, I was.
The police stopped you, right?
Yes, they did.
Upon the officer asking you to produce a valid Michigan operator's license, were you able to do that for the officer?
No, sir, they were suspended.
Then you agreed to suspend on that date and time you were driving, correct?
Yes.
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to count B, dismiss count A per the plea agreement. And counsel, you're asking for immediate sentencing?
Yes, the court pleases, Your Honor, just briefly to allocate on my client's behalf. Your Honor, he does not have a valid license. He's aware of that. I told him that he's not going to get it back until he stops driving. He's aware of that. He lost his job at Burger King because he's been incarcerated for He said in one case, 2 weeks, then another case, total of 3 weeks. He lost his job, but he does have a job waiting at Austin Construction for him when he's released. He was unable to post the court's bond, so he's been in custody continuously. We'd ask for the court to consider time served and or a small fine, but he will need time to pay those fines now that he's getting back to work. He does live with his father and has no other source of income other than what was taken away from him by virtue of losing his Burger King job. So with that, we'll leave the sentencing in the court's discretion.
Okay, so let me clarify a few things. Mr. West was ordered to be in this court February 25th of 26 for a pretrial. He failed to appear. The court issued a warrant March 3rd. May 1st, your client was in custody at Wyandotte PD, presumably because of the offense date of April 30th, where he was arrested because he was driving without a valid license and for the possession of drug paraphernalia. So had your client taken care of this matter to begin with, he likely would not have been incarcerated, whereby losing his job at Burger King. Further, the court will note that this court, counsel, just so you're aware, ordered personal bonds on each of these matters and ordered your client to be tethered to treatment through the Wayne County Jail as one of his conditions.
They never tethered me, ma'am.
I'm sorry?
They never tethered me.
Do you
I
have?
was looking forward to the treatment, honestly.
Hold on, sir. Hold on just a moment. Do you have any other pending matters?
No.
Not on probation or parole.
Well, that's interesting. Why you weren't tethered to treatment?
The Wayne County Jail says that I have a cash surety bond, that they're saying from Wyandotte, I have a cash surety bond and not a personal.
No, sir. What I did is I reinstated your bond and we made a note on the second page, bond already posted on this case. Thank you. So perhaps somebody didn't read the full document because I reinstated your bond if it wasn't forfeited yet. And so it appears though it was not forfeited. And on the second page, we made a statement, we wrote on here, bond already posted, which meant they did not have to wait for a bond to be posted. That is why I ordered personal bonds on the other matters so you could be tethered to treatment.
Yeah, I was looking forward to that too, ma'am.
Well, good. We're going to ensure that that happens. The court's going to find that after review of the criminal history and the matters before the court finds that there's not reasonable grounds to depart from MCL 769.5. The court's going to order 60 days jail, credit or to be tethered to Wayne County Jail, to treatment through Wayne County Jail.
Your Honor, since it doesn't sound like it was my client's fault why he was not tethered, could the court perhaps be lenient on the fines?
I was actually going to waive the fines.
Thank you.
Go back to right here. You want to talk this?
All right, so I'm going to also indicate that these are concurrent.
Where did you want to say?
Here.
So I have 60 days of due jail time, ma'am?
Well, 60 days less 14. I'm pretty sure that's 46.
46 days?
But you'll be tethered to the treatment.
Okay, so the jail time will be served in treatment?
Yes, sir.
Okay, thank you very much.
You're welcome.
Your Honor, the fines waived, that's to both matters?
Yes.
Thank you.
All right, good luck to you, sir.
Thank you,
Thank you
Your Honor.
very much.
I'll zoom on with the other in custody now. Your Honor.
Okay, I think you have another,
Oh, yes, I can do
let me
this.
see here. Okay, there's that. Yeah. All right, we're on the record in the matter of the city of Wyandotte versus Anthony Vega, 26505.
Your Honor, good morning, Richard E. Toronto, P338. We had with my client is approaching. State tax at first. State your name, sir. Anthony Vega.
All right, good morning, and please remove your hands from your pocket, sir. All right. I know we have a band of brothers today.
Yes.
All right, and so council, today's the date scheduled for pretrial in this matter.
Yes, Your Honor, the court may recall that I did, in fact, arraign all three of the co-defendant brothers. And they all equally said that they had no objection at that time to those arraignments. And now I've ended up with Mr. Anthony Vega only as his appointed counsel. And you have no objection to that. Is that correct, sir? Yes, sir. All right. And Your Honor, may I proceed with the resolution?
You may.
Your Honor, after retrying the matter and with the prosecutor and my client wished to avail himself of the offer, he will plead guilty to the amended charge of disorderly conduct. I'll explain to them what that entails. He understands the charges, all maximum penalties involved, and also the client invites the rights partner. In fact, understanding waiving those rights by entering into this plea freely and voluntarily. He will plead guilty to the amended charge of disorderly conduct pursuant to HIDA, Homes with Trainee Act. I told him what that entails. I believe he qualifies, and we're ready for the court's examination.
All right, sir, if you can please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, nothing but the truth? Okay, sir, in the Wayne County Jail, you can keep yours down. I'm not addressing you right now. So thank you very much for paying attention though. And sir, you did hear the plea that was placed on the record, correct?
Way up, okay?
As to the amended charge of disorderly conduct, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand the possible, that by entering into a plea, you'll be waiving some of those rights.
Yes, ma'am.
You understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency. You also understand what the HIDA status is, correct?
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, sir.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea? All right, thank you. And counsel, if you can please read to your client.
Yes, thank you. Mr. Vega, on or about April 18th, 2026, how old were you on that date and time? And you were out with your brothers, correct? Yes, sir. There came a time where you tried to get back to your apartment, but the police had told you to stop for some reasons, correct? And so you continued to go into the apartment disregarding their commands, is that correct? That's correct. And while in there, they became kind of disruptive amongst the good peace and order of the neighborhood, correct? Got a little loud, police were shouting, you groups were talking back and the like, is that correct, sir? And I've satisfied Your Honor with the disorderliness.
All right, the court has also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement, and determine your eligibility under HIDA at sentencing. Sir, have you relocated with your brother?
Yes, ma'am.
Okay, so did you continue that new address?
I did not. He is addressed in Waterford, Your Honor.
Okay, so he will have to make sure he's changing his address with probation.
All right.
If you were to test right now, sir, what's in your system?
We.
Okay, when's the last time you used it, sir?
Today.
Today? Okay, sir. I don't believe, if I recall, that you have a prescription for marijuana. No. So then tell me, sir, why are you violating this court's order and using marijuana just because you feel like it? Just before you answer, I don't know is not an acceptable answer in this court.
Were you nervous about coming to court, sir? You thought that might help? Yes, sir. You're not still under the effects of marijuana, are you? No, sir.
Well, when did you use it, sir?
I would. 8.
8 a.m. And so you're not currently under the effects of marijuana. Tell me how that works. You only used it 2.5 hours ago, and you're still not under the effects of marijuana.
Just for the record, Your Honor, I had no problem communicating with them.
I understand. But just as though we have to make sure somebody's not still legally intoxicated, I need to make sure that this individual that doesn't want to follow the court's orders is not currently under the influence of a substance, which I would think, I mean, I don't know. I'm not a marijuana user, so I don't know how those effects work. But I would think that if you used it 2.5 hours ago, sir, you would still be under the influence of that, correct?
Yes, sir.
And if you weren't, then it would seem as though the marijuana's effect was not useful to calm your nerves about coming to court today. Would that also be correct? So it can't be both. Which is it, sir?
It'll calm me.
Right, so you're either
Yeah.
currently under the influence and you're calm, or you're not currently under the influence, and then the use of the marijuana was for nothing because now you're in front of the court here and now you're presumably not calm. So which is it?
I'm calm. I'm intoxicated.
Where does one get marijuana at 18, sir?
I bought it.
You bought it.
Where I buy it from.
So you do know, in addition to violating this court's order, sir, you're putting yourself at risk because you have no idea what that marijuana is laced with. Do you understand that?
Yes, ma'am.
And yet you choose to use it anyway.
Yes, ma'am.
Great. Okay. Well, so counsel, I can't accept the plea today because your client's under the influence, and I don't know that he's making this plea knowing, voluntary, or not.
I agree.
So, sir, you're gonna have to come back another day.
Hopefully the plea will still be on the table at that time, Your Honor. And I caution my client not to be under the influence of anything when you come to court, correct?
Sir.
Next time?
Sir, you're 18 and you're not making great choices.
I'm working on it. I got my permit, I'm getting my license, and then I have a job that's paid for me. I'll be.
That's great. You do realize, sir, if you use marijuana and then you drive,
Yes, ma'am.
that's illegal also. Even if you used it 2 weeks ago and it still shows up in your system, that could be a problem for you. Sir, I'm not going to do a bond violation hearing for you. However, I am going to order you to participate in random testing. Because when I say something is an order of this court, sir, that's meant to be followed.
Yes, ma'am.
So we're going to test today, so we have a baseline level. All right, Ally, when are we having Mr. Vega come back?
On June 10th at 9:50.
It's June 10th at 9:15 a.m. Bond and conditions are continued.
Thank you, Your Honor.
Stop at probation, sir. You're going to get set up with your testing information.
Thank you.
You're welcome. That's your one opportunity, sir.
Your Honor, I'll go to the video now.
Yes. Okay, is Mr. Goldhawk, and that one you don't have to be, he's out of custody, Australia, right?
What?
Mr. Vega's out of custody, right? He's in the back. Yes. Okay, so, let me say that one first. Do we have any attorneys? Do we have any attorneys? Oh, Mr. Gold, happy birthday, isn't today your birthday?
Yes, thank you. All right.
And you chose to spend it with us. That's great. Looks like the birthday present that keeps on giving away.
Nothing from Elliot's? Elliot, was it in for her birthday cake?
On Zoom right now.
Yeah, she's not here. She hasn't checked in.
What's that? Yes, I do have one for you here, ready to go.
Okay, I'm looking for you.
What's that?
So, I guess I'm very good. Another one.
No. I want to do this one now, and then that's how we're doing it. That way people can get out of here. Continue on with what they have to do. All right, which matter are you here on, Mr. Homer?
I have a marriage, she's actually here.
Is in county.
Oh, 11:30. Oh, so you weren't running late. You had plenty of time to stop.
Let's go try to.
Okay.
Judge May,
What's that?
2 people in custody on
Solar.
Zoom. I could talk to them now, but I've got 2 people in the courtroom. Which would you prefer? You
Well,
want me to take the guys?
I can, who do you have ready to go in court here? Who?
Friend, Mr. Rodriguez is back. We're ready with him. And we also have Mr. Tyler Morgan.
Okay, so, well, I can handle Mr. Goldpaws and Mr. Holmberg while you talk to those other 2, and then we can handle the.
Okay, I'll go zoom in on these 2.
That might be.
Charles Thomas.
The other one's
Thank you, Judge.
Kohler.
Okay, it's not Parsons.
No,
Talk to
I
Tom.
don't think it is. It looks like Kohler. It might be.
Okay, Wayne County Jail, Mr. Kohler, can you please, raise your hand? Okay,
Kohler.
Kohler's in the B. And then, is that Mr. Steiner? No, Mr. Parsons.
Yeah, I just.
Kenneth? Thomas, Charles Thomas. Can you raise your right hand if you're Charles Thomas? Thank you. There we go.
Yeah, Alex. I go zoom in on my phone to see if I can pronounce.
Oh, yeah, thanks. Good to you.
All right, so let's go on the record in the matter of the City of Wyandotte versus Richard Vega, 26504 A and B. And, counsel?
Morning, Your Honor. Your Honor, for the record, John Goldpaw, 758 on behalf of Mr. Vega, please put your name on the record.
John Vega Jr.
All right, and so, good morning. Today is the date scheduled in this matter for a pretrial, the third of the brothers today. And, counsel, as to the pretrial.
Well, Your Honor, first, I believe it's also.
No, he's been arraigned
Pretrial, I apologize.
April 20th. All 3 were in custody.
I'm sorry, Your Honor. Thank you. Your Honor, as to the pretrial, I've had an opportunity to speak with Mr. Vega as well as with the prosecuting attorney. I've also had an opportunity to review the police reports, et cetera. It's my understanding that in return for a plea to disorderly conduct to be taken under HIDA, the charge of resisting and obstructing would be dismissed. As to the no insurance, which is not under HIDA, as well as he would plead responsible to no proof of insurance. And as to the no operators on possession, he would be pleading guilty to allowing an unlicensed driver to drive.
Okay.
That will not be under HIDA as well.
Well, I don't know if this current one will be under HIDA, given your client's criminal history.
Your Honor, he is 22 years old, and HIDA is eligible.
Right, but it's court discretion as to how often it can be used. I don't have to accept it.
Your Honor, my understanding is that HIDA with even a prior, so long as within the I'm sorry, I'm trying to think of the right word. As long as it's within the particular age group, I'm not saying under 20, but with the agreement with the prosecuting attorney, is the prosecuting attorney who has to at least allow the plea to be taken.
I understand that, but the court has discretion as to whether or not it's going to accept the plea with a HIDA designation, or whether I'm going to find that your client's eligible under HIDA. And I have to tell you, counsel, absent something that tells me that I have to find your client eligible under HIDA, given his criminal history, specifically a felony fleeing and elude police officer, 4th degree, that your client pled guilty to in 2021, and now given these charges, I'm not likely to find your client eligible under HIDA.
Well, I guess, Your Honor, then that's the reason for the reduction. And if the court is not going to accept that I understand. I just want to put forth that I believe under these circumstances that HIDA would be appropriate. And that's what we discussed.
Well, I don't know if you want to, I'm just letting you and your client know now that your client likely isn't going to be eligible unless you find some type of law that tells me that I have to find him eligible under HIDA, which I don't believe exists. So I'll give you an opportunity to speak to your client.
That's okay, Your Honor. There's also, as part of that plea, is going to be to a disorderly conduct. So is that correct? You understand? You may not get HIDA because of the prior record. Yes, sir. Okay. You understand, John?
Okay. Likely not. Just so you know, it's not a may or may not, it's a likely not going to be eligible under HIDA. All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Are you picking him up, Ellie?
No.
Please be louder.
Yes, ma'am.
Perfect. Thank you. All right, and sir, you heard the plea that was placed on the record, correct?
Correct.
And as to the generous plea of an amended charge of disorderly conduct, how do you plead?
Guilty.
As to the amended charge of allowing a licensed driver to drive, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And you do understand, sir, as we've discussed on the record, or as I've informed you on the record, that HIDA, while the prosecution may have agreed to it, is discretionary by the court. Do you understand that? And that upon a review of your criminal history, I'm likely not going to find you eligible under HIDA, and this conviction will stand on your record. Do you understand that?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please forward your client.
Thank you. Mr. Vega, on April 18th of 2026, were you in the city of Wayne?
Yes.
And did there come a point in time when police officers were calling out to you and telling you to stop, and you ignored their orders and entered into a bill? Is that correct?
Yes.
And then there was some more discussions, and they got loud, and you became disorderly during this process. Is that correct?
Yes.
Defense is satisfied with respect to that. Also, Mr. Vega, on that date in question, were you operating a motor vehicle?
Yes.
And at that time, did you have a valid operator's license to operate that motor?
No.
So you were allowing yourself to drive while unlicensed. Is that correct?
Correct.
Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate, and the court will accept your plea to the amended charge of disorderly conduct, as well as to the amended charge of allowing a licensed driver to drive, and the no proof of insurance amended charge.
That's responsible. You understand that?
Yes.
Okay.
Thank you.
And sir, are you under the influence of anything this morning?
Oh, man. I've been used since I've been locked up.
Very good. And so if you were to test right now, what's in your system?
There, weed takes 30 days to get out the system. I don't know what your guys' test are, but marijuana will come up in my system, but it'll be low.
Okay. And you've had no new use since you were in
No, man.
custody? All right. And sir, where do you work?
I work at Freeman's Landscaping.
Oh, that's right. I remember the brothers all worked together as well. Perhaps you may all want to distance yourselves because you don't seem to make good choices altogether.
It was, to be honest, Your Honor, I made the decision and I told my brothers to run, so it does fall on me. And next time I'm making a smarter choice.
Well, sir, to be honest, I'm not sure how many more opportunities you think that you should have.
This is my last opportunity.
You're correct.
I plan on coming back to the court and I plan on getting locked back up.
Well, I hope you plan to come back to court on your sentencing date.
I think he meant on another matter.
On new charges?
Yes, ma'am.
That's good. So how are you going to effectuate your plan? It's great to have a plan, okay? It's good to have a plan, but how are you going to implement that plan?
I got my permit since I've been out and I will go take my driver's test this week or next week and I will have a license and I plan on staying and working, staying out of trouble and have my vehicle insured next time.
Well, that would be a good start also.
We discussed that, Your Honor.
You would think having the felony on your record for fleeing and eluding, that would have been, your probation and the conditions that from probation that you would have had that learning experience in that regard. So, bond and conditions are continued. Please have a seat in probation. Somebody will be with you shortly. Okay?
Thank you, Your Honor.
You have a good day. All right. We are on the record in the matter of the city of Wyandotte versus Andrew Barrett, 26292. Morning.
Good morning, I'm Edward Holbrook on behalf of the defendant.
Thank you. And your P number, counsel?
Sorry,
your P number?
Yeah, 62763.
All right, thank you. And sir, your name for the record, please.
Andrew Barrett.
All right, thank you for dressing appropriately for court. Today is the date scheduled for the pretrial in this matter. And counsel, in addition to it being a special day for you, you should probably mark this on the calendar because we're actually calling your case early by about 40 minutes. That doesn't usually happen around here. Okay. And so, counsel, as to the pretrial.
My client was not guilty plea, Your Honor, and virtually the amended charge about it will be impaired, making a factual basis that on March 7th, of this year, while in city Wyandotte, he operated motor vehicle while visually impaired. Is that correct, sir? Yes. Now by alcohol, correct? Yes.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. For Patterson, I have you heard the plea that was placed on the record, correct, sir?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And as to the amended charge, sir, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney and you understand all of those rights.
Yes, Your Honor.
You also understand by entering into plea, you'll be waiving some of those rights.
Yes, Your Honor.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
Counsel, do you can please pardon your client?
On March 7th of this year, you brought me a motorcycle in the city of Wyandotte?
Yes.
And was that on a public road?
Yes.
Private operated motor vehicle exception, right?
Yes.
Of an alcohol nature?
Yes.
And what was that?
4 years.
Alcohol beers?
Yes.
Okay, did that, it's operated motor vehicle after ingesting that alcohol?
Yes.
And did that, in alcohol impair your ability to operate a motor vehicle?
Yes.
You by swerving?
Yes. I swerving on the side street.
And you normally wouldn't have done that if you had not drank, correct?
No.
All right, do you stipulate to a 0.115?
Yeah, sure.
All right, the court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And sir, if you're to test right now, what is in your system?
Nothing.
All right, the court's going to order bond and conditions are continued. You're going to go over to probation, get all of your next steps, including your pre-sentence interview date and your sentencing date.
Thank you so much.
Thank you. Have a good day. All right, let's go off the record. So is that seventh one also? Are either of the prosecutors ready on the restitution hearing? Do we know?
Do you see this? It's like, I read this one the last. It seems like a cheat. Okay.
Okay, thank you.
Okay, just don't start.
Okay. Not have anything to start with yet anyway, so so we're good.
The Google Pixel on the Zoom, can you hear me?
Yes,
Hi, what's your name?
Walter Turner. Remember, I had called on the 27th.
I'm sorry, what'd you say?
I said Walter Turner. I had called last time on the 27th, so I was told today was the day I had to be.
Hold on. I'm gonna pause right there. Sir, a couple of things. Number one, remove your hat and your hood. And number two, we're having a very difficult time hearing you. So please remove your hat, sir.
I'm sorry.
Are you having a hard time hearing him also?
Yeah, but.
What is his name?
Walter Turner.
Right. Did we tell him he could appear by Zoom?
Handling it now.
What's that?
They're handling it now.
Oh, okay.
Restitution.
Sir, your meeting is supposed to be held in person, not via Zoom.
First, I didn't get a chance to, because I'm at work. When I first had a letter, it was for virtual. That's why I had called on the 27th.
Okay, we'll have to look at his file because I don't recall off the top of my head. There was permission to appear via Zoom, but I don't know if somebody else did. But in any event, I don't think his connection's great, but
I'm sorry. No, I'm saying the original time was the 27th. I had called you guys before on the 27th for court, and you guys told me that it was scheduled for the 13th, but I wasn't aware that it was for me to come inside.
yes, sir. Court is in person unless there's an exception. So did you receive an exception to appear not in person?
It was virtual court. When I got a letter, it was a virtual court. I didn't know nothing about the going into an actual courtroom.
Okay, sir, hold on. We're gonna check the file because this doesn't make sense to me, but.
That's why I had called on the 27th of April, because that was the date that it was supposed to be.
Okay, sir, just one moment. Is that Mr. Turner's file?
Tennyson.
Oh, okay. We need Mr. Turner's file because I'm not understanding.
Not the anything, it's a 17 case.
Okay, I don't know if maybe something was written in the file and not in the computer, so.
Walter turn?
Okay.
Walter?
Yes.
Oh, you have it right here? Okay, thank you. Okay, well, I'm showing that Mr. Turner posted, he was in custody February 6th of 26. Posted bond. Arraignment pretrial scheduled for May 13th.
No, on what I had, it had literally
Sir, please just one moment.
I apologize. My apologies.
I don't see anything in here indicating virtual of anything. I'm not sure where you even got virtual from, sir, because there's nothing in here showing a notice to appear virtually.
The paper that I had is when I had to call you guys on April 27th. That was the day that I had, which is the day I had called you. That's how I entered the courtroom, because on the paper that I had that it said that, but I didn't even know. I wasn't even aware I had a ticket with you guys because.
Hold on, sir. I'm not going to get into the matter from 2017. All I can tell you is that this is in person. It's in person. That way you can speak with your attorney that's here and everything else. So it's extremely difficult to do it via Zoom.
I'm confused now.
Yeah, that's not true.
I'm confused. I wish I had the paper on it so I could show.
So, sir, I don't know what you're gonna have to, where do you work, sir?
I work all the way in Novi.
All right, sir, we're gonna give you a new date. You are to be in person, not Zoom, in person.
Okay.
Okay, Ally.
June 10th at 9:15.
June 10th at 9:15, sir, in person, okay?
Okay. My apologies. I was just.
That's all right. I appreciate that you at least appeared via Zoom and not failed to appear, but in person, okay?
Okay.
Thank you. Have a good day.
Thank you.
Okay, let's go on the record in the matter of the City of Wyandotte versus Ryan Kohler, 26130.
Good morning, Your Honor. Martin Kohler on behalf of Ryan Kohler, who's appearing by Zoom from the Wayne County Jail.
All right, thank you. And Mr. Ryan Kohler.
Hi, how are you, Judge? Ryan
Good
Kohler.
morning. I'm fine, thank you. Your name for the record, please.
Ryan Kohler for the record.
Okay. And counsel?
We have reached an agreement, Speaker, Your Honor, that Ryan is going to plead guilty to the disorderly conduct, and in exchange, the other two charges will be dismissed.
Okay.
Now he's currently still in Wayne County on the The felony charge would be breach of agreement, and we'll be placing that on the record at Wayne County Court next week.
Okay, so what, I don't have case number 25706. So you have two cases up in front of us today?
There's actually three cases, Your Honor. There's retail fraud, there is also
Right.
another fraud, and the disorderly conduct.
Okay, well, I don't have the retail fraud case. I don't have the 25706 case in front of, oh no, hold on, wait. I do. It's all here. Okay, sorry.
I wouldn't want to, it's okay, Your Honor. I enjoy your program.
Okay, so, all right, so 25706 is being dismissed. All right, Mr. Ryan Kohler, please, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right. And you heard the plea that was placed on record by by your attorney?
Yes.
Okay. So counsel, I don't believe that there was, I just need the prosecutor in here so we can stipulate to the competency portion. Mr. Kuzniak, I don't know if you want to stay in here for this or if you want Catherine to come on in, on Mr. Kohler for the competency. We just need to,
I know Catherine's been more intimately involved, so.
Okay.
Pull her in, please.
Been a long process, Your Honor, and we appreciate the folks involved in this.
of course.
Can Brian put his hand down? He's holding it up.
Oh, yes, I'm so sorry. You may lower your hand, Mr. Kohler. I'm just going to refer to you as Ryan if you're okay with that.
That's fine.
Okay, perfect. Okay, and Counsel?
Good morning, Your Honor. Catherine Kuzniak, P 85417 for the people.
All right, thank you. And then as to the competency report, I know that there's not yet been any addressing of that since the competency report has been received. And so did you each have an opportunity to review that competency report from the Center for Forensic Psychiatry?
Yes, Your Honor. I had the opportunity to review the report, and it has been found that Ryan Kohler is competent to stand trial at this time. And I do stipulate to the findings of the report.
All right. So the court then is, and that's for you as well, Mr. Fuller?
Related to the other case as well, but stipulate to it as well, that's so.
All right. All right, the court will indicate that there's been a stipulation to the competency report, finding defendant competent. Ordered. All right, thank you. You're welcome. All right, then Mr. Ryan Fuller. You heard the plea that was placed on the record, correct, Ryan?
Yes.
As to the charge of disorderly conduct, how do you plead?
Guilty.
You've gone over your rights and rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
And knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right. Any immigration issues?
No.
All right. And so, counsel, if you can please report to your client.
The date of the original transgression, if you have that, Your Honor.
January 30th.
Ryan, in January 30th, 2026, were you in or the city of Wyandotte?
Yes.
And on that date, did you act as a disorderly person and have disorderly
Yeah.
conduct?
Yes.
Well, counsel, if you can establish a little bit more detail.
On that date, did you approach your neighbor
Yes.
that lived across the hall and were you, did you display anger and disruption?
Yes.
Okay. And so were you loud as well out in public, sir? Were you creating a disturbance?
Sure. Yes.
Okay. All right. The court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the disorderly conduct, dismiss the larceny per the plea agreement. And the court's already dismissed the retail fraud for the plea agreement as a global resolution. And counsel, are you asking for immediate sentencing?
Yes, Your Honor, please.
Okay. And what would you like the court to know?
Your Honor, my client has already been in jail more than 90 days. He is still in jail pending the resolution of the felony charges in Wayne County Circuit.
All right. So here's what I'm going to do. I'm going to order 90 days jail credit for 90 days. I'm going to waive fines and costs. Ryan, I don't want to have to see you back in court again.
Okay. Thank you, miss.
Well, I mean, we'll see you Thursday or another day coming up on your other matter, but and the court's going to waive the fines and costs.
Thank you, Your Honor.
Have a good day.
Bye-bye.
Good luck to you, Ryan.
Thank you.
as well. Thank you. All right, let's go on the record. Maybe we're on the record. I'll just do this one. We just need to get your attorney in here, counsel, or sir, and then we can handle your matter. Let's go on the record in the matter of the city of Wyandotte versus James Thompson, 251668.
Ready? Those Thompson coming, Your Honor. He's here. He's just in the lobby, I'm pretty sure.
Okay, there's no talking in court.
So I can go get him, Your Honor.
Excuse me, there's no talking in court. Hello?
Whoever talks, do not talk.
There's no talking in court.
We haven't said the end. He's approaching, Your Honor.
All right, thank you.
Your Honor, good morning, Richard T. Solano, P33828, appearing on behalf of my client, appears to my right. Sir, please state your name. James Thompson.
All right, sir, thank you. And thank you for dressing up appropriately for court. And today's the date scheduled in this matter for the adjourned pretrial. And counsel?
Your Honor, yes, I've had an opportunity to review the lengthy discovery. Today, I brought the thumb drive with me that I've given my client, and he's expressed a desire to also view it, so I'm going to give that to him to view it. So we're asking for adjournment. But Your Honor, I have a request in the future. Do you think it would be okay if I request 2 copies to maybe avoid this situation or copy it and send it to them?
I can't tell you how to do your discovery. I mean, I don't know if I don't
know if they would give me 2 or not.
I don't know. I'm not sure. That's the police department, so I'm not sure what they do or not do, but or you could have somehow spoken to Mr. Thompson outside of court to review it.
I did talk to him, but I think that he wants to see it, right?
I understand. I understand that. What I'm suggesting though is that he could have viewed it outside of the court today. That you could have met up with him outside the court to view it, right?
That's one way, Your Honor, yes.
Right. That would have been very helpful, as opposed to having to adjourn it again for discovery. So. Okay. We'll set this for a final pre-trial.
June 24th at 10:50.
I do, if I may, Your Honor, prosecutor was saying something about June 10th. I said that would probably be work. Is June 10th good enough that the court has that open?
Well, counsel, what we're trying to do is we're really trying to, maybe, we're trying to do is not have 80 to 100 cases on a Wednesday. So we're trying to spread it out a little bit, and we may be outside of our time standards for the court, the Supreme Court. But at the same time, we have to have this balance, right? Where we have to, be able to breathe and function during the day. So we can't continue with 80 to 100 cases every Wednesday. So we're trying to spread it out a little bit. So you may have requested 2 weeks, but you're getting 4.
All right, that's fine, Your Honor. In the future, I'll try not to delay the court in these kind of cases.
Okay, I appreciate that, counsel. Thank you. All right.
As for bond to continue then, Your Honor?
Bond and conditions are continued. If you were to test right now, sir, what is in your system?
Nothing.
Okay. All right, thank you. Have a good day. Okay,
Thank you, Your Honor.
Mr. DeBoy, let's go off the record for a moment. Okay. And Mr. Serrano, are you ready on your sentencings?
I'm ready for Mr. Candia's sentencing. In addition, I'm ready for Mr. Melfi, who was in.
Okay, let's handle Mr. Melfi because he's in Elmhurst. Right.
Can we,
Your Honor, I'm ready. I can come in there right now if you need me.
Okay, well, I'm handling Mr. Melfi and then we're going to handle Mr. Thomas.
Thank you. I'm in with the prosecutor right now. Thank you.
All right, let's go on the record in the matter of the City of Wyandotte versus Aaron Melfi, 251496.
Your Honor, good morning. Richard T. Serrano, P33. I appear with Mr. Melfi's presently treatment facility in Elmhurst. Sir, please state your name, unmute yourself. You're muted.
Aaron Donovan Melfi.
All right, very good. And good morning, sir. Today is the date scheduled in this matter for sentencing on your client's plea to possession of drug paraphernalia.
That's correct, Your Honor.
And I presume that your client, I presume prior to your client being tethered to treatment that he appeared virtually in 28th District Court for that warrant. Did you do that, sir?
Excuse me?
The warrant that you have out of the 28th District Court in Southgate, have you
all
cleared
the
that out
fines-
since you've been in custody?
All the fines were paid. I didn't know I had a virtual date for that one.
I don't know if you did. I was just asking if you've taken care of it.
He's
I don't
letting you
care
know.
all
He's
the
aware of
fines
it,
yet.
but he's not.
Okay. All right. So, counsel, as to the PSI.
Your Honor, yes, we've had an opportunity to review the pre-sentence report. The interview is factually accurate. My client's 53 years old, married. He is on a social security disability where he gets $1,700 per month for serious back concerns. He is under a primary doctor's care. He takes it, he has a 1 matter pending in Southgate, nothing else. He's not on probation or parole. He tells me this plea was to be taken pursuant to 771.1. We are asking that. I explained to my client what that entails. He's been 2 months in Elmhurst, Your Honor, clean and sober, and he told me he feels very good. And we would hope that the court would consider that in fashioning his sentencing, Your Honor. With that, we leave in the court's discretion.
All right. And sir, how are you doing while you're in treatment?
I'm very well.
All right. And your client's been in treatment since, let's see.
Couple months, Your Honor.
Well, on March 16th, I ordered your client tethered to treatment. So I don't know if he went right then or not. I'm sure there had to be some processing time. And so, sir, where are you at with your treatment?
I believe it's on the right track.
Okay.
100%. I want to go, I want to do some more meetings and, counseling, therapy. My wife's doing Al-Anon to better understand what's going on with me. And
Okay,
I'm doing good.
all right, very good.
He's taking some proactive steps, Your Honor, even with his wife now, so. Let's consider that.
Okay, so what I'm going to find, counsel, is that there's not reasonable grounds to depart from MCL 769.5. After hearing from counsel, hearing from Mr. Malfi, and reviewing the report, the recommendation. The court does find the recommendation is appropriate, and the court is going to order $90 days jail, credit for 60, I think it's 59. Continue to be tethered to treatment in the Wayne County Jail. And the court will waive the fines and costs.
Thank you very much, Your Honor.
Good luck to you, sir.
Thank you. Never mind. Thank you, Your Honor.
You're welcome. And the court's going to find your clients not eligible under 771 because there's not a probation that I'm doing.
I understand, Your Honor, thank you.
Okay. And we are on the record in the matter of the City of Wyandotte versus Charles Thomas 26541.
I had a question.
Well, here on behalf of Charles Thomas. Mr. Thomas, can you hear us? Would you state your name, sir?
Charles Thomas.
Thank you.
All right, thank you. And today is the date scheduled for the pretrial in this matter. And counsel?
Yes, Your Honor, I've had an opportunity to review this with Mr. Thomas this morning, and he is prepared to plead as charged.
All right, sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, and sir, you heard the plea that was placed on the record, correct?
I have. Yes, Your Honor.
All right, and as to the charge of disorderly conduct, how do you plead?
I plead guilty.
You've gone over your advice of rights with your attorney, correct?
Correct, Your Honor.
Understand all of those rights.
Correct.
You also understand, sir, the possible, that by entering into a plea that you'll be waiving some of those rights.
I understand.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
I understand.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And any immigration issues?
No, Your Honor.
Counsel, you can please vote to your client.
Yes, I will. Mr. Thomas, do you recall being in the city of Wyandotte on or about the 25th of April this year?
I do.
And at that time, you were in a commercial establishment, I think it was called Janet's Closet. Do you recall that?
I do.
And at that time, there was some sort of a argument, altercation between you and the employees, and they demanded that you vacate the premises. Do you recall that?
Yes.
You had maybe had a few drinks prior to that incident. Is that correct?
Correct.
Do you agree that you were acting in a disorderly fashion that day?
I agree.
Satisfied with that?
All right, the court also is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge. And counsel, you're asking for immediate sentencing?
I am, Your Honor. The calendar reflects that he's been in custody on this relatively minor offense. I think it's over 16 days. This is the court to sentence him to time served.
17 days today. All right, sir. Right, well, a year ago, you had a disorderly conduct in the 25th District Court, sir. And then December 16th of this year, you had a matter again in this court, and that was dismissed, invasion of privacy or trespass. So when are you gonna get it together, sir, and stop being disruptive in public and just mind your own business?
Your Honor, I want to say that this was a really devastating. The 26th was my son's birthday. I've also missed Mother's Day, and I plan on stopping alcohol absolutely for moving forward with my life. And this has been an extreme learning lesson for me. I want to better my life and be a father. And yes, Your Honor.
So let me understand this. Did you, were you going in there to buy some items?
No, Your Honor.
Then why'd you go in there, sir?
I'm not really sure exactly. I think I just went in there just to look around, because I had never seen that store before. But
Ma'am, are you on your phone? Ma'am, are you on your phone? Okay, those two can go have a seat outside, please. They don't know how to follow the decorum of the court. So, sir, you went in there to look around, and that then caused you to become irate and behave in the manner that you did.
Your Honor, I was under the influence of alcohol at the time. Prior to that, I had just left an antique shop. I had bought my son a birthday present, and under the influence, I decided to stop in that store, and I truly regret. But
Okay, well, good. We're going to help you in that regard. Court's going to order the court finds that there's not reasonable grounds to depart from MCL 769.5 after hearing from counsel, hearing from Mr. Thomas, and reviewing the police report and the criminal history. The court's going to order 90 days jail, credit for 17 days. The balance of your jail is to be served on an alcohol teller. That will help you with your alcohol consumption, sir.
Your Honor, I really want to get out there to see my son to give him his birthday present. I had just missed his birthday, Your Honor.
Sir, let me clarify what I stated. I ordered 90 days jail, credit for the 17 days that you've been in custody. You're going to be released for the balance of your days that I've ordered because you're going to be on an alcohol tether out in public, not consuming alcohol.
I understand. Thank you, Your Honor.
The court's going to waive the fines and costs.
Thank you.
Sir, perhaps you should just stay abstinent from alcohol, which you're going to have to be while you're on your alcohol tether. And after you're done with your alcohol tether, perhaps you want to remain abstinent so that you're not back in this situation again.
Absolutely. Yes, Your Honor. Absolutely.
All right, have a good day. Thank you. Okay.
Your Honor, one question. With the understanding that I'll be released today with an alcohol tether, is that correct?
Sir, I don't know if it'll be today or tomorrow, whenever they put the tether on you, but yes.
Okay, thank you so much, Your Honor.
You're welcome. Let's go on the record in the matter of the city of Wyandotte versus Tyler Morgan, 232232 A, B, and C. Area B.
Morgan, I feel like on behalf of Tyler Morgan, step up, station.
Morgan?
All right, today's the date scheduled for the arraignment and the pretrial in this matter. And we've been waiting for a while for Mr. Morgan, so I'm glad that you're here now, sir. And as to the arraignment,
Almost being stands mute to the charge.
all right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And as to the pretrial counsel.
Yes, I've had an opportunity to review this with the city attorney. My client is prepared to offer following pleading guilty to an added charge of, I'm sorry, it's not an added charge. Hold on a moment, Your
Possession of drug paraphernalia.
Yes, paraphernalia charge, it would be dismissal of counts B, possession of narcotics, and A2 insurance charge. He would be pleading responsible to A1, the improper plate. There is a charge C, the court will note that was defaulted some time ago. It was a civil infraction speeding ticket.
Correct. All right, sir, please raise your right hand. You solemnly swear from testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, thank you. And sir, you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the amended charge of possession of drug paraphernalia, how do you plead?
Guilty.
As to the charge of improper plate, how do you plead?
Responsible.
Oh, that'd be guilty count. That's a misdemeanor, counsel. Expired plate's a civil infraction, improper plate's the misdemeanor.
Yes, Your Honor. Yes,
Yes, Your Honor.
I'm sorry.
Okay, so guilty or not guilty?
Guilty.
Okay. And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of your rights.
Yes, Your Honor.
You also understand, sir, by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, no, no.
Any immigration issues?
No.
All right, counsel, if you can please order your client.
Yes, well, Mr. Moore, you recall being at the line about the 13th of October, 2023.
Yes.
And at that time, you had an interaction with Wyandotte police officers, is that correct?
Yes.
And at that time, during that investigation, that officer apparently determined that you had an improper plate on your car.
Yes.
And in addition to that, during that investigation, an officer alleged that the device in your possession which is commonly used for narcotics.
Yes.
I'm satisfied with that.
The court has also said, did you already do the improper plate as well?
You did. So
Yes, that's what I thought. Okay. All right, the court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge of possession of drug paraphernalia and the charge of improper plate, dismiss the original charge of no insurance and possession of narcotics per the plea agreement. And counsel, you're asking for immediate sentencing?
Yes, Your Honor, I think there's a good story here that the court will appreciate. Mr. Morgan is a graduate of a rehabilitation program, an intensive rehabilitation program since this incident. And he tells me that he was 3 months inpatient of a program called QBH in Detroit. Then there was 9 months of transitional housing after that. And as a result of that, he's been able to maintain his sobriety. Is all that true, sir?
Yes.
Think that you would like to say to the judge?
Sorry that it took so long for me to get here. I'm here now. After the incident that happened, I made sure that I went to rehab and all the course of getting my job back and doing all that.
But he's back at his employment, which was interrupted due to his own issues. But he's back at the same employment. Now he's got 14 years with that company. He does have an 11-year-old son that he splits custody. That's the highlight of his life. And ask the court to take this into consideration and let him move forward.
Okay, and sir, if you were to test right now, what is in your system?
I have marijuana and methadone.
Okay. And I'm presuming the methadone is prescribed.
Yes, and the marijuana prescribed.
That's also prescribed by the same doctor?
Yeah, no, different doctor. Different
Okay.
IFG doctors.
All right, so does your methadone doctor know that you're using marijuana and prescribed marijuana?
Yes.
And your marijuana doctor knows that you're prescribed methadone?
Yes.
Okay. All right, sir. What about your plate? Is that all clear it up now?
Yes, everything's all cleared up.
Okay, very good. Okay, so the court's going to find after hearing from counsel, hearing from Mr. Morgan, reviewing the report, the recommendation, the circumstances surrounding Mr. Morgan, that there's not reasonable grounds to depart from MCL 769.5. The court's going to order a $100 fine as to the inmate possession of drug paraphernalia, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $325 on the possession of drug paraphernalia. Improper plate, the court's going to order a $100 fine, $100 cost, assessment fee of $70, justice system assessment fee of $50. $325 on that one. After the warrant fees and clearance fees.
$50 warrant fee on the
Okay. So that's $375 each one.
Okay.
For a total of $750, sir. You did have a bond posted. And so we can apply that bond. Please stop at the window to make sure that your all of your contact information is accurate so that any balance would be sent to you via mail.
Okay, thank you very much.
Okay, have a good day.
Thank you, Your Honor.
All right, thank you. All right, let's go off the record for a moment.
That was Patterson you asked about, right?
Huh?
Okay. I couldn't remember that. I heard you say Williams. I'm thinking maybe that's something.
No, okay. All right, so, Emily, we're gonna go off the record for a moment. I'm gonna go in chambers with counsel on, where's Mr. Kuzner? Matter of the city of Wyandotte versus Joseph Steiner, 26539.
Your Honor, can I go for P 3075, on behalf of Mr. Stein?
All right, Mr. Steiner, please, wave your, or raise your right hand. I'm sorry, unmute first, please. I'm so sorry.
Okay,
All right, thank you. Your name for the record, please.
Joseph Paul Steiner.
Okay, and, counsel, today's the date scheduled for the pretrial in this matter.
Had an opportunity to speak with Mr. Stein, but also had an opportunity to police reports and the his prior criminal record. I've also had an opportunity to discuss this matter with Mr. with the prosecuting attorney. It's my understanding that Mr. Steiner would plead guilty to alcohol in a parking lot, and the disorderly conduct would be dismissed. Also, there is a recommendation, only the recommendation of time served in this particular matter. I've explained to Mr. Steiner his constitutional rights. He understands those constitutional rights. He also understands that by entering into this plea agreement, he would be waiving some of those rights. There are no immigration issues, and I also indicated to him that the recommendation for time served is just that, a recommendation would not have to be followed by the court. Understanding all of that, he wishes to enter into this plea. Is that correct, Mr. Steiner?
Yes, sir.
All right, please raise your right hand, sir. Do you solemnly swear or affirm testimony about to give in this matter be the truth and nothing but the truth?
Yes, ma'am.
All right, and you heard the plea that was placed on the record. Is that correct, sir?
Yes, ma'am.
And as to open alcohol, how do you plead?
I plead guilty.
As to the, you understand, sir, that by entering into a plea, you're going to be waiving some of the rights you've gone over with your attorney. Do you understand that?
Yes, ma'am.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
And you understand, sir, that the recommendation is time served, but as your attorney's indicated, it's only a recommendation. Do you understand that?
Yes, ma'am.
Knowing all that, do you want to continue with your plea?
Yes, ma'am.
There's no talking in court. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Immigration issues? Any immigration issues?
No, ma'am.
All right. And counsel, if you can please run to your client.
Thank you. Mr. Steiner, back on April 24th of 2026, were you in the city of Wyandotte?
Yes, sir.
And while you were in the city of Wyandotte, were you in a parking lot and in the street with an open beer can?
Yes, sir. I was, yes, sir. Yes, sir.
Police came up to you, there were some conversations, and they confiscated that open beer. Is that correct?
Yes, sir.
And there was alcohol in that beer can as well. Isn't that correct?
Yes, sir. Yes, sir.
It's satisfied, John.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the open alcohol, dismiss the disorderly conduct per the plea agreement, and counsel as to sentencing.
Your Honor, I believe under these circumstances that the 20 days that he has been in Lane County jail would be sufficient under these circumstances. I've discussed this with Mr. Steiner, clearly understands his actions as meaningless as it may seem to some people. Still, he is very remorseful for those actions. He realizes this is not the type of person he should be and wishes to move on. He's going to, or has been, attending the guidance center in Southgate. He's there for mental health issues, has been on his medications period of time, and now things seem to be working out much better for him. I believe that the time spent in the Wayne County Jail is time well spent, and resolution.
All right, sir. It appears though alcohol is not a good support for you, sir.
I understand. I understand. I go to meetings. I understand.
Hear you, sir. What are you saying? I can't hear you.
I go to AA meetings from time to time at Blessed Hope in Lincoln Park on Hazel. I help there. I just happened to have a beer that day. I apologize to the courts. It was wrong, but I do attend AA at times, Blessed Hope on Hazel and Lincoln Park.
All right. Well, sir, also it seems to have been a safety concern for you because you were in the middle of the road. The court's going to find that after hearing from counsel, hearing from Mr. Steiner, reviewing the police report, criminal history, the court does not find there's reasonable grounds to depart from MCL 769.5. The court's going to order 20 days jail, credit for 20 days, waive fines and costs. Good luck to you, sir.
Thank you very much, Ron.
Thank you.
All right. And then we are recalling the matter of, let's see, hold on, let's go off the record. Who are the two that we still have left in custody? Parsons and,
Got person free for the fact. He just
Okay.
wanted them, so. So
Can I go?
yes, you're all set, sir.
Thank you.
You're welcome. Mr. Gopal, do you have any of the ones that are still in Wayne County Jail?
I have paperwork back on. I have Mr. Williams, and I have Mr. Tennyson ready to go.
Okay, I understand that. I'm just asking, do you have any of the ones that are in Wayne County Jail?
No.
I was just curious. Okay.
Oh, no, the only one I have was Mr. Tennyson.
All right, let's go on the record in the matter of the City of Wyandotte versus Robert Parsons, 25421 26538.
Very good. Afternoon, Your Honor. You'll pull here on behalf of Robert Parsons, joins from the Wayne County Jail by Zoom. Mr. Parsons, please unmute, mute, and state your name. Hit the button, sir. There we go.
Okay, thank you.
Your name for the record, sir.
Robert Lee Parsons.
All right, today's the date scheduled for the pretrial counsel in these matters.
Your Honor, I had an opportunity to review this with city attorney, discuss this situation with Mr. Parsons, and he's prepared to offer a plea on both of these cases. And with respect to the older case, 25-421, Mr. Parsons is prepared to offer a plea of guilty to the amended charge of allowing an unlicensed person to drive a motor vehicle. Count two would be dismissed. He would also be pleading responsible to the added civil infraction of no proof of insurance. With respect to the newer case, 26-538, he would be pleading guilty to count one as possession of a controlled substance misdemeanor. Count two would be dismissed.
All right, sir, please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
I can't hear you, sir.
I do.
Okay, thank you. And you've heard the pleas that have been placed on the record, is that correct?
Yes, I have.
As to the new case from April of 26, possession of controlled substance, how do you plead?
I'm guilty.
As to the amended charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
As to the amended charge of no proof of insurance, how do you plead? Responsible or not responsible?
Responsible.
You've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
I do.
You also understand, sir, the possible that by entering into a plea, you'll be waiving some of those rights.
I do.
You understand as well the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, I do.
Knowing all of that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, no one is. No, not at all.
Any immigration issues?
No.
All right, counsel, if you can please voir dire your client.
Yes, I will. Thank you, Your Honor. Mr. Parsons, you recall being in the city of Wyandotte around the 27th of March of 2025?
Yes, I do.
And then at that time, you had a 1999 Ford automobile in your possession. Is that correct?
I did. Yes, I did.
And at that time, you allowed someone who was, you knew did not have a valid license to operate your car. Is that correct?
That is correct.
Thank you. Also, on another date that would be much more recently, April 25th of this year, you recall being in Wyandotte.
Yes.
Is that correct? Yes?
Yes, correct.
Thank you. And at that time, you had an interaction with a Wyandotte police officer. Do you recall that?
Yes, I do.
In the course of that interaction with that police officer has alleged that he's found in your possession or with you in your car some drugs, specifically some small quantity of cocaine. Do you admit that?
Yes, yes, yes.
I'm satisfied with that, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to those charges, dismiss the possession of drug paraphernalia, as well as the driving license suspended and the no insurance. Counsel, are you asking for immediate sentencing?
Maybe. What do I mean there?
I don't know.
All right, he's been 18 days in jail. He tells me that he's been 18 days in jail. He's sort of an enforced treatment. He would like to have treatment. He would not like to do 72 days in jail. So if I could read your mind, I'll have a clearer answer for you. But
I'm not laughing at your client. I'm just laughing. You'd like to be able to read my mind. I don't even know what I'm thinking right now because I haven't really heard enough yet.
I just understand that, Judge, and I don't know Mr. Parsons. He's say he's a man of senior years, old enough to claim Social Security and has a history. I've spoken with him several times now. Seems like a nice guy when I talk to him. He's definitely got some devils in his past. I should point out also that his license is valid, which was the basis of allowing that reduction on a suspended license. So it's not a complete waste. There was no one hurt in this thing. It was a car accident. I don't think there was a problem with the plate or some reason he got Plea out of it. Officer indicated it was a tag. The tag was bad. Was cooperative with the officer. He admitted he had the stuff in his possession. He knew it was wrong. And so that's that's the dilemma. He would welcome some assistance regarding treatment. And in fact, he's advised me that, low bond here, and that his loved ones chose not to post that small amount of money because they felt that the
Jail recovery center.
sobriety would be
Right.
to his benefit. So he does have people that watch out for him and care about him. So, more compassionate sentence around it that doesn't necessarily involve him being, incarcerated for the next 72 days, possibly 71. Then I think that would be good for everybody concerned.
So, Mr. Parsons, how long have you been using crack cocaine?
Well, actually, it has probably about 6 years now, off and on. But I do have bouts. I do have bouts at times where I overdo, and I try to stay away from it, but I do that first hit, and it becomes a problem again. I just gotta figure to stay away from it, and I do my best to stay away from it, and I generally do, but sometimes I falter.
Okay, and so what's your trigger for your faltering, sir?
Well, believe it or not, it's some of the people around me that I have to get away from, basically. Bad influences, I would say. Even at my age, I guess I do have bad influences in my life. But I do tend to stay away from it pretty good. But it's an off and on thing. It's not a permanent thing, It's just something that draws me. I'm sad to say.
All right, so you've been in custody for 19 days. What I'm going to do on the 26538, I'm going to order 60 days jail, 19 days credit. So that leaves you with 41 days to be tethered to treatment.
Oh, I'm not sure what that means.
Well, we're going to help you get treatment, sir, so you can try to not have that off and on relationship with crack cocaine. You can have it always be off. Okay?
Oh, okay.
So I'm going to order 60 days jail, credit for your 19 days that you've already been in, sir, and the balance of your 41 days.
Is treatment?
Yes.
Okay. I thank you. Thank you.
You're welcome. And so, on your 25421, well, I'm going to waive the fines and costs on this matter. And then I'm going to, on your other matter, indicate a $100 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50 on the 25421, the allowed a licensed driver to drive. $175 on no proof of insurance. There warrant fees, Ally?
$50.
Okay, plus $50 warrant fee on each one of those.
Can I make payment arrangements on those?
Just give me one moment, sir. So that's a total of $600. And so what I'm going to do, sir, is I'm going to have you, I'm going to indicate $50. Will $50 per month be something you can do, sir?
I do believe so, yes.
Okay, beginning August 1st.
Okay.
That gives you time to complete your treatment and then contact the court to set up any payments if you need to do it differently.
Okay. Will I see treatment people today or?
I believe you should, I would presume you'd be there by the end of the weekend. I'm not sure, sir.
Okay.
Quickly they will be able to move today.
Okay, thank you very much. Thank you.
You're welcome. Have a good day.
Thank you. Bye-bye.
All right.